of bills that we're taking up today, and then we can begin with committee introductions. So welcome everyone to the Joint Standing Committee on the Judiciary. It's March 3rd, and we have a series of work sessions on bills related to tribal relations. The order in which we will consider bills is that we will begin with LD 906, and then 1907, 1626, and that should take us through the morning. We'll have a lunch break, and when we return from our lunch break, which hopefully will be around 1, although we know in legislative time that's not always precise, we will probably take up at Representative Evangelos's request LD 1568. That was listed last, but he will ask the committee to vote ought not to pass, and so we would probably do that to accommodate his schedule. And then we'll take up LD 585 and end the day with 1218. So that's the order of bills for today. And now we will move on to committee introductions. And I am going to call on committee members as they appear on the screen, just because it's the easiest way to do it. Please keep your cameras on for the entire introduction so that members of the public can see us all, and also so that the squares don't move around and make it hard for me to track who has or hasn't been introduced yet. Thank you, everyone. Representative Newell, would you like to introduce yourself?
Thank you, Madam Chair. Good morning, everyone. My name is Rena Newell, and I serve as the Passamaquoddy representative. Good to be with all of you today.
Thank you, Representative Sheehan.
Thanks, Madam Chair, and good morning, everyone. I'm Erin Sheehan, and I represent House District 12, which is downtown Biddeford.
Representative Poirier.
Thank you, Madam Chair. I am Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Representative Moriarty.
Thank you, Madam Chair. Good morning, all. I'm Steve Moriarty. I represent my hometown of Cumberland and part of Gray in District 45.
Representative Babbage.
Thank you, Madam Chair. Good morning, everyone. My name is Christopher Babbage. I represent House District 8, which is most of the town of Kennebunk.
Representative Thorne.
Thank you, Madam Chair. My name is Jim Thorne. I represent House District 103, which are the towns of Carmel, Herman, and Etna up in beautiful Penobscot County.
Representative Reckitt.
Good morning, everyone. My name is Lois Reckitt, and I represent District 31, which is the ocean end of South Portland.
Representative Hagan.
Thank you, Madam Chair. Hello, everyone. Nice to see everybody here. David Hagan, House District 101, Hamden and Newburgh.
Representative Libby.
Thank you, Madam Chair. Good morning, everyone. I'm Laurel Libby. I represent District 64, which is part of Auburn and all of Minot.
And Senator Keim.
Good morning, everyone. My name is Lisa Keim, and I represent Senate District 18, which is northern Oxford County, and 2 communities in Androscoggin.
And I'm Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough. I'd also like to introduce our committee clerk, Peggy Reinsch, our OPLA analyst, Peggy Reinsch, who will be with us today, and also our committee clerk, Susan Panett. Thank you both. And with that, we will open up the work session on LD 906. This is an act to provide Passamaquoddy tribal members access to clean drinking water. And let's see. I think the way we will begin this work session is with, and Peggy and I haven't had a chance to coordinate. First of all, I'd like to remind committee members that Janet sent around a bill analysis, and I hope you all had time to read that. The bill analysis has a lot of answers to the questions that we posed during the public hearing conducted several days ago. I would like to, I think, begin with a very sort of top-level reminder of the purpose of this legislation. We did receive a lot of questions, getting into the kind of nitty-gritty of the water quality issues, and those are really important, and we've got a lot of good information. We as a committee are considering a bill that will change jurisdiction related to the regulation of water in this area. And we're not deciding actually what the source of water will be. So just want to set that out there, that our policy level decision is really related to the matters addressed in the legislation. And so I'd like to use that as a guide for our discussion today. And Peggy, I think that I could take us through Janet's analysis, but if you, as we go through it, if you're feeling like I'm missing stuff, will you please let me know?
I will, thank you. Yeah, I'm kind of pinch hitting here. So, and just to start off, the LD 906 was a concept draft, and Janet did send a proposed amendment. And I know Representative Thorne found it, the exact date, I'm not sure, but it was the third version because there were some minor tweaks that had to happen to it. So if you remember that, it's the third version, and it should be posted in the electronic LD file. Thanks.
And committee members, as we go through the bill, if you would like Peggy to screen share it, we're certainly fine with doing that. So I will let's see, I think I'll start out with Janet's analysis and talk about the different sections of the bill. The first section of the bill would repeal the taxation of the Passamaquoddy Water District property. The Passamaquoddy Water District is a quasi-municipal entity that is created by enactment of a charter. And the charter for the Passamaquoddy Water District allows the property of the water district to be taxed. This is the only water district in the state with a charter that allows the property to be taxed. And what we heard at the public hearing was that the taxation of the property of the water district deprives the water district of resources that are needed to improve and maintain the equipment and improve the water and ensure that the water district is providing clean drinking water to members of the community. I guess I think maybe, yeah, I'll go through them all and then we'll take them one at a time. I also am seeing some questions in the chat, and I would like to remind everybody that the chat is not part of the official record of the meeting and is not part of the meeting. It's also hard for us as committee members to respond to and pay attention to the chat while we're in the midst of a meeting. And so I would just ask people to not use the chat unless there's an urgent technical issue. The one question that was asked is the bill analysis publicly available? And it is publicly available on the Judiciary Committee's website. Thank you, everybody, for respecting the purposes of the chat. The second element of the bill is to allow 2 parcels of land that are currently owned by the Passamaquoddy tribe in the town of Perry to be added to the lands that are eligible to become trust lands. The third element of the legislation, which is found in Section 5, would amend the Maine Implementing Act to provide that unless the tribe and state of Maine enter into an agreement granting the state concurrent jurisdiction over drinking water issues, that the Passamaquoddy tribe would have exclusive authority to adopt ordinances regarding drinking water within the Passamaquoddy Indian Territory. And it would also give primary enforcement jurisdiction to the Passamaquoddy tribe if they requested, and then shift enforcement from the Maine, the state of Maine, to the Federal Environmental Protection Agency. The legislation would also give the Passamaquoddy Tribal Court exclusive authority to pursue civil and criminal enforcement of drinking water ordinances. And it has a contingent effective date that makes the bill effective upon 60 days after approval by the Passamaquoddy tribe. And so with that, I think that that's a very high level discussion of the impact of the bill. I think it probably makes sense to take these issues one at a time. And I'd like to start with the first issue, which is the taxation issue, and would entertain committee questions about that. And we do have lots of folks available who we can pull over to the panel to answer any questions about the tax exempt issue. Senator Keim, go ahead.
I had a couple of questions and I was looking for the information. It might be right in front of us, but what is the amount of the property tax paid? Do we have that information and in front of us?
We do, and I definitely read it last night, and I think I remember, but give me 1 second, because I think that I am going to be able to give you an exact figure.
Madam Chair, I have it right here.
Thank you, Representative. Go ahead and tell us where you're getting it from as well, because it'll help orient us to the materials.
Yep. It was from the memo from Ann Belfleur, the PWD business manager, dated March 1. The town of Perry receives $23,000 a year. The city of Eastport receives $43,000 per year from taxes assessed against the water district, rather in the form of taxes assessed against the water district.
Thank you, Representative. That's very helpful.
Sure.
Did you have another question, Senator Keim?
Yes, I did. I was just wondering if the two towns knew about this loss and if we could possibly hear from them. And I am happy to wait if there's a better time for that.
I think this is a good time. And again, I think if we can take it issue by issue, it'll probably help us organize our thoughts. So let me, and so is your question for a town official regarding the impact that loss of that revenue would have on the town? Or is your question for a representative of the water district as to how they would use those funds, or both?
I guess I was thinking the towns themselves.
Okay.
But I haven't looked at and I don't know, Representative Poirier might have a better idea on who could speak.
Yeah, I have a list of people who and their roles. And so I will call over, we'll start with the town of Eastport. And I believe we have Kate Devonshire here. So let me just see if she is here. Yes. Okay, Kate Devonshire, I'm going to bring you over to the panel.
Madam Chair, in the meantime, may I ask the date of the amendment wording you're looking at?
Yes, it is dated.
I believe February 17th at the top.
Yes, thanks, Representative Thorne. And
That's what I have.
okay.
Thank you.
Can I clarify, because so the amendment I'm looking at says corrected for public hearing 2/17/22, but then it says proposed committee amendment 2/14/2022.
That's it.
That's the one.
Okay, okay.
That's
Yeah.
fine. Yeah.
Yeah, and committee members, if you go into the electronic committee files, it's when we have a proposed amendment, you can see the date that it was posted, and that's a good guide to remind us that that's the most recent one as well. But I think we're all understanding what the most current proposed amendment is.
Yeah.
Okay, and so Kate Devonshire, have you been able to join?
I am here. I am here. I'm keeping my video off because my internet is kind of spotty. I apologize.
Okay. Thank you for joining us. Welcome to the Judiciary Committee. I don't know if you've ever been here before, but we're delighted to have you. Could you please answer Senator Kime's question about the impact that revenue loss would have on the city of Eastport?
Good morning, and thank you for having me. The city of Eastport, with the revenue lost, the timing couldn't have been better if this ends up going through, because we would be able to adjust for it in the budget coming up. But the impact of $42,000 for our city would be kind of detrimental. If you put it towards like people, that's our entire fire department. That's what gets paid there. So it's just, I hope that answers the question, Senator.
Did that answer your question, Senator Kime?
Yes, it does. And then I guess the Eastport also has part of this. So I'm just wondering, so this is the property tax they take off from the water district, but then the town of Eastport also pays in to the water district as well, like the people there are paying in to use
That
it?
is correct. So it's actually a couple of different things. The property taxes they're referring to are, there's the physical property, like the office building, there's a pump station, distribution center. But the city itself also pays, last year, for example, was for our fire hydrant fees. That was $247,000 that we pay into the water company for that. And then also everybody who hooks in, who doesn't have a well, they're metered and they pay for usage.
So the town itself pays the 247,000 and then your residents pay for metered usage.
Correct.
Okay. Thank you.
Yeah. Kate, I had a question for you as well. Can you tell us what the annual revenue is for and I'm not sure if the municipality is a city or a town, but for Eastport, what's the total revenue for your annual municipal budget?
Our total revenue is for the entire city.
Yes.
Sorry. It is, I'm just flipping through to get you an exact number. 5,958,000.
Thank you.
So.
All right. And then committee members, additional questions for the city or town of Eastport, we'll say it that way, for Eastport.
It's city, but it's okay, we're tiny.
I've visited Eastport and spent some time bicycling there, and it's a beautiful community. So related to the tax issue, the tax exempt issue only for the city of Eastport. Go ahead, Representative Rackett.
I wanted to point out to people that we were sent by analyst Janet's, whose name I always foul up, Stoko, another document called Responses to Questions on 906. And several of those questions had to do with things like, do the community serves agree with the request for the tax exempt status? What's the property, where is the property located? What's the amount of property taxes? So all in the first page and a half of that document is the responses to some of the questions we're now asking. So if you have that in your possession right now, it's a pretty clear explanation of the costs and the what has been done in terms of getting agreement from people about doing this. So I just pass that on. Thank you.
Thank you, Representative. Representative Thorne?
Thank you, Madam Chair. And I don't know if you can answer this, Kate. That we also were in fact sent the copy of the 98 I don't know if it's a lawsuit you want to call it, Passamaquoddy Water District versus City of Eastport, dated 90. Yeah. And then at the end of that, I'm just looking for a synopsis, if you can, if you're familiar with it, that it says judgment affirmed. Was that just for a year tax exempt, or do you recall?
I will be perfectly honest with you. I do not have the answer to that. I can speculate, but I can get back to you guys in a couple minutes with that answer if you would like. Okay.
I think that might be a question that Peggy could answer right now. And can you just re-ask that question to Peggy, Representative Thorne?
Yes, basically, I'm just looking for a synopsis of the meaning of this judgment that says judgment affirmed on that 98 document that is the Passamaquoddy Water District versus City of Eastport for tax exempt status. Was that just a temporary thing or was that an ongoing condition?
And Peggy, I can answer it too, because I read it last night if you don't have it available. It's up to you.
My understanding is it's not tax exempt because of what's in the charter. The charter says it is not tax exempt. Does that answer your question?
No.
Oh.
No. Yeah. I'm just confused about this one. The way that I read the docket, it says that they're looking for tax exemption status. And then at the end, it says judgment affirmed.
Yeah, so, I think I can answer your question, Representative Thorne.
Thank you.
The court found that it was not currently exempt, but by an act of the legislature, the water district could become exempt if the legislature amends the charter. And that's actually the first section of this bill.
Okay, thank you for that clarification.
Well, thanks. It was a good question. Thank you. Other Representative Reckett, is your hand up anew or is residual? Okay. Representative Libby, did you have a question?
I do. I have a question for Kate. A question and a follow-up. So my question is, we had a public hearing on this bill last May, and I'm just curious. I don't believe that we heard from you then. When did you folks in Eastport learn about this bill?
Kate, we're not able to.
Sorry about that. I heard of it directly about a week ago.
Okay. And my follow-up question is, I understand we can run the numbers all day long and you can give us numbers, but I would really appreciate knowing real world kind of impact because a $5 million budget is very amorphous to me. Are you in favor of this change? Is Eastport in favor of this change? And what do you see as the overall impact to your city?
The overall impact monetarily, we could make it work. I mean, we're gonna have to make it work. Our biggest concerns are the fact that the water goes through the tribe and then goes to Eastport. So if we're not getting the same issues, or we're not having the same issues as they are, then why? And we're all for good drinking water. That's not the question. We're for that. It's just we want to know why we didn't know about it, or if all avenues have been approached. Is that?
Yeah, that's helpful. It brings up another issue that's not a tax issue, but I think we'll certainly want to bring you back because you bring up a very important issue. Thank you.
Representative Newell?
Yes, thank you, Madam Chair. Oh, I lost her. Good morning again, Miss Devonshire. It's good to see you again.
Good morning. I like your background.
Following last night's meeting at the Water District. Just a couple of questions, if I may. Madam Chair, as you mentioned, following your response to a question posed in regards to the city budget, so at $5,915,000, the proposed loss is equal to 1% of your budget, correct?
I'm going to trust your math on that. So yes.
Would you agree that the district would benefit following not having to pay taxes to the city of Eastport? Would it have an impact on the quality of water being delivered to the citizens of Eastport? I lost you again.
No, I turned the video off because my internet's not the most stable, and I wanted to make sure I heard your question clearly. So you had asked if the water. I'm sorry, it just broke up. Would you mind asking it again, Representative?
Yes. The revenue that would be saved. No, let me reframe it. Would you agree that PWD would have a beneficial impact on water should the district be allowed to retain those tax resources?
I have no reason to say no to that. I do believe that whatever assets you'd be able to get from the tax exemption, either it be ours or Perry's, the water district would utilize it to the best of their capability, because the end game is clean water. You know, it's just a matter of us getting there.
Thank you, Madam Chair. One more question, please.
Go ahead.
Ms. Devonshire, you indicated following a question by Representative Libby as to when you received notice, and your response was a week ago. Could you tell the committee how long you've been serving in your capacity?
Sure thing. It has been 303 days. I started on April 28th.
I appreciate that detail. I would like to just conclude with a question. As you may be aware, the tribe led a multi-stakeholder effort on addressing this issue beginning in, I believe it was 2019. I know that was prior to your beginning. However, did you receive any notice from any individuals that might have made you aware that this was occurring on a quarterly basis over the last 3 years?
No, I haven't. The way that, and this is just for clarification for the rest of the committee, the way that the water district is set up is the city appoints a liaison to the water district. So in theory, he would have been the person to hear about it and then come back and tell me about it. He's been with the water company for as long as the water company. I think they put him in with the pipes. So he had no idea about it. So I know that my tenure has been short, but we've had long ties there.
Madam Chair,
Are you all set, Representative?
just to follow up on her comment, please. The liaison that you're speaking of from the Eastport City Council to the Passamaquoddy Water District, does that liaison serve as a board of trustee member of the water district?
For clarification, he's not a council member at all. He's a person that the city appoints to that. His name is Richard Clark. He's also the fire chief too. So he wears two hats in this case, but he's not directly related or tied into the council in that regard. Did that answer that?
Yes, just one final,
Okay.
I believe.
Of course.
I appreciate that response.
Point
and
of order,
making the
Madam Chair.
clarification that he does not serve on the council.
Point of order, Madam Chair.
Just a moment, Representative Newell. Go ahead, Representative Libby.
I just am cognizant of the fact that we were directed that this was questioning regarding the taxation implications. If Representative Newell has a question for this other gentleman, should we perhaps bring him in?
I think she's trying to make a point about a piece of information that was shared in the context of this discussion regarding when the city of Eastport knew about this proposed legislation. And Representative Newell, if you could just, I think you might have a different perspective on when the city of Eastport knew about the legislation. And could you just tell us what your perspective is, please?
That the individual that Ms. Devonshire is speaking of as the liaison to the Eastport City Council is also a member of the Passamaquoddy Water District Board of Trustees, and I believe serves as the chair. So that information potentially could have been conveyed from his position as a PWD Board of Trustees member to an Eastport City Council liaison.
Okay, and is it your position that the water district and that particular individual knew about the legislation for more than a week or so?
I would say going back to the initial start of the larger stakeholder meetings, which would have been more than a couple years.
Okay, thank you for sharing that information.
Thank you.
Representative Poirier, go ahead.
Thank you, Madam Chair. And I'm not sure if this is a question for Kate or if this is something that Peggy could answer for us also. But looking at the information that we received, the taxation falls under the section 15. And in the analysis that we received also, I showed that the water district is considered a consumer-owned utility. Based off my research with other consumer-owned utilities in Maine, not necessarily water, but other consumer-owned utilities, they actually have nonprofit status that gives them that tax exempt status. Is there anything that stops this water district from becoming nonprofit to become tax exempt?
I do think that that's probably a question for the analyst rather than for Kate. Do you agree with that, Kate?
Thank you. Yes.
Okay. And I know that Representative Poirier, what the guidance in the law court decision was is that the legislature can amend the charter to exempt the entity from tax. But Peggy, did you have anything you wanted to add on that?
I don't, and I'm not sure if the consumer-owned utilities are also chartered or they incorporated as nonprofits. So I really don't have anything to give you, other than I think those are two different types of entities, and I'm not sure if they both go through the same process. Can certainly work on that.
Okay,
Thank you.
Thank
I
you.
was just curious if this is the only avenue or if there is something that hadn't been looked at yet for that tax exempt status.
Hmm.
Thanks.
yeah, thank you for raising that issue. Senator Keim?
I'd like to go back to the issue of when the town heard about this. I think that we need to be careful that because Representative Newell is wanting to defend the bill, that we are careful in how we treat people that come to our committee to that talk to us, and that we're not giving unfair advantage to certain members of our committee because of their perspective. And when this bill came to us, wasn't it a concept draft?
It was a concept draft.
So then how would Representative Newell say that in 2 years ago or whenever this last meeting was, that they knew about this bill? Because we didn't even know what this bill was when it came to us originally. So I don't think the town of Eastport should be characterized that somehow some people there are not doing their job in, representing what's going on, because obviously the town didn't know. And that was Representative Libby's point. That's that the town of Eastport didn't know. And clearly they didn't know. And we in fact didn't know when the bill came to us what the bill was, because it was a concept draft.
Senator Keim, I appreciate you presenting all of that information. I would ask the committee to move on, because I feel like this is an issue that is not actually relevant to the decision we have to make. Our decisions are about right now primarily focusing on whether this one water district within the state of Maine that is subject to property tax should have its charter amended so that it is treated like every other water district in the state and be exempt from tax. And who knew what when is not a very productive issue. It will not help us address the underlying policy concerns. So thank you for
I
raising that.
absolutely
And I think
agree.
we
I
can
just don't want to
set
see
it to
people
the side.
mischaracterized. Thank you.
Yeah, thank you. Representative Poirier, did you have a follow-up question? I'm sorry, I moved on probably earlier than I should have.
I do have a question that piggybacks on what you just said here too. I think it would be helpful for us to know when we're categorizing this particular water district against other water districts in Maine, to know if there are any other consumer-owned water districts in the state of Maine. It's my understanding that this water district was purchased from a private company, therefore it was always taxed. And when it became consumer owned, therefore it was still privately owned. And that's hence the court decision that Representative Thorne mentioned, why it remained taxed. So when we're making that comparison, I just want to know, are we comparing apples to apples? We're talking consumer owned utility here versus a different type of ownership. So I'd just like to have that clarification.
Okay, I think that's information that we probably don't have available today. And I would encourage you, because it sounds like you're being very thoughtful about this, to also think about, is it possible to, for good policy reasons, exempt this one as well? And I feel like that's an important consideration as what you've mentioned, but thank you. Representative Moriarty?
Thank you, Madam Chair. I think we're going down a dead end here as far as the status of the water district. And I'm referring to the decision from the Maine Supreme Court that Representative Thorne mentioned earlier from 1998. And in one of the earlier paragraphs, it clearly explains that the district was created by the legislature in 1983 as a nonprofit public municipal corporation. It is not, in my judgment, a consumer-owned utility. The court's language is explicitly clear, and it's drawn from Section 1 of the district's charter itself. So I think we can just put a an end to this confusion, it's a nonprofit public municipal corporation.
Thank you, Representative Moriarty. Committee members, I would like to move on to hear from both the town of Perry and then also a representative of the Passamaquoddy Water District. So thank you, Kate, for being here with us today and answering our questions. And I'm going to ask if you would be able to stay around for the rest of the work session in case we have questions for you, but I'll put you back in the attendee room.
Great. Thank you very much for your time. I appreciate it.
And then next, we're going to hear from Tim Woodcock, who is here for the town of Perry. And again, this is questions about the amount of tax received by the town and impacts on the town budget. Senator Keim, go ahead with your question.
So I just wanted, I guess, just clarity. I was going to ask Kate another question about this, but it wasn't related to tax. Are we going to bring the town of Eastport back in at another point for broader questions, or how did you want to work that?
Yes, right.
Okay.
And that's why I asked her to just hang out in the attendee part of the meeting.
Okay, thank you.
You're welcome. And she has indicated that she's going to stay here. Timothy Woodcock, welcome to the Judiciary Committee. And I just want to see, I know that you've probably been listening to our conversation. Can you let us know if the figure that we have for the tax payments that Perry receives of about $23,000 is accurate? And then if you could explain to us what losing that revenue what impact that would have on the town of Perry, and just so that we have the same information, also what the annual revenue is for the town of Perry.
Thank you for the opportunity to participate. I believe that figure is correct in terms of the tax loss. And it is my understanding, I have reviewed the Supreme Court decision that Representative Moriarty adverted to a moment ago, and it does appear as though the logic of making it not tax exempt was that it was originally privately owned. And so that was already a source of tax revenue to the municipalities. And therefore they asked the legislature not to make it tax exempt. And so that was why the decision came out the way it did. I would suggest with respect to the details of the town of Perry budget, I believe there are some representatives of the town of Perry who are also in the wait room. They have a much more detailed knowledge of this than I do. I did speak to them yesterday about these issues. And so we have a little bit of a division of labor here where they have a far more detailed knowledge. I think they can also give you a better background on the origins of the legislation and their awareness of it to the extent that's an issue for the committee in this work session. I am available to answer questions about the legal implications of some of the provisions of the Act.
Thank you. I didn't realize that other representatives of the town of Perry were in the attendee part of the meeting. Can you indicate who you would suggest we bring over to answer the questions?
I believe that Anne Belfleur should be.
Thank you.
Yes.
I'm going to send you back to the attendee part of the meeting.
Thank you very much.
And we'll be joined by Anne Belfleur to answer these questions. Anne Belfleur, welcome to the Judiciary Committee. We appreciate you joining us today. Did you hear the questions and are you able to answer them?
Yes, I heard them, and the question is, what implications will the loss of tax revenue have on the town of Perry?
Yes.
We're a small community. Our budget is roughly around $2 million. So 25,000, would be hard for our community to lose. We have a school that we have to help run. We try to keep the taxes even for the citizens. So any increase, is going to hurt.
Okay, thank you. Committee members, are there any questions regarding the tax exemption provision for Ann Belfleur and the town of Perry? Representative Newell, go ahead.
Thank you, Madam Chair. I actually had my hand raised earlier before Ann appeared on screen. I just wanted to clarify Mr. Woodcock's position and association with the town of Perry. And so, Madam Chair, moving forward, if we could just ask,
I will.
Thank you.
Yeah, thanks for the reminder. Thank you.
Yes, thank you.
Senator Kime?
Thank you. I actually don't have a question for Ann, although I do very much appreciate you being here, but I don't have a tax question for Ann. I had a question for Peggy.
Okay, is it related to the exemption?
It is.
Why don't you go ahead with it then?
Peggy, my question is, when we do anything that's an unfunded mandate, it has to pass the legislature by 2/3. And this is a little bit different, but it is taking away funding. Would that fall under the same category or no?
I don't think so, because it's the Office of Fiscal and Program Review makes that initial determination. So I'm not really sure what they look at. I would think that it doesn't, because it doesn't affect it really has a very localized effect on Eastport and Perry. I think that's it, but it's not like all municipalities or all counties.
Okay, thank you for that answer.
And then Representative Evangelist, did you have a question for Ann Belfleur?
Thank you, Madam Chair. Very briefly, I just wanted to know if you could give it to me, what the total annual budget is for the town of Perry.
It's roughly around 1 million.
It's 1 million. And the hit you'll be taking is, did I hear 27,000?
I believe it was 20.
Around 23.
Okay. 1 million and 23. Have you done an assessment of what this would do to your mill rate, if it's any significant impact?
We have not as of yet.
Okay. And just the last question, when you do property assessments, unfortunately, I got voted in as a write-in candidate once in the 1980s as an assessor, something I don't want to do again. But we had something called an overlay. It's kind of a way to round off the mill rate, but it creates kind of a little bit of a surplus or a buffer. Do you know what your overlay is each year or last year?
I may have it available here.
It's on your tax commitment page if you have a town report, but you can get it to us later. I'm just trying to make some financial measurements as to the hit and impact you'll be taking.
Actually, I just took those out of my bag and left them home, so
That's
I don't
okay.
have to.
Maybe when I get off and you get off screen, you can make a phone call or something and get that for me. The town office should have it bang right there on the tax commitment page of the town report. Thanks.
Thank you.
Representative Thorne?
Thank you, Madam Chair. Hopefully this is an easy question, and it may be for Peggy, so I'm not sure how you want to do it, but a quick question is, am I to understand that this 1998 only applied to Eastport, Passamaquoddy Water District versus Eastport, the town of Eastport, then Perry was not involved in that? Or didn't have a similar one for tax exemption? Lawsuit?
I think it was both. the city of Eastport and the town of Perry.
Oh, okay.
They were in the caption, right? City
So,
of Eastport,
right.
town of Perry.
Yeah, I see it now, fine print. So my understanding is that gave the legislature ability to do this?
The
Make-
legislature always, I'm sorry.
Yeah, just to make a tax exemption status. That's what this 98.
So I think what the court is saying is the tax exemptions, the taxable status comes from the water district's charter, which was not changed when it was purchased from a private owner. That if the legislature wants to change that status, the legislature can amend the charter, and that's what section 1 of the amendment is doing.
And this has
So
been.
the court isn't saying you have to do it. The court's saying if you want to change this, it takes an amendment of the charter.
Okay, and the question in my head is, it's 2022. How come it's taken this long and we're dealing with it now? Why didn't it get dealt with, or has it been dealt with in the past? And this is just another run at it. Did you know? Do you know?
I don't have any information about that.
Okay, maybe somebody else in the committee does. Thank you, Madam Chair. I'm just trying to get my head around if the ability to do this since 98, has it been tried before? Or is this the first attempt at it since 98 to get the tax exempt status?
Yeah, and I understand where you're coming from. We can try to get that information for you. Representative Moriarty?
Thank you, Madam Chair. I'd like to respond, if I could, to Representative Thorne, and then I have a separate tax question of my own.
Okay.
Representative, this document we're all looking at is a decision from the Maine Supreme Court deciding a single lawsuit. And as I read it, the central issue in that case was whether or not the legislature, in enacting the charter of the Passamaquoddy Water District, violated the Maine Constitution by not making it tax exempt. Bottom line is, the court determined that there was no violation of the Constitution, that the legislature was acting within its discretionary range. By implication, that means that what the legislature did at one point, it can undo at a later point. As to the lapse in time between 1998 and today, I have no answer as to why it didn't come forward. But this decision is really very straightforward, very narrow in scope, and there's nothing about it that lasts for 1 year or 2 years. It's the court's call on the constitutionality question. My question, Madam Chair, on taxation is, it just occurred to me, I think we're missing one piece in our broad and comprehensive understanding of the tax situation. And specifically, and I guess this goes to Representative Newell, does Pleasant Point or Sapaic pay property taxes to the water district?
Pay property taxes or receive property taxes from?
Well, do they tax? Yes. Do they tax the water district in the way that Eastport and Perry do?
Okay, let's see if Representative Newell knows the answer to that question. Thank you.
Thank you for the question, Representative Moriarty. Am I to understand that you're asking the question as to whether or not Pleasant Point taxes the water district?
Yes, that's right.
At this point in time, Representative Moriarty, we are not allowed to tax due to the restrictions. If you need further clarification on that question, Representative, then I do believe that we have Attorney Hinton in the waiting room, and he could be brought over, Madam Chair.
No, I understand fully, and you've just filled a gap in our comprehensive understanding of who pays taxes to whom. So thanks for that.
Thank you.
Representative Evangelos?
Thank you, Madam Chair. And Ms. Bellafor, while we've been talking here, I found an annual report online. And so I have the answers, so don't put people to work looking for it. In recent history, the overlay's been, roughly 30, 35, 38,000 from what I've seen in the town reports. So I just wanted to add that in. I'm trying to assess what kind of a real financial hit the towns are going to take by granting a certain status enjoyed by all of the water companies. And in this case, the overlay is larger than the hit to the town. So from my own auditing standards, I would consider it negligible. It's not of a significant factor. Your budget is 1 million, but you get hit by the schools for another million. You got to come up with some taxes and cognizant of how rough it is. But I just wanted to get some numbers, and I'm not diminishing your concern, but I'm trying to get a proper financial measurement in my head. That's all I'm doing. So thank you very much.
Thank you, Representative. And I think that Anne Devonshire also has some overlay information. I'm going to bring her back onto the panel, and I'm also going to bring onto the panel the Mark McCluskey, the operator, for the Passamaquoddy Water District. And we can just quickly get the overlay for Eastport from Kate, and then we'll ask the operator what the impact of loss of this revenue or gaining this revenue would have on the water district. And Kate, have you rejoined us? And Anne, I'm going to send you back to the attendee part of the meeting.
Mark McCluskey is here with me, so we had some technical difficulties, so I'll let him take my place.
Great, thank you.
Before.
And then
I'm
Kate,
back in.
Okay, could you let us know what the overlay is?
Sure. The overlay for the city of Eastport is I just put it in the chat too. 76,900 and so we'll say 77,000.
Thank you. And I'm going to send you back to the attendee part of the and have we been joined yet by Mark?
Yes, I'm Mark McCluskey. Thank you for having me.
Thank you, Mark. Can you please let us know what the impact would be on the Passamaquoddy Water District if it did not have to pay these two property tax bills?
Well, actually, I think you're talking to the wrong person because Ann does handle all the financials for the water district, and I just am the technical person who is in charge of running the water treatment plant. So of course, the district is always struggling with funding, and we always have some pretty good projects that could help the water quality, and if we had some more money, it would definitely help operations some. Yes.
Can you give us an example of the expenses you've had that you have not been able to, the work that you would have been able to do had you had additional resources?
Well, actually, I'm referring to the project that we're working on now. There's going to be a recurring expense for the granular activated carbon system that we're putting in, and we have to change out the media in that system. We've estimated approximately once a year for the tune of approximately $60,000, which is a totally new expense to the district at this time. Definitely will improve the water quality, but it's going to be somewhat of a burden on the district to come up with the funding to change out this media every year.
Thank you for that answer. I see that there are some committee questions. Representative Libby, go ahead.
Thank you, Madam Chair. I suppose that I'm not sure who should answer this question. Pleading ignorance here, I've tried looking up overlay as it relates to water district, and I do not believe I'm finding the correct answer. So could somebody please explain? I'm assuming it's not a zoning, which is what I'm finding. So what is an overlay?
Representative Evangelist, could you give us just a brief summary of that? And then we can do a deeper dive if needed.
Sure. When the property tax assessors set the mill rate for a town, they take all the cost factors into consideration, but they put something in called a fudge factor. Every town does it. It's called the overlay. It's money that the town has in the setting of the mill rate, but that is not budgeted to be expended. So technically, if all goes well in the year for the town, it becomes in effect, a surplus. So I'm bringing it up because I'm attempting to determine whether the value of that overlay, which is a surplus, I want to know how big this hit the town is taking. And to me, a hit would be in the hundreds of thousands of dollars when the overlay is 30-something thousand. But the overlay is bigger than the hit they're taking. So I consider it a significant piece of information by accounting standards. So it relates that way. It relates to the money, to this taxation problem. The towns, I'm a former town manager. I've run these kind of operations. While I wouldn't like the news, I wouldn't argue that it's a significant hit to my town's balance sheet. It's less than the overlay. We can handle it, but that's my opinion.
Thank you very much, Representative Evangelos.
Representative Thorne, go ahead with your question.
Thank you, Madam Chair. And I guess, is it Mark?
Yes.
Okay. I'm just curious, and you raised a question, is there any techniques or methods that the other towns use to flush out or for water clarity that Pleasant Point doesn't exercise?
I'm aware that the tribe flushes fairly good twice a year, as well as the water district in the spring and the fall usually.
Okay, so there's no other filtration or chemical treatment or anything that the other towns do that Pleasant Point doesn't?
Pleasant Point doesn't have any treatment at this point.
Okay.
Is that your question?
Yes, I'm just wondering if there's a filtration or a runoff system or technique that the other towns use that Pleasant Point doesn't, and therefore makes their water quality not as good? Like a sediment?
Sure, yes.
Sediment runoff?
Actually, in the city of Eastport, we actually have a few strategic locations where we run bleeders to keep the water fresh. When there's a low usage area, we have bleeders which run approximately 5 gallons a minute continuously, and that keeps the water fresh in those areas. The reservation does not do that at this point.
Okay, thank you.
Yeah.
Representative Evangelist, did you have a question for Mark as well?
Yes, Madam Chair, but I know we were supposed to be talking about taxes, but when we get to water quality as part of this discussion, Mark would be a very important person to talk with, but Representative Thorne was kind of getting at what I was wanting to get at. I'm going to be wicked brief, but Mark, when the expense that was created for Eastport when they put in these systems, was that paid for by the city of Eastport or by the water district?
As far as the bleeders go,
yes, sir.
That's just we have to account for all our water, and we account for that, but it's not metered and it's not charged to anybody. So no, there's no.
But I mean, the installation of the bleeders, the capital cost, was that borne by the city of Eastport?
Capital cost to install a bleeder is very minimal.
Is it? Okay, all right.
Maybe $1,000 to put one in at the most.
Madam Chair, the other line of question I wanted to explore was where Representative Thorne was going around, for instance, I want to know if the town of Perry gets the same exact water as the Passamaquoddy Nation, and whether they're experiencing those exact problems, especially in the summer. I don't know if you want to get bogged down in that right now, Madam Chair. If you're going to hold a section for water quality and let's finish this financial piece, I'm happy with that. Your choice.
Thank you. I think we should finish up because we have several different types of policy decisions to make on this bill. And the first significant policy decision is, would we legislatively amend the charter in order to exempt the water district from property taxes? And so I want to I sense that we're close to being done on that.
Yeah, me too.
And I just wanted to finish us up.
A little later, we can do water quality then?
Yes, for sure. Okay, thank you. Representative Newell? Representative, we're not able to hear you.
Thank you, Madam Chair. If I might, I know we're going off of a little bit off, but if I might just follow up on Representative Thorne's question to Mark.
Yeah, so long as it focuses on the cost related to what could be done with the added revenue or the added revenue from being tax exempt, because again, I want us to be able to think about and talk about this particular decision. Go ahead.
I may be able to follow up later if you'd like. It was just a follow-up question to the response provided to Representative Thorne as to the bleeders and the runoffs.
Okay, let's take that up when we talk about the water quality, if that's okay with you.
All right, thank you.
Thank you. Representative Hagan, did you have a question?
No, I just was not prepared to talk about the bleeders and whatnot until later. And I wanted to recommend that we stay on topic so that we can handle one at a time. That's all I had.
Okay, thank you. Okay, committee members, any other questions for Mark McCluskey related to the what would in effect be additional revenue to the water district if it didn't have to pay property taxes? Representative Babbage?
Thank you, Madam Chair. Mr. McCloskey, if you could just help me to understand, I've got partial information here, but as far as the water district charging its customers, can you give me an idea of the percentage of customers that exist in Eastport, in Sapayak, and in Perry? And what's the draw on your water supply and from which you receive income?
Again, Ann would have more of that information. I'm the designated operator for the water district, and my office is in Waterville, and I zoom in on the treatment plant daily and check operations and speak with the guys. But as far as anything, as far as volumes and charges and stuff like that go, Ann is the one to ask for that. I don't know. I can't give you a percentage of how much water goes to Eastport and how much goes to the reservation.
Thank you, Mark. And Representative Babbage, I know that this is a really important and interesting topic. I would also encourage us all as a committee to focus on the questions that we need answers to in order to make the policy decisions that we're going to have to make. And
was designed, Madam Chair, I'm sorry.
No,
that was designed
I appreciate that.
It was designed as a financial question. In other words, where is their income coming from? And as opposed to what the taxation would. Thank you.
Okay, thank you. Okay, any other questions related to the tax exemption issue? Representative Evangelos, go ahead.
Sorry, I didn't write down, Madam Chair, the Eastport tax number, which would represent the loss of revenue. Somebody, I got Perry's at 23,000. What was Eastport's? Somebody had-
Eastport was 43,000, and their overlay is 77,000. And their
Thank you.
budget is about 6 million. Would any committee member like to make any, well, first of all, looks like we're done with our questions. Mark, I'm going to send you back to the attendee space. Thank you for being here.
Thank you.
And then committee members, would anybody like to comment on the underlying policy issue, which is the level at which we need to be thinking about the first section of LD 906, which is should the charter of the Passamaquoddy Water District be amended by the legislature to make the district tax exempt. Actually, Representative Evangelos, I see your hand is up. You can start us off.
I think it's the fair thing to do. It's never fair when you have these situations where 99% of the folks enjoy things one way, but there's these archaic exceptions. It should be unconstitutional, really. But anyways, I think we need to fix it and put them on the same ground as every other water company in the state. That's it.
Thank you, Representative. Would other committee members like to weigh in? Representative Moriarty?
Thank you, Madam Chair. I agree with Representative Evangelos. I think the legislature should exercise its authority and discretion to make this water district tax exempt, just as every other water district in the state is.
Thank you. Committee members, other thoughts and concerns about the tax exempt aspect of this bill, the amendment to the charter? All right, I'm not seeing any anyone else who wishes to weigh in. And Representative Babbage, go ahead.
I appreciate it, Madam Chair. I will just say that I'm in agreement with my two colleagues that just spoke. It is the legislature's prerogative to make this decision, and whether or not an entity is nonprofit or not is a classification that is on paper, and we can determine whether or not this is a taxable entity or not in the legislature. So I also believe the same as Representative Evangelos and Representative Moriarty have expressed. Thank you.
Thank you. Would anyone else like to weigh in? I'm not seeing any other hands up, but Representative Thorne, go ahead.
Thank you, Madam Chair. And again, a freshman question. Hopefully it's an easy one. How come this bill is not in taxation if it's a tax issue or this aspect of it?
I think it's, as we have seen throughout the 130th legislature, bills often have policy issues that cross the kind of artificial boundaries that are created by our committee structure. But the relationship between the state of Maine and the Wabanaki Nations is something that is assigned to the jurisdiction of our committee. And I believe that is why this bill came before our committee. And I do think that the time for contesting jurisdiction has been addressed. This bill's been in the committee and we've been working it. And, we've all been asking, including you, really great probing questions about it. And so I think it is something that we're able to handle and address.
Thank you for that clarification. Appreciate it.
Yeah. All right, committee members, I'm not seeing any other hands up to weigh in on the policy issue. I'll just briefly add my own comments, and it's actually quoting something that Kate Devonshire said. She said, we'll make it work. And I really appreciate that expression of that kind of can-do attitude on her behalf. I do think this is a really important way to provide resources to the Passamaquoddy Water District. Their new filtration system is going to cost, we just heard, $200,000 a year to replace the carbon filters in order to keep the water clean. And this increased revenue that they can use by not paying property taxes would help them. It would support about a third of the cost of that new annual filtration expense. And so I think we'll put just move on to our next issue. Before we do that, I would just, let's see. I'm just going to take a minute to find our next issue by looking at the bill analysis. So, okay, the next issue is obtaining trust status for the 2 parcels of land in Perry. And I am going to ask Peggy if you could bring over Michael Corey Hinton. He is a member of the Passamaquoddy tribe. He is also an attorney who worked on this legislation, and I think he'll be able to give us a good, quick summary of the implications of that aspect of the bill. Welcome, Attorney Hinton. I know that you have spoken to us before in detail about this bill. For the purposes of this work session, we're going to have some committee questions about the 2 parcels of land and obtaining trust status. But can you just give us start us with a broad brush summary of what the proposal is and what the impact or implications are?
Yes, I'd be happy to, Senator Carney. Thank you very much for the opportunity to be here today and for the opportunity to present to the Judiciary Committee regarding this significant human rights legislation. LD 906 would take 2 pieces of land that are currently owned in what is called fee simple status by the Passamaquoddy tribe and would allow the tribe to apply through a federal process to have those lands added to the Passamaquoddy Indian Territory. And by virtue of doing so, those lands would be put into a federal status referred to as trust status. The Maine Indian Claim Settlement Act currently identifies swaths of land throughout the state that are designated as being within the Passamaquoddy Indian Territory. And those lands are all specifically identifiable in the text of the Maine Implementing Act itself. LD 906 would modify the definition of the territory to include these 2 additional tracts of land. In particular, the first tract of land, we call it Zamaguanagook. It's the place where the water flows in Passamaquoddy. It is a tract of land that is located immediately adjacent to the reservation. It is directly across the street from a brand new federally funded school. And on this parcel of land, which the tribe acquired in the 2010s, I believe, around 2014, there is a well. There was a well located on that land. The tribe, in the middle of the pandemic, when water quality reached a low in the spring and summer months, the tribe, there was outcry regarding water quality, and the tribe engaged in an effort to identify potential alternate supplies of drinking water for community members. Presently, community members, if they are uncomfortable drinking the PWD water, which comes through Brown certain times of year, they will purchase their water. They will have water delivered to their house, or they will have to drive to fill up water. The closest fill-up station that tribal members use is approximately 15 to 20 miles from the reservation in the town of Robbinston, at an unregulated water source. So the first tract of land, Zamaguanagook, is a location where the tribe rehabilitated a well, where the tribe has used federal COVID response funds and contributions from a nonprofit to put a well house on the site to make sure that there's an electric pump, so that people can any time of year go into a warmed structure to fill up water. It would just be essentially a roadside spring, and the tribe is currently going through the process of having this well put onto line, and we're hoping that that'll happen before the water turns bad in the spring and summer. That's the first parcel of land. It's approximately, I believe, 38 acres located in the town of Perry. The taxes paid on that parcel in 2021 were $1,447.50. I'll repeat, the taxes paid on that piece of property to the town of Perry, $1,447.50. I would note that for these lands that would be added to the Passamaquoddy Indian Territory pursuant to LD 906 if enacted, the tribe is obligated pursuant to the Maine Indian Claim Settlement Act, Implementing Act, to make payments in lieu of taxes. And so any lands taken by the tribe and put into a protected trust status, the taxes that would have been paid to the towns would be paid to Washington County. The town pays significant amounts of revenue to Washington County to help offset the impact of trust lands on local governments. And so there would not be a total loss to the town with respect to that parcel. The second parcel of land, we call it the Humphreys Farm. It is located about a mile from the western edge of the reservation in the town of Perry. It's approximately 17 acres. It was acquired by the tribe some time ago and has been used by the tribe for temporary housing, and it has been used to support community food development. It is a farm, and it has been used as a farm by the tribe, and there is a desire to continue to rely on the property as a farm, and also to ensure that there is water available from the parcel. In the early 2010s, the tribe worked with the Water District and the United States federal government to obtain a grant to look at alternate supplies of water districts to replace the current supply for the Water District. And one of the supplies that was identified and that was analyzed for purposes of that feasibility study was a groundwater supply located beneath the Humphreys Farm property that we're referencing. That water was tested on that site, and there is quite a substantial supply of water. I don't know if it would necessarily be able to be a full municipal supply for the whole region, but there is a lot of groundwater there. And immediately after the town, the tribe was testing, the town of Perry passed a moratorium to prevent use of water from that parcel by the tribe in the way that it had been envisioned. And so the tribe has been unable to essentially use its water under its land for the purposes that it would like. And so this legislation would put that Humphreys parcel also within the Passamaquoddy Indian Territory. Again, that land wouldn't automatically become trust land. The tribe would have to apply through federal law to have those lands specifically accepted into trust. The total tax impact of the Humphreys parcels, I have the numbers. There's three different tracts. The first tract, the tax bill was $1,425. The second tract was $774. And the third tract was $1,188. These are all contiguous tracts that comprise the farm itself. So the total taxes paid on that property, it looks like it would be somewhere in about $3,000 to $3,500 taxes paid on that particular property every year. I hope that answers at least some preliminary questions regarding the fee to trust portion of LD 906. I'm happy to answer any follow-up questions. Thank you.
Thank you. And I do think that committee members will have questions for you. We appreciate you being here. Senator Keim, go ahead with your question.
Just want to make note that it's generally when we have a work session, we have an unbiased person present us our bill analysis and walk us through an overview. We don't usually have a proponent of the bill come and explain the bill to us. So I think that in fairness, probably we should have Peggy walk us through our bill analysis and not Attorney Hinton.
Thank you for that comment, Senator Keim. I'll just share my perspective with you. Janet worked very hard to provide us with thorough a thorough bill analysis and a lot of information in response to our questions. And she is not able to be with us this morning, unfortunately. I did try to give an overview hitting on the important points that were raised in Janet's bill analysis. It is there for us to read. We can ask Peggy to provide some more information if she is able to. I thought that as chair of this meeting, the most important thing right now is for people who have questions, who may disagree completely with the intent of the bill or the information that is being provided, to ask questions of people who are providing the information, whether it's questions that you might have for Attorney Hinton or questions that you might have for someone else. And, my apologies for not following the process that you would have preferred us to follow. I'm just trying to get answers to committee members' questions and help people follow the lines of questioning that they need to follow in order to make up their mind on the policy decisions underlying this legislation. Would you like us to ask Attorney Hinton to return to the attendee space and have Peggy present more of the bill analysis? Because we can certainly do that if that is if you think that would be most helpful in answering committee members' questions.
I think that having Peggy go through the bill analysis, and if you wanted to do it section by section, that's fine. But I think having Peggy walk through the bill analysis before we just invite people on who are, for or against is helpful, and is typically how we do that, so that we have an unbiased representation given to us of the bill before we get into the biased representation.
Okay, that's fine. Attorney Hinton, I'm going to send you back to the attendee space. And Peggy, are you able to give us a bill analysis on this section of the bill?
I mean, I think you've already talked about it a little bit. It is amending the main implementing act to, this is just section 2. So it adds a new paragraph F, and it's the 2 parcels that Attorney Hinton described. This means it's eligible for federal, for trust status. It's a protected status, and it's held by the Secretary of the Interior, the U.S. Secretary of the Interior, on behalf of the Passamaquoddy tribe. There is a process to go through. What is included in the amendment is at the end of paragraph F that the addition of land to the Passamaquoddy Indian Territory pursuant to this paragraph is not subject to approval by any city, town, village, or plantation within the state, which is actually part of the current law. And you can see that in section 3 of the amendment, because it cross-references this one paragraph in subsection 2. What the process is when land is transferred into the ability to be trust lands when it's within the jurisdiction of a municipality. So this would accept it out of that process. There's still the federal process to turn it into trust land. Is that helpful?
Go ahead, Senator Kime.
So I missed some of what you were saying, Peggy, because I somehow got changed out and so I've been lost in cyberspace as someone kicked me out and then put me back in, and I don't know what was going on. So I kind of missed what you were saying. But my question about this is that there's already a process to take land that the tribes own, and in fact, that's what they were given money for in the Settlement Act, is to purchase land and make that trust land, I believe. But can you explain that process to me? And if that's what you just did, I'm sorry again.
So my understanding is that the implementing act laid out parcels of land or areas where land could be purchased. And that's part of statute, even though it's something that everybody has to agree to. Because these parcels are not already listed in the statute, you need to amend the law to include those specific parcels to make them eligible through this process. There might be another trust process available. I know that Attorney Binney had talked about a process outside of the Settlement Act, and that's not what this is. This is keeping it inside the Implementing Act. And the Implementing Act includes a provision that says if, so the legislature has over the years added different parcels, amended the law to add different parcels once they were purchased and held in fee by a tribe, to allow them to become trust lands under this act. And so that's the state level step. There's a federal step after that. And sometimes there's a deadline on how fast the Secretary of the Interior goes through that process and accepts them into trust status. This does not have a deadline on it. The existing process says if that land that's identified as within a municipality, then there has to be, let's see, no lands within any city, town, village, or plantation shall be added without approval of the legislative body of that city, town, village, or plantation. And what this amendment is doing is saying, we're going to skip that piece for these two parcels of land. That we're not going to say the approval of the legislative body of Perry in this case is required. We're amending the law to say that doesn't apply in this situation for these two parcels. And once, if this goes into law, and the Passamaquoddy tribe will need to certify that they approve of it because it is actually amending the Implementing Act, then it goes to the federal level, and the federal level has their process for examining the situation and deciding whether or not to take the lands into trust.
Okay, so just to clarify then, the process under the Implementing Act would allow them to do this, or no, because this land is out, because the Implementing Act has certain lands that they're allowed to take into trust land, and this is outside of that?
So that's why this is here, is because these parcels are not specifically included in any kind of outline of what property was anticipated to be taken into trust. But if you look at all these paragraphs, anything after B are things that have been added by the legislature. And in addition, there are several parcels in paragraph B in that big block that have been added since 1980. So it's not an unusual process for the legislature to agree with the tribes and add land into the category that can be taken into trust status. What's different here is that this land is within the town of Perry, and normally the legislative body of the town of Perry would have to approve that before going forward. And the language here says, no, we're not making that requirement happen for these two parcels.
Understood. Thank you so much.
Senator Keim, I just want to apologize for rushing us. I think I can see that your suggestion that we start with Peggy's analysis was really helpful, and I appreciate you raising the issue. Thank you. Committee members, are there questions for Peggy regarding the analysis of this part of the legislation? Representative Reckitt, go ahead. We're not able to hear you, Representative.
I don't know whether Peggy can answer this question. It came to my mind when Attorney Hinton was talking, because I know from other meetings, not with him, but with the tribes in general, that something about the process of the shift from buying land on fee as fee land and then making the transition to trust land. And aside from the situation around the town of Perry, and I understand what Peggy is saying, and that's very helpful, about were this to be done without this legislation, that the town council or the selectman or whoever runs Perry would have to agree. However, my question is, were this property to be shifted with into trust land by agreement with the feds, because they're the ones that have to do that. And my understanding, it's a year or two process, maybe, if you're lucky to do it. What my question is, would that impact the decision that apparently the town of Perry made, that the tribes cannot use the water on the land that they owned under fee land? If that land gets shifted to trust land, who then would or could decide the control of the water underneath that land? Is it the feds? I mean, would the Department of Interior have to do it? Or would the tribes be free to do it themselves? Or could the town of Perry still say, no, you can't have the water under the land that you own? That's my question.
Right. I think that's a complicated question, and I'm going to do my best to answer it. And hopefully I will answer it. Once it becomes trust land, it becomes part of Indian territory. And so sections 2 and 3 of the bill are dealing with turning those parcels into trust land. And then section 4 of the bill is amending the powers of the Passamaquoddy tribe and the Penobscot Nation. But specifically, if you look on page 3 of the amendment, you see that it's specifically authorizing the Passamaquoddy tribe to exercise power pursuant to sections 6207 subsection 10, which is new language and appears on page 5 of the amendment, and 6207A, which is also a new section, and 6209A subsection 1 paragraph F.
Peggy, I'm so sorry, but can I just ask you to back up just a little bit? You were talking fast and I'm trying to find my place. So, and I want to hear it. Sorry.
Okay. I'm going to shortcut it. And then if somebody can, maybe somebody else will have to fill in details. My understanding is that the next sections of the amendment do provide the authority for the Passamaquoddy tribe to regulate drinking water on those parcels. That's the shortcut. And so I was kind of drawing a map, but you don't need the map. You just need to know that this would make sure that they had the authority to at least enter into, it says, intergovernmental agreements authorizing the state of Maine to exercise concurrent jurisdiction over specific drinking water related issues within the Passamaquoddy Indian Territory. So I think it definitely takes it out of the realm of something that the town of Perry can regulate. It doesn't mean it's completely unregulated. The legislation goes on to authorize the Passamaquoddy tribe to administer drinking water related programs. This ties into the US EPA and the Clean and the Safe Drinking Water Act at the federal level. So, I mean, it's a little bit complicated, but the whole idea is you turn these into trust lands. They become part of Passamaquoddy Indian Territory. Passamaquoddy tribe is given the authority to use those lands to produce drinking water.
Thank you. That's
Committee members, would it be helpful to have Peggy screen share the amendment and then show us how that transition happens in the actual proposed language of the bill. Can you like wave your hand or give me a thumbs up if you would like her to do the screen share? Okay, I'm not
Okay.
seeing a groundswell of support for that. Peggy, thank you.
Great. I do want to say it's much more complicated than that about regulating drinking water. And that really is something that I am not up to speed on. Most of this I'm not up to speed on, but that's definitely something I would need some help or a little more time to be able to answer specific questions about. But that's kind of the game plan.
Thanks, Peggy. There are a couple more committee member questions for you. Representative Moriarty, go ahead.
Thank you, Madam Chair. Peggy, I'm still in section 2 and looking at subparagraph F. It describes the 2 parcels purchased by the tribe, the one in 1983 and one in 2017. I gather that under the implementing act as it stands now, a tribe may purchase and become the owner of a parcel without the consent of the host community.
They, just like anybody else, can purchase land. Yes.
Exactly. In the
Yes.
same fashion that you and I could buy a woodlot or something like
Right.
that. Okay. Now, looking at the immediately preceding paragraphs, D1, D2, and E, they each refer separately to other acquisitions. They've given dates which post-date the 1980 Claim Settlement Act. Can we infer from this that the legislature has already amended the main implementing act to cover those post-1980 acquisitions?
Yes,
So it's a path we've taken before.
it is.
And-
Most of, go ahead.
No, you were still answering, so.
No, I'm good. Go.
Okay, all right. The last question then is, even though the tribe owns these 2 parcels as shown on the map, as you know, in fee as the lawful owner, do I understand that it cannot tap the water resources of the aquifer unless they acquire trust status?
I don't think that's normally the situation. But as Attorney Hinton described it, it sounded like the town of Perry adopted a moratorium on doing that. And because that land is owned in fee, just like if I owned the land and the moratorium applied to my property, then I would not be able to do that as well.
Okay. And
That's my understanding. I don't have any firsthand knowledge of that.
right. So it may be a final question. When it comes to tapping an aquifer and drawing down on the resources of an aquifer beneath an entire town, who has the say-so on that?
That is not an answer I could even come close to give. I apologize.
That's all right. That's all right. Thanks very much.
Representative Libby, go ahead with your question.
Thank you, Madam Chair. Peggy, first of all, in a historic context, do you have any knowledge on how many times before the process has skipped town approval?
I think that most of the property that's been acquired up to this point has not been within a municipality, a town, a plantation. It's been unorganized territory, basically, so they didn't have to go through that step. I don't remember. I mean, there was paragraph C was land in the city of Calais. That was many years ago when they thought there might be an opportunity to build a casino in Calais. That would have required Calais to agree to that because there's no exception. I don't think there's an exception. Yep, so it even says one, the acquisition of the land by the tribe is approved by the legislative body of that city. That's actually the acquisition of the land as opposed to turning it into trust status. But I don't recall there needing to be an exception from municipalities.
Okay. And then my second question related is how large are these parcels that are under F, number 1 and number 2? Do we have the size of those parcels?
All I know is what Attorney Hinton said, which was one was 38 acres, and that's the one that abuts the reservation. And the other is it's 3 parcels, but it makes up about 17 acres.
17 acres. Okay. And I'm curious, I'm sure you can't answer this question, but you might know who could answer the question of, so if that's rough math here, 55 acres, would it be reasonable to think that when tapping an aquifer under a total of 55 acres, that you could tap and get 1 million gallons in 1 week without going outside of that 55 acres?
I wouldn't have, I have no idea. I'm sorry. You're right. I'd have to ask somebody else about that.
Okay. I'm sure we'll come across that answer in the process of the hearing. Thank you, Peggy.
Representative Hagan?
Thank you, Madam Chair. I have 2 questions. May have been touched upon by Representative Moriarty. Does any of the water that the drinking water go through either of the 2 parcels?
I don't know.
Okay.
They are in the town of Perry. So is your question, are they being served by the water district?
No, I was just curious as to, does any water go through those 2 parcels at any point?
And do you mean like piped?
Yeah, the piped
By
water.
pumped
Yeah.
through? Oh, I still don't know the answer to that, but I was just curious.
Okay, and then I have one more. If this bill passes, what kind of power would the tribe have to impose restrictions on water coming into Passamaquoddy land? What kind of authority would the tribe have on water that's not there yet?
So and I don't know the answer to that. I think that has been a question that's been raised over time, and I must admit I don't know what the answer is to that.
Okay. All right, thank you.
Thank you. And Representative Hagan, please, those are good questions. Please ask them in the subsequent portions of the work session.
Sounds good. I actually wrote them down.
Excellent. Senator Keim, go ahead.
Thank you. So Peggy, when I asked a question about, land acquisition, and then you said it has to go through a federal process, and I recognize that, we're not federal, so we don't know everything about that. But do you have any idea on what types of things they look at? For one, for 2, does it really take 1 to 2 years, like Representative Reckitt said? And then if the town of Perry were opposed to this acquisition, do they have some kind of recourse with the federal government? So what I'm wondering is, is the federal government a sort of a rubber stamp on what we do here in the state, or do they have some sort of real process they're going through? And and then can the town of Perry sort of bring that grievance to them if we pass this and they didn't like it? And if you don't have that answer, that's fine. I just think at some point we should probably understand a little bit about what that next level looks like.
Right. Thank you. I know that there are other people in the attendee room who can answer that question. I also know that this is something that the Judiciary Committee spoke about a couple of years ago, and I can probably access those materials, but just not right this second.
Right.
So you can either have somebody else answer it, or you can wait until we can pull those records up from a couple of years ago.
Okay, thank you. And just a comment to Representative Moriarty, I put in a bill, my very first session about tapping aquifers, and that is an incredibly complex subject, and I got blown away with, water rights issues and that kind of stuff. So I think if we do dive into water rights issues, we're going to need some experts, because it's very complex.
Representative Poirier?
Thank you, Madam Chair. And this question actually goes along with putting the lands in trust, but also with the water testing that was done on those lands, because what I'm hearing is that's a big reason why they're wanting to put the land into trust, is to tap into the water supply there. So after the test drilling was done, there was negative impacts on area residents and having dry wells after the 1 million gallons was pulled over the course of those 10 days. If this land were put into trust land and the tribe decided to pull water, if residents of Perry continued to have issues with dry wells, would they have any means of, would they be able to rectify that after the test drilling problems with wells? The tribe did take responsibility for that and rectify with new wells. But if it's in a trust status, is there anything guaranteeing that anybody negatively impacted outside of the tribe would have anything taken care of for them?
I really don't have an answer to that. I don't know if that's something that the federal, Safe Drinking Water Act applies to. If the state has some regulatory authority over that. I know that, as Senator Keim said, aquifers are complicated, and who can access them and what you can do with them. So I guess we'll have to, there might be somebody here who can answer that question, but I certainly can't. I know that Janet tried to get people from the EPA here. I'm not sure if they would be able to answer it, but they were not able to attend.
Thanks, Peggy. Senator Keim, I know that you've asked a couple of questions. Representative Newell's hand is up, and she hasn't had an opportunity to ask Peggy questions, so we defer to her for just a moment. Go ahead, Representative Newell.
Thank you, Madam Chair. Would it be possible to bring Attorney Hinton back in to answer Representative Poirier's question?
Yes, it definitely will. Let's wait until we finish up with questions that we wanted to ask our committee analyst, and then we'll bring him in. Thank you. Senator Keim, go ahead with your question.
Peggy, I know this, we're just bombarding you, and I'm so sorry, but I was asked to look at testimony because I know Attorney Hinton said that they actually passed an ordinance that said they could not extract water, and I didn't know if you had any information about that. I was told that it wasn't that they couldn't extract water, that there just became a process. So do we have any information about that?
I do not have that information.
Okay, well, I'm certain that someone coming next could answer that. Thank you.
And Senator Keim, I know that we've received voluminous documents from Janet, but one of them is a copy of that ordinance. Okay, committee members, any additional questions for Peggy? I am not seeing any. I know that Attorney Hinton has been listening, and I would like to bring him back onto the panel to answer some of the questions that Peggy wasn't able to answer. Representative Babbage, did you have a question for Peggy before we bring Attorney Hinton on?
Only if, thank you, Madam Chair, only if she can facilitate the process so we don't have to bring other folks in. I have a question for Mr. Hinton, but I wondered if Peggy, and I know, knows from the analysis what the impact of this real transfer in real estate status means to the respective municipalities in the water district. Have we received that testimony? I would like to pursue.
Representative Babbage, when you say what it means, are you talking about from a property tax impact?
I'm aware of the finance issue, but we're talking in this section about the change of status from fee into the pipeline to become trust land. And I just wanted to make sure that I understood what the perceived impact would be on the municipalities and the water district. And I can wait and get that from others, but I didn't know if we could shorten the process if I just was not recalling testimony that already addressed that.
I don't recall specific testimony on what that would mean. I mean, you've heard the information about the property taxes, but payment in lieu of taxes to the county. I don't know if you're talking about land use. It doesn't sound like they're intending to do different land use other than sources of drinking water. But sorry.
It's fine.
You all set, Representative?
For Peggy, yeah. Thank you.
Okay.
Thank you.
Representative Evangelist, did you have another question for Peggy?
I have a question for Attorney Hinton.
Okay, and Representative Libby, did you have a question for Peggy?
I did not have a question for Peggy. I did want to bring up that it might be helpful to bring Scott McNichol in, Perry Selectman, in regards to the impact to Perry. That it would be helpful to hear from him. And just a quick point of order, it would be helpful if we could perhaps remind the participants that the chat is for technical issues only, and that anything else belongs in the forum here.
Representative Moriarty, did you have a final question for Peggy?
No, I don't, Madam Chair. I want to get into the queue and request that Ann Belfleur, the Water District Business Manager, be brought back in. She testified a little while ago.
Okay, so I think it's helpful for us, instead of bringing people back and forth between the panel and the attendee space, to hear from one person at a time. And so the list that I've got is Attorney Hinton and Belfleur. And who did you mention, Representative Libby, that you wanted to hear from?
Scott McNichol. He's the
Perry
Selectman.
Okay, so we'll hear from Attorney Hinton, Scott McNichol, and then Ann Belfleur. Okay, so Attorney Hinton, welcome back. And I know that you have been listening. Could you start by answering some of the questions that had been asked of Peggy that she was not able to answer? And then we'll take specific questions from committee members.
Sure. I've been taking some notes, and so I'll try to take a stab at some of the high level issues, and I would appreciate follow-up questions. So the big category of issues that I'd like to address first relates to use of tribally owned groundwater. And I'd like to start with the fact that the Passamaquoddy tribe owns land in Perry, and that landowners do, constitutionally speaking, enjoy the right for equal access and equal rights under the law with respect to their property. When the tribe received federal funding to help the water district look for an alternate supply of water, the town of Perry received reports that some wells were negatively affected. There's no doubt about that. The tribe and the United States replaced wells that were negatively affected. I believe the number was less than 5. Some of those wells were hand dug. Some of those wells are extremely old, and one of those wells actually turned out was drawing water from tribal lands. The reports were received. The town of Perry passed a moratorium. They banned the extraction of water. They subsequently passed an extraction ordinance that effectively requires a costly process for anybody to use water for any purpose other than small water supplies for homes or for very limited numbers of people. The extraction ordinance, the water extraction ordinance, is currently the law for the town of Perry. It was instituted following the moratorium. Both the moratorium and the water extraction ordinance were enacted specifically in response to the efforts of the Passamaquoddy tribe to use water on its land. In these ways, I think there's a very strong argument that both the extraction ordinance and the moratorium are unconstitutional deprivations of property rights, and they constitute unconstitutional discrimination against the Passamaquoddy tribe. With respect to the wells, as I stated before, the tribe ensured that people negatively affected had their wells replaced. For anyone who's been involved in large infrastructure projects related to water or otherwise, you will know that anytime that there are large budgets of projects, there are always funds included in the budget to deal with mitigation and to affect citizens and other people, the nature or the public that are negatively affected by projects. That is how there was funding available to specifically support those individuals that had their water levels negatively affected. And I can say with absolute certainty to Representative Poirier's question that if, and it's an if, there was a decision to use the water supply on tribal lands, there would be funding available to help deal with the adverse impacts of that. As I said, that is how these projects are handled in a matter of course. I hope that answers some of the questions related to the use of the water. Water is inherently a shared resource. The key is that Passamaquoddy tribe has been unable to use its resource. The question is not whether the Passamaquoddy tribe should be able to use its water or not. The question is whether the town of Perry should be able to hold a veto over the residents of Pleasant Point and Eastport and their desire to get clean water. The town of Perry has a vote on the PWD board. It is not a customer of PWD. The town of Perry has enacted ordinances to obstruct local efforts to supply clean water for the water district. And yet they are not the people who receive brown water. I'll stop there and I'm happy to answer any questions.
I was muted. Thank you very much. There are a number of committee questions for you, and we'll start with Representative Evangelos.
Thank you, Madam Chair. Wanted to say hello to Chair Harnett. Hi, Tom. Attorney Hinton, first of all, I have a comment and then I want to get a clarification and a question, but I managed a school system once and we did 5 construction projects, and one of them was in the town of Union. We acquired new land, and it's a school of 400 kids. And well, I was in charge of this stuff, so I called a well driller and told them we needed a well. I didn't have to ask anybody permission to drill a well for my school kids. We just did it. Maybe there was a permit we had to file. I don't remember, but this is a human rights issue. Equal treatment for all. But my question is, you mentioned on the $4,400 loss in property tax revenues, there was a payment made to the county. I would like to know if it would be possible when that payment was made to send it as an offset against the town of Perry's county tax, so it would come off of their line. They have, I looked up their town report, well, it's 2 years old, so might be a little dated, but I assume they're paying a county tax of about 170,000. So is there any way that that payment could be directed to their line at the county?
That's a great question, Representative. Thank you very much. As I mentioned before, the tribe makes substantial payments to Washington County as payments in lieu of taxes. And those dollars are specifically intended to help offset the tax impacts of lands not being specifically taxable by local governments. However, I don't believe that it would be the tribe's decision as to whether or not certain funds could be earmarked for the local governments. I think that's something that Washington County and the municipalities would have to work out. But I mean, the tribe, makes these payments, and these payments would continue with respect to these two particular parcels if they were added to the territory. And again, these lands wouldn't automatically go into that status. There is a process that would have to be gone through, and I'd be happy to answer questions about that process. I know that Senator Keim and Representative Libby had specific questions about the trust acquisition process, and I would like to be able to answer their questions if they would be so willing to direct them to me at any point. Thank you.
So to be clear, the payments are directed to the county in general.
Yes.
And it would have to be a locally negotiated offset and not part of what we're talking about today then.
There may very well be an agreement in place for Washington County to distribute those funds to specific municipalities, because the tribe does make payments already on lands within the town of Perry, for example, as a part of that, payment in lieu of tax structure. So that may already exist. I don't know off the top of my head.
I won't get bogged down in it today, but it would be a good idea if that offset could be applied directly to their line, and then we'd have one less point of contention here. Thanks.
Senator Keim?
Thank you. Thank you for being here, Attorney Hinton. I have a question. What provision of the ordinance of the Passamaquoddy Water District do you find unacceptable? I mean, the ordinance that the town of Perry put in.
I believe that the ordinance as a whole is facially neutral, but has discriminatory intent. And there are specific types of discrimination analyses that you must go through when you're looking at laws. There are some laws that are on their face discriminatory. They are facially, obviously, specifically intended to discriminate against certain types of people.
So can you give me an example of what exactly is discriminatory? What language there that you find discriminatory?
As I said, with respect to this law, this would fall into a different category of discriminatory laws. And that category of discriminatory laws are laws that are facially neutral. So on the face, the specific language doesn't express a discriminatory objective, but when you look at the actual impact of the law, that's where the discrimination and the disparate impact becomes noticeable. The only way to really evaluate whether a law has discriminatory intent in a way that is not facially apparent is to look at the actual effect of the law. And here we know that this law was specifically passed because of the activities of the Passamaquoddy tribe. I'm unaware of any other landowners in the town of Perry that have run into similar issues trying to use water on their lands. Therefore, I think there's a strong argument to be made that the entire purpose behind this law was to discriminate against the Passamaquoddy tribe, even though those words do not appear in the text of the law itself. And there are ample examples, particularly in the Deep South, where laws have been enacted and where there's been discriminatory intent that was only apparent from the impact and not on the face. There is an entire body of constitutional law that is developed around these sorts of laws.
Okay, I have a few questions around this, Madam Chair. So I understand from your perspective, you see this as discriminatory. I will interject and say that when I came into office, there was a lot of upset people in my territory, in my district, about Poland Springs and their tapping water. And it isn't necessarily because someone is, tribal or not, but the impact on other people's wells is very concerning. And so I think from their perspective, it isn't necessarily discriminatory, but just a matter of trying to protect wells. So I think some of the things, so there isn't a specific requirement then that's in their ordinance that you're opposed to. It's just overall because it impacts what the tribes want to do with water. I mean, because you think it's discriminatory, but there isn't an actual requirement that you find is unacceptable or is something that wouldn't be proper.
To be really clear, there's a well-developed public record around this period of time in about 2014. And Poland Spring was not trying to put a water extraction operation in the town of Perry.
You're right. I bring up Poland Spring just to say that happened in my district. And there was a lot of changes that were attempted around law. It wasn't necessarily discriminatory, I guess is what I'm trying to say. Like the town of Perry, you're characterizing them as being discriminatory with this ordinance. What I'm trying to get at is if they're just trying to protect their people with their ordinance, and is there any specific issue within the ordinance that you find unacceptable, that is not proper for an ordinance? Because you said that everything within it, the language itself, is not discriminatory, but your opinion is that it was, the purpose behind it was discriminatory. So I'm trying to get beyond that level and down to the level of the ordinance itself. And if there's anything in there that you find to be problematic that you would disagree with.
Yeah, as I said, laws don't need to be explicitly discriminatory in order to be unconstitutional. And this, in my opinion, alone is an example of a law that was not passed to address private interest rights, which is what a Poland Spring would be. But this is a law that was specifically intended to obstruct the desires of the Passamaquoddy tribal government, which has a unique constitutional status, a protected status. This ordinance was passed to obstruct their desire to get clean water. It's not that there's specific language. The embodiment of the entire ordinance itself was targeted at the Passamaquoddy tribe's efforts to get clean water. And it's practically an incontrovertible fact. If you read the news articles from the time, if you talk to people that were in the room when the town of Perry considered these issues, they weren't talking about Poland Spring, they were talking about the Passamaquoddy tribe. That process, that dynamic resulted in an ordinance that very clearly was intended to target one landowner in the town of Perry. That landowner happens to be the Passamaquoddy tribe, a federally recognized tribal nation that is entitled to protection under the civil rights laws and under the Constitution of this country.
Yeah, so similarly though, if someone comes in and pumps water out of any town and it impacts others around them, I think towns have to then react in some way. So whether the conversation around that was discriminatory, it remains that in the end, did they pass an ordinance that is fair, that everyone has to abide by, that is actually a proper ordinance for the protection of the greater good? And I think I hear you saying that, yes, the ordinance is proper. It's just
That's not what I'm saying. That's not at all what I'm saying. Please do not distort my words. What I'm saying.
Chair, point of order.
Go ahead, Representative Newell.
Madam Chair, I believe the line of question that Senator Keim is proposing has been answered by Attorney Hinton. If we might please move on with the questions, I would appreciate that.
Yeah, I agree with you. And these questions have been asked and answered. It's obvious that there is a disagreement, but we've gone beyond the point where it's appropriate to continue with the this line of questioning. Senator Keim, did you have other questions for Attorney Hinton?
At this moment, no, but I guess I was just trying to understand, I was trying to restate his position back to him so I understood it correctly.
And
And
yeah, and I
that's that
we've
there
covered that.
isn't. Yes, I will come back with questions later. Thanks.
Thank you. Representative Libby, go ahead.
Thank you, Madam Chair. Mr. Hinton, my first question is, we talked about the negative impacts of pulling 1 million gallons of water in 10 days and what resulted from that. And I appreciate that apparently the tribes and the federal government made good on that and provided new wells. So I just would like to know where in the bill, given the dramatic changes this would make, where in the bill does it provide for handling negative impacts and guaranteeing?
Great question. Yeah, it's a great question. It's really important to keep in mind what this bill does and does not do. What this bill does not do is authorize any particular specific use of any particular piece of land. This legislation ensures that tribally owned land is available for some future time when there may need to be an alternate supply of water. This bill does not authorize taking water from anybody, doesn't authorize an extraction project, it doesn't authorize the creation of a new water supply. That is a multi-year process that would need to be engaged in. And the tribe has obtained funds to do another feasibility study to look at supplies of water again. And if that sort of effort were to proceed and were to identify a particular water source to be used, that is when you would have accommodations made and forethought given with respect to impacts on landowners. That specific issue that you're mentioning is extremely important. We've talked to Scott McNichol about this. We actually had a really positive conversation, Representative Newell and I did with him last week about the impact of wells. And we hear the town of Perry loud and clear, but this legislation is really not about taking concrete project steps. It's about ensuring that a supply of water can be used for the uses that a water district or landowner might want to use the water for.
Thank you. One follow-up, Madam Chair.
Go ahead.
So in talking about the moratorium, you characterized the actions of Perry in going over the tribe's heads as discriminatory. And I just wonder, how would you categorize legislation that goes over the heads of a municipality?
That's a great question. And there's a really good reason why local consent is not sought with respect to these specific land acquisitions. The main implementing act includes a definition of the Passamaquoddy Indian Reservation. I know that not everyone in front of you may not have that in front of you, but I will note that this is 30 MRS, section 6203, paragraph 5, the definition of Passamaquoddy Indian Reservation. You will note that towards the bottom of this paragraph, there is a block of text that begins with the language, the Passamaquoddy Indian Reservation includes those lands which have been or may be acquired by the tribe within the town of Perry, and then it describes a certain area. In the early 1990s, there was an acute housing shortage on the Passamaquoddy Indian Reservation. Homelessness rates were soaring. The Passamaquoddy tribe owned a parcel of land at the corner of Route 190 and Route 1 that it sought to use for housing purposes. The town and the tribe engaged in the process of how those lands could be put in protected status. The town of Perry ultimately required the tribe to pay $350,000 just for the tribe to be able to take land that it owned to add it to its reservation so that the tribe could build housing outside of Perry's municipal zoning ordinances. So when you ask, why have we taken this approach? The reason is in the implementing act. The town of Perry has extracted significant sums of money, more than $250,000 for the tribe to acquire single parcels of land in trust. This same language says that the town of Perry must approve the tribe's use of those lands. that process that the tribe went through, it literally cannot afford, $250,000 for parcels of land. Those are extractions of monetary concessions that the tribe simply cannot afford right now. And so there's a very good reason why local consent from the town of Perry has not been sought. It's because since the 1990s, the town policy has been to, on the first hand, request significant sums of money for the tribe to take tribally owned land and put it in trust. And two, the town of Perry has taken specific directed legislative action to obstruct the tribe's desire to use its lands. Taken together, it's very, very clear that the town of Perry has significant reasons why it would not support tribal self-determination with respect to the development of critical human needs, including housing and water. I know that City of Town of Perry Selectman Ann Belfleur, she can talk to these issues from the town of Perry's perspective. So she's available to talk about how the town has dealt with these issues for the tribe in the past. But again, it's included in the law how much money the town of Perry has requested that the tribe pay to build, critical infrastructure in the past.
Thank you.
Representative Hagan, go ahead with your questions.
Thank you, Madam Chair. It's been a long time since I thought of this question, so it may have been answered by Mr. Hinton in many of his answers. So bear with me. I'm not a constitutional expert, but I was curious when you had said that the town of Perry's thing is unconstitutional, and I was wondering exactly. And I'm sure you can give me a good answer on this one, easy one for you. Where in the Constitution? So what would you be citing for an unconstitutional act?
The Constitution provides that all citizens are entitled to equal protection under the law.
Yeah.
And so I would say that this sort of discriminatory ordinance would clearly constitute an equal protection issue. And I would argue that it would also constitute an unlawful deprivation of property rights, a regulatory taking of the tribe's water under the constitutional takings provisions.
Thank you. Another one?
Go ahead.
Would one of my two earlier questions be appropriate here, Madam Chair?
I honestly am not remembering what they are. Can you,
How
why
about I
don't you
throw out
move?
and you just tell me if they would be appropriate with Mr. Hinton?
Go ahead.
I was curious as to, does the water go through either of the two, the piped water go through either of the two parcels?
I do not believe so.
Okay.
No.
And would this bill give the tribe the power to impose rules or restrictions on water not on tribal land coming into tribal land?
No, it would not.
Thank you.
Thank you for asking those questions and for writing them down and remembering them, Representative. Representative Babbage, you're next.
Thank you, Madam Chair. Appreciate it. Mr. Hinton, if I haven't spoken to you yet, it's good to see you again, and thank you for being here. Just to make sure that I've got the facts correct, perhaps you can confirm this. We're talking about two parcels of land, about 55 acres total, which are in the town of Perry, that are not reservation, but that have been purchased by the tribes. And if they were to go from fee land to trust land, it would mean a little less than a loss of $5,000 in tax revenue to the town of Perry, but that currently the tribe is paying payments in lieu of taxes to Washington County. Would as a result of these transactions, would those payments in lieu of taxes be increased by some amount that would be determined at some point?
It's a good question. Thank you, sir. My understanding is that the payment in lieu of taxes would need to be increased to account for the tax revenue that would have been paid on these parcels. So in other words, it's, the payment will be shifted from going directly to Perry, essentially to Washington County, to offset, the local governments.
Thank you. And if I may, Madam Chair, did I miss here or you helped me? My question was going to be originally, can you clarify for us the precise negative consequences that would be rectified by this transfer of fee to trust land? But I think we're really talking about the restrictive Perry ordinance regarding the drawing of water and how that would not apply to these two parcels if they were put into trust land. Is that right?
Yes, that is true. I mean, and to be really clear, there's two parcels and there's two different bodies of water that are under them. And so would it be helpful if I just talked about the water and how it might be used to help sort of better frame?
You can answer a couple of things really quickly for me if possible. The Boyden Lake, the reservoir is in Perry, is that right?
Yes.
And did you say that the Perry ordinance restricts both the reservation and the town of Eastport?
No, well, the town of Perry would just restrict lands within the town of Perry, and it's a tribally owned lands in Perry. I don't believe that there'd be any impact on Eastport property unless it was owned in, within Perry.
And the ordinance does not impact your ability to draw water on the reservation if there were some there, but it's specific to these two parcels.
Yeah, that's right. The ordinance would not apply to lands in reservation or trust status.
Okay, those are my questions. Thanks so much. Appreciate it.
Thank you.
Representative Evangelos?
Thank you, Madam Chair. Hello again, Attorney Hinton. I'll be as brief as I can. Let's do the first one with a yes or no answer. Let's see, equal protection of the law, the 14th Amendment of the Constitution. I can drill a well for my 400 school kids. You can't drill a well for your 600 residents. That's an equal protection issue, isn't it?
I mean, yes, there's an equal protection issue at play. Answers are always more complicated than simple yeses or nos. And I think, the issue of, drilling school wells for kids is something actually that the tribe can speak very specifically to, because we've run into issues trying to put wells online for school children on the reservation. And it's interesting to hear that you have not had that issue elsewhere. So there may very well be equal protection issues embedded throughout this matter.
Yeah. Well, what I'm getting at is everybody should be able to drill a well on their property within, unless it's a zillion gallon something for Poland Springs or something. This is a timing question. In the development of that ordinance in Perry, did that come almost concurrently or right after the problem affected by the private property owners?
It came immediately afterwards. There was the moratorium was put into place immediately after there was a public meeting regarding the reports, and the moratorium was in place for a period of time until it was replaced with the water extraction ordinance. And so there's a very clear line and timeline from receipt of the reports to the moratorium and to the extraction ordinance. And I believe that the ordinance and that whole policymaking process was immediately in response to the water testing activities.
Well, thank you. That's a very important distinction for me in regards to the discrimination issue. Do you think that the new filtration system that's going in is going to help? Because you've indicated there's pieces of what we're talking about here today that'll take perhaps up to years to get implemented. Are you hopeful that remedial action will give you some short-term help until a new water supply can be found?
We certainly hope so. The tribe has put a lot of resources into that upgrade. We've been a major partner in financing that upgrade. And so we sincerely hope that the upgrade will help. It's important to note the upgrade, all it does is clean the water better. It's called polishing. And the water source itself is becoming increasingly shallow over time, meaning the water will become increasingly dirty and increasingly subject to swings in water quality. And so, when you look at the infrastructure of the water supply itself, it suggests that these filters, they should be helpful in the short term. They are intended to help clean up the water, but it's unclear if they could be a permanent solution given the fundamental erosion of the water supply itself.
Thank you, Mr. Hinton. That's all I had, Madam Chair.
Thank you, Representative. Representative Poirier, go ahead.
Thank you, Madam Chair. And I do have a question for Mr. Hinton, and then perhaps when the timing is right, we can bring Ann Belfleur back to get her perspective on the ordinance and also impacts to the town of Perry for this portion of the bill. But Mr. Hinton, one thing I just want clarification on as far as putting the lands into trust, where we're going around basically what the implementing act calls for now. Has the town of Perry objected to putting the lands in trust, or have they even been approached about putting it into trust, or has that not been done whatsoever?
There have been discussions between tribal representatives and town representatives regarding this legislation, but there's been no specific separate discussions regarding the placement of those parcels in trust. Those discussions have been a matter of, the broader legislative discussion.
Okay, thank you.
Thank you, Representative. Representative Thorne, go ahead.
Thank you, Madam Chair. Attorney Hinton, I'm one of the non-lawyers on the group. These restrictions that are in place, would they apply to and I hate to keep referencing a company like Poland Springs, but would it also apply to them that they could not drill a well and extract water if they were to buy land in Perry? Or
If
is it?
they bought, yeah, good question, sir. If they bought land in Perry, they would definitely, everyone in Perry is subject to this water extraction ordinance, whether you're private or whether you are a public entity.
So it's possible that maybe they were thinking about a company doing that. And if it applies to them, that it's not exclusively targeted to you, it may be targeted towards another company.
I'm not aware that there were any other entities mentioned in the course of those policymaking discussions other than the Passamaquoddy tribe.
But if it's not unique to just the tribe, if it also applies to a company that would move in and do that, then it's not necessarily unique to the tribe. It applies to everyone.
Theoretically, you are correct. However, there's zero record of any water bottling company looking to go into the town of Perry.
But it would prevent it, correct?
I think that
Madam Chair,
Representative
point of
Thorne,
order.
excuse me. Thank you, Senator Sanborn. Go ahead with your point of order. I think you were going to raise.
Asked and answered just as Representative Newell's point of order a while back.
Thank you. And I agree. You've asked the same question twice and it's been answered. And so if you have an additional question that you would like to move on to, Representative Thorne, please go ahead. Otherwise, we'll move on to Senator Kime.
No, my question was answered, Madam Chair. I appreciate that. Thank you.
You're welcome. Senator Kime, go ahead.
Thank you. My question is well, two actually. One, I think Representative Libby asked if there was anything in here that protected. So if the ordinance was put in place because there was this impact to wells, and so they put in an ordinance that would protect, would take into account like the impact on the general vicinity. So then if the tribes take over the land, is there then no protections in place regarding impact to the general vicinity on whatever you choose to do with this land?
Thank you for the question, Senator Keim. I don't think it's correct that there would be no protections for residents of Perry. The United States has an obligation to protect private property rights when it's undertaking infrastructure projects. A project like this would be funded with federal dollars, and it might involve implementation with the Passamaquoddy Water District as well. It probably would. And for those sorts of entities, you can't just take somebody's property without compensating them. The United States Constitution prohibits the taking of property without just compensation. And so I think that as a matter of law, there would necessarily need to be safeguards put in place to ensure that if in fact there were any negative impacts, there are specific provisions made to protect private property rights that might be negatively impacted. And that's what happened previously. I have receipts from how private wells were paid for people that were negatively impacted, and we can document precisely how the tribe facilitated the construction of those new wells. And I would assume that the same exact process would be employed here to ensure no negative property impacts.
So are you suggesting then that we would put in something in the law that there wouldn't be negative impact?
What I'm saying is that federal law, state law, the law of this country requires that it prohibits the taking of private property, including water, without providing compensation. And so when the United States or, like I said, the water district too is engaged in a project to utilize water, if there is what's called a taking of someone else's property, drawing down that person's water, they would be entitled to compensation as a matter of law. So it's not necessary to modify this legislation, which, as I stated before, isn't specifically about any particular water project. But those safeguards exist because they are required and they're inherent in law in this country.
Okay, and then my next question is, and maybe this isn't the right question for you, but if the tribes were to take over the water district itself, is there some objective that would be different in that happening other than the way it's being currently run?
The tribe has no intention to take over the water district. I mean, to be really clear, this legislation, it doesn't alter how the water district operates. This legislation is specifically intended to provide support for the water district. And the tribe has invested significant resources for many, many, many years to help the water district function. In no way, shape, or form is this legislation about the tribe, doing some statutory overtaking of the district. It's not about altering how the water system operates. It's about simply helping the water district do a better job. And so, the tribe wouldn't be taking over the water district. Sorry if I gave that impression.
Thank you. And for Peggy, I think that what I hear Attorney Hinton's response about water rights and whether it's implied in state law or federal law or whatever, I would like follow up on that at a later time, because my past history with dealing with Poland Spring issues leads me, I definitely had different experience of what the law would be in protecting people. So I think we need that information for later. Thank you.
I'd be happy to submit the receipts for the amounts paid to provide new wells to citizens impacted. That would probably be the best way to gauge this issue, because Poland Spring is a private company that is not subject to laws like the United States would be with respect to the taking of property. And so when a federal project resulted in negative property impacts, the United States, working with the tribe, compensated those individuals. Those same legal requirements would not necessarily apply to Poland Spring. And I just can't emphasize enough that Poland Spring is not a good comparison. I feel that, actually, respectfully, the activities of Poland Spring are at stark odds with the intentions of the Passamaquoddy tribe here, which is specifically to ensure drinking water for people that live in the vicinity of the water source, whereas Poland Spring extracts water and imports it throughout the world. That is not the intention of this legislation. I think any comparisons between Poland Spring and the Passamaquoddy tribe are unfair and not quite accurate.
I appreciate the difference there. I am merely speaking in regards to the impact on surrounding communities, which is something that I've experienced in my district. But thank you for your clarification.
Welcome.
Representative Babbage, I know you have a question, but I wanted to ask just one follow-up on this conversation between Senator Keim and Attorney Hinton. Could you, Attorney Hinton, first of all, the project that was ongoing when the 5 wells were impacted, was that a federally funded project?
It was, yes.
Can you please describe to us what the adverse impacts, and just briefly, like an outline fashion, the impact that that federally funded project had on other individuals that was a deprivation of their rights, and then how compensation was provided for that deprivation of rights?
I'd be happy to, Senator Carney. Thank you. My understanding is that when the feasibility study was being conducted, it was necessary to conduct a multi-day stress test of the tribal water source. In the course of that stress test, I believe that there were between 3 and 5 reports of private citizens' domestic water supplies being affected. And the specific impacts range from decreased water pressure to water being temporarily cut off to well pumps being negatively affected as well, in terms of being not being able to draw water at certain times. And for anyone who uses well water, you know that if your pump is sucking dry air, it can negatively impact the pump. And so those are the sorts of reports that were received. There was an effort to specifically verify each report. And so the tribe and the United States, particularly the EPA, I believe, they undertook efforts to meet with individual landowners that were negatively impacted. For those individual landowners that were willing to provide evidence that they were negatively impacted, they were provided with new wells. And I could pull together some additional information in terms of the mechanics of how the well was put in and how exactly it was paid for. I've only seen invoices, but I do know that there were some reports that were received that could not be verified. There were some attempts to verify reports, and the people that made the reports were no longer willing, after the report was made, to provide supporting evidence. And so we saw a little bit of a range in some of the reports, but again, the number of wells that were actually replaced, I do believe it ranged between 3 and 5.
Thank you. Representative Babbage, go ahead with your question.
Thank you very much, Madam Chair. I have what I think are 2 quick ones. The first, Attorney Hinton, is if the 2 parcels are transferred from fee into trust land, would that change accessibility of federal dollars?
Well, it depends on how the rest of this legislation would all come together. If, hypothetically speaking, LD 906 became law, and those parcels could go into trust, the tribe would be able to access sources of funding to help support drinking water within the reservation. As it currently stands, there are certain pots of money that the tribe cannot access to support drinking water on tribal lands, because the tribe has no jurisdiction over drinking water systems. And so there would be enhanced opportunities for funding that would be specifically applicable to tribal lands if these lands went into trust and the tribe was able to regulate drinking water there.
Thank you for that. And my second one is only to understand, I think you were about to go there the last time I was questioning you, but regarding the 2 parcels of land, are we speaking about a source of water being an aquifer or drawing down the reservoir, or both?
Good question. So both parcels of land draw from groundwater sources. that are below the ground, and they're, you know, a couple miles away. So they're different sources of water that will be drawn from. One of the parcels of land that's right next to the reservation is right next to Half Moon Cove, for anyone who knows this part of Down East. And there's a body of groundwater that's there. The tribe actually has a well across the street that draws from the same source of water. The other parcel of land would be a little further away, and that I would assume would be a different groundwater source. And those groundwater sources are definitely, you know, distinct in every way from the surface water source that is the reservoir.
Thank you.
You're
Thank you,
welcome.
Madam Chair.
Representative Hagan, go ahead.
I have one. I'm not sure if this is the correct question for you, Mr. Hinton, but I'll just say it. Maybe you know the answer. Earlier, Ms. Devonshire had said that the water by the time the water gets to Eastport, it's fine, and she didn't understand how there could be a problem. And it just dawned on me in the last few minutes that part, and I was curious. Did you have a response to that?
Absolutely, Representative Hagan. I thank you very much for the opportunity to respond. You'll note in the materials that the Passamaquoddy tribe submitted that there is a concerned citizen survey from citizens of Eastport, specifically regarding PWD water. And I will just pull that up so that I can read from the results of that survey. The objective of the survey was to gather information regarding drinking of tap water provided by the Passamaquoddy Water District. There were survey boxes that were located at the library in Eastport, the Eastport IGA, and in other locations in Eastport and Perry. And there was also a notification of this survey that went out in the Quoddy Tides local newspaper. The results of the survey, there were 78 total responses. And of the total responses, it looks like the majority, the significant majority of these individuals do not use the water, the significant majority actually. And comments provided by respondents to the resident survey include, we do not even give it to our animals, and it's ridiculous to pay for water you cannot drink. I would note that specifically in response to this concern that I heard from Ms. Devonshire, you know, we've been aware for a while that there is a narrative that the water is fine in Eastport. And I would like to say that I have specifically inquired and received testimonials from residents of Eastport in the past several weeks that indicate their dissatisfaction with Eastport, with water in Eastport. We've gone to great lengths to find out whether or not people are indeed satisfied with their water. And I'd like to also note, if you look at attachment D to the Passamaquoddy tribe's response to questions from the committee, you will see the results of water quality testing over roughly a 10-year period from 2009 to 2019. The water district, it tests one location in its entire system, and it tests water in the city of Eastport. So when at any point there is a notice put out that the water district has failed a drinking water quality standard, that is water tested in the city of Eastport. So when you look at D, this attachment D to our responses, you will see that at times the water quality in Eastport is more than double the level for carcinogens. Now, that water may look clear, but it is most definitely laden with a specific type of carcinogen, a trihalomethane called chloroform. And the notices that the water district gives out regarding water that it tests in Eastport show that the water, prolonged exposure to elevated levels of trihalomethane, can cause cancer and liver failure in people with vulnerable health and otherwise. And I will note that the Passamaquoddy tribe has been engaged in a research project to specifically look at whether or not elevated levels of trihalomethanes can be linked to adverse health outcomes in the community. And it is early results from this research suggests that if you reside at Pleasant Point, you are more likely to suffer from adverse health outcomes, including cancer and birth outcomes. So these are the results of perhaps of the water quality that's delivered to the residents of Eastport as well. Thank you.
Okay.
Did you have a
I'm happy
follow-up?
to answer a follow-up.
Well, I was curious as to if the town of Eastport is not complaining, how scientifically can water be very bad going through the reservation, but not or not bad to a point where the city has not got an issue with it?
Yeah, it's a good question. And I just want to know, I mean, the PWD manager, Ann Belfleur, who I believe is present to speak on behalf of the town of Perry today, she was quoted in a newspaper as saying that the water is bad sometimes. It's not always good. I just want to be really clear. 12 months out of the year, you're not going to necessarily see brown water. But in the spring and the summer, it is very possible that you will see bad water. And what we are seeing is that essentially there are people that are content with brown water certain times of year. The Passamaquoddy tribe has been receiving this brown water. And regardless of what Eastport residents have decided to make public, regardless of what their city officials have done, the Passamaquoddy tribe sees this issue. And we know that our residents in Eastport see the water problems as well. So it's not just Ann Belfleur that recognizes the water problems in Eastport. It's also the residents of Eastport, regardless of whether or not the public officials are willing to make a statement in support of clean drinking water.
Okay, thank you. And at some point later, I would like to bring back Kate Devonshire's person. I didn't write his name down, so I don't have it. The guy who works at the facility from where his office is in Waterville.
The operator?
Yes.
Okay. Thanks. I'm going to just add that to the list. And Representative Libby, go ahead with your question.
Thank you, Madam Chair. I think actually my question might be better suited for that gentleman because my question is, I understand that the treatment facility in Perry is installing now a new carbon filtration system. And I guess my question would be, does that new carbon filtration system remove trihalomethanes?
Great question, Representative Libby. And the polishing process that is intended to be affected by these filters is hoped to remove trihalomethanes. That's one of the specific hopes that we all have for the filters.
Okay, I thank you. I'll ask that of the water treatment gentleman. I'm sure he'll have facts and not hopes. Thank you.
I respectfully resent that characterization of my response. I've met with the water district engineers. I've met with state of Maine engineers. I've met with Indian Health Service, and I met with the Environmental Protection Agency. I have put years of effort and countless hours into understanding this issue. And I will tell you that the filters are intended to solve THM problems. However, it's important to note that there's been absolutely no pilot testing done with respect to this technology. It is only hopes that it will clean THMs. There are sincere hopes, and they are based on the best perspectives of the water district, which I would encourage you to get. But please do not pretend like I'm giving you anything other than facts.
Mr. Hinton, I did not use the word hopes, and I am not trying to mischaracterize you. You used the word hope, and I would like to have an answer about whether these filters do indeed.
Representative Libby, you are arguing with Mr. Hinton, and would ask that
I respectfully disagree. Thank you, Madam Chair.
We're going to move on to the next question. Senator Keim, go ahead with your question.
I don't have any question for Attorney Hinton. I would like to have Tim Woodcock brought back on and have you add him to the list.
Thank you. I will do that. Okay. And so I think it looks like we are done with questions for Attorney Hinton. And so the list that I have is Scott, and all I've got is Mick N because I didn't write down his full name. Representative Poirier, what was that individual's name?
Actually, I believe Ann will be speaking on his behalf. They're both selectmen in Perry. Scott actually is traveling back to Maine today and is on a plane right now and couldn't be with us.
Okay.
So Ann should be able to answer those questions.
Thanks. Thank you. That's really helpful. So next we'll hear from, well, the list is Ann Bellafleur, the operator of the Passamaquoddy Water District, and then Tim Woodcock. At this point, committee members, it's nearly noon. And I think what we should do is, and we have been meeting for 3 hours straight, so I would like for us to take a lunch break. I would suggest that we take a half-hour lunch break, which I know is short, but we have a lot of people here to speak to us about these bills, and we obviously have lots of questions as a committee. So can you nod your head if 30 minutes is okay with you for lunch? Looks like that is acceptable to everyone. So let's take, we'll be in recess until 12:30, and please return promptly, and we'll start with Ann. Thank you. Hi, Representative Harnett. When we resume, when the committee reconvenes on the screen, I'll give you a chance to introduce yourself. I think you're the only committee member who hasn't had a chance to do that.
We have a full slate today, so I think so. Thank you.
And committee members, I know it was way too short of a lunch break. And Peggy, thank you so much for curtailing your lunch as well. I think if you are back, committee members, please activate your video so that we can resume the work session on LD 906. Thank you. All right, I want to begin by talking just for a moment about where we're headed, because this is our first bill and we've just finished our lunch break. And during the break, I took a look at the bill and the bill analysis and kind of traced what we've talked about and what we haven't talked about. And I think there are two umbrella issues. One is the charter amendment regarding the property taxes. And I feel like we had a very thorough discussion and covered that information. The next kind of major issue is the putting the land in trust status, and then the change of authority as to who regulates the drinking water. And we haven't quite gotten to that last one, the authority over who regulates the drinking water. And so what I'd like to do is to spend maybe 20 minutes or so hearing from the few people who have been identified as speaking on the trust status issue, and would encourage committee members to listen to each other's questions, because I do think that way we can make the most efficient use of our time. And then I would like to make sure that we hear, at least spend some time hearing from Michael Abbott, who's the director of the drinking water program that's run by the Maine Department of Health and Human Services. I think that we'll finish our work on LD 906 by around 1:15. And then I think that we should continue to move through our bills during the work sessions in the order that has been indicated on our schedule. And I would just let people who are here for 585 let you know that I don't anticipate that we would reach that until at least 3 o'clock this afternoon. And so I would just ask that you check in with our committee clerk, Susan Panett, probably around 2:30 for an update on when we might be taking up 585. Let's see. I saw a hand up, Representative Evangelos.
Thank you, Madam Chair. Along those lines, I'm really concerned about the day's schedule. These issues are so hugely important. And unless the chairs define time constraints for today with continuous work sessions going on into next week or sometime, we're never going to make it today. I mean, 1626 is still in front of us. And it's like 10 times as complex as 906. I don't know what we're going to do, but for one thing, I'm asking our chairs to tell the leadership that this artificial March 11th constraint, given the workload assigned to this committee, is going to have to give way to common sense. We need to do our work as best as we can, and we're never going to make it by March 11th. I'm not finding any fault with the chairs. We've got these monumental issues in front of us. Indigent legal is another one. We need time. Obviously, today's an example. We don't have the time. There are some things that aren't going to get heard today. We're just going to either that, or we have to develop time constraints on each work session and tell the folks we're going to come back next week and do another session. I don't know how we're going to resolve it, but we're never going to get through all this with 1626 in front of us. I don't know I'll let you and Tom respond, but we need to do something and we need some help from leadership.
I agree with you that our workload for today, like I didn't anticipate that 906 would take the amount of time that it has taken. We do have authority to meet 5 days a week, and we can certainly add work sessions. And I don't necessarily think we're going to get through everything that we had hoped to get to conduct a work session on today. But it's also really unpredictable how quickly or how lengthy work sessions are going to be. And that's why I'm sort of kind of walking through the various steps and making decisions as we go along, just because it is so unpredictable. I don't want to cancel work sessions that have already been scheduled for this afternoon and then find that, you know, something goes really quickly and we have extra time. And so it's a very imperfect and imprecise process as far as the work that lies ahead of us today. But I would just ask for people's continued focus and patience. And I think what we'll do is we're going to finish up on 906 as I had outlined, and then take maybe a 5-minute break to make a mental transition. And at that point, I'm going to assess a little bit more where we're headed for today. And again, I know it's not ideal. I wish that we could be more definitive at this point as well, but it's kind of the nature of the work we do and how important the policies are that we're laying. So thank you for raising that, Representative. Okay, committee members. So at this point, the next person that we're going to hear from on LD 906 is Anne Bellafleur. And Peggy, if you could bring Anne onto the panel. And again, committee members, we have heard a lot of information. We're not deciding whether a specific project is or isn't needed. We're really deciding whether the Passamaquoddy tribe would be authorized to put 2 pieces of land into their trust land. And so just to keep that in mind in your questioning of the next couple of people who committee members have asked to bring onto the panel for questions. And so with that, Anne, welcome back to the Judiciary Committee. We appreciate your standing by all morning on our behalf. And I think that Representative Poirier, I know that you in particular had questions. Would you like to start with your questions?
Sure. Thank you, Madam Chair. I would like to know what the impacts of having the land transferred into trust would have on the town of Perry. And that does play into the water drilling that we have discussed as well. I would like more information on what the impacts were from the town's standpoint also. Thank you.
And Anne, before you answer, can I just ask you, I know you wear multiple hats. Are you here today with your Passamaquoddy Water District hat or your Town of Perry hat on?
Well, so far it's been both, but I do have our licensed operator here for the water district. It's just that he couldn't answer the financial questions, but he can answer all other aspects of the district.
Okay, can you then speak to us with your Town of Perry hat on, and we'll bring the operator on to answer the water district questions. Thank you.
Okay. So how will it impact the town of Perry if it's turned to trust land? I think it will override the ordinance that we have in place. Loss of, I don't know, the hunting and fishing rights, if any, that we have. I think the ordinance is the biggest aspect.
Representative, do you have a follow-up?
Yes, I just would like to hear Anne expand on how the ordinance came into play, because we've heard from Mr. Hinton his perspective on that, but I would like to know as far as the towns, how spread out was the impact And how would you feel this land going into trust would impact in the future?
Well, there were wells in the area vicinity that went dry or lost pressure or low water quality. And I've heard it's been all the way to the next town, but that's hearsay. I don't have proof of that. I lost my train of thought. I'm sorry. Yeah. So if they don't have to abide by the ordinance, it's going to affect the whole town. The ordinance was set up so that any large scale over 5,000 gallons or more a day, would have to provide the town with information on what was going to take place, how it was going to take place, what the impacts were going to be. Hopefully there was or is a study done to present to the town so we could make, an informed decision. And it wasn't targeted to one person or group. It's anyone who owns land and wanted to do this large extraction of water. So it was just to maintain, a little control by knowing what's happening. So if the citizens come to us, we would be able to help them. I mean, we don't want anyone's wells to go dry and not have any way to fix it. People can't afford a new well, every other month or year. So that's why the ordinance was put in place. I don't know if that answers your question.
Thank you. It does.
Representative Moriarty, go ahead with your question.
Thank you, Madam Chair, and I apologize. I've got to leave right afterward to go to criminal justice. So, Ms. Belfleur, we have the advantage today, as opposed to 2 weeks ago, of two terrific maps provided to us by Janet, our analyst, which show us the locations of not only the communities, but infrastructure along the way. So I have just a few quick rapid fire questions for you. As I see it and understand it, the water district is a single source district. And that source is
Correct.
The Boyden Stream Reservoir. Is that correct?
Yes.
And that's surface water as opposed to the aquifer.
Yes.
Right? At this point,
Yes.
the district does not draw any water from the aquifer in Perry.
No, we did not.
Okay. I don't know where from the source to the ultimate destination, is there a purification or treatment plant?
We have a treatment plant in Perry.
In Perry. Okay.
That's probably a couple miles from Boyden's Lake where the source is. So
Okay,
there's a treatment plant in Perry.
Okay, so it comes from the lake to the treatment plant. You have no customers in Perry, as it turns out, right?
Right.
So from Perry, the treated water then passes through Sabayak, and
Yes.
the tribe draws from the treated water, correct?
Yes.
And that water
Yes.
quality, would you agree, is bad, at least seasonally, if not year round?
Define bad, I guess.
Well, we've heard it: brown, smelly, carcinogenic. I'm not trying to trap you here. Let's just be upfront.
I would say we do have a problem with color a couple times a year, depending on runoff or the condition of the source.
Okay, and then from Pleasant Point, the pipeline continues on down to the city of Eastport.
Yes.
Correct? And are there any purification plants between Pleasant Point and Eastport?
We have a rechlorination station located in Eastport in case it needs a, boost of chlorine before it gets.
Just chlorine,
Yes.
right? Okay, so Eastport's customers are getting the same water that those folks on the reservation are getting.
Yes.
I don't understand why Eastport isn't up in arms about this.
I don't either. I can't.
But
We
you must
have
be-
very few complaints.
Seriously.
Well, what happens when it gets to Pleasant Point? It goes through 3 master meters.
Yep.
And then it goes within the reservation.
Yes.
So we're looking into or trying to identify if there may be an issue within their infrastructure versus Eastport's is all new over the last 20 years. The district has $16 million in loans we're paying back for all new infrastructure in Eastport.
Okay, last question. You just referred to their infrastructure on Pleasant Point. Isn't it the district's infrastructure?
No, they own it.
So they treat the
They don't
district's water separately before
They
it's
don't treat it separately.
well,
They don't treat it separately. They distribute it separately.
okay.
They distribute, once it hits the master meter, it goes into their piping to each individual house. Pleasant Point is one customer to the district, not 700 individuals.
Well,
if that makes sense.
Well, it does, but it sort of
So it's
obscures
the
the
same,
truth, the fact that you've got 700 users on Pleasant Point.
That's what I was told.
Did you,
Okay,
Representative
I think
Moyer,
that's it.
you all set? Okay.
Yes,
Thank you.
Thank you. Yep,
We'll see you after you're done with criminal justice.
hopefully.
Senator Kime, go ahead.
Thank you. Thank you for coming and spending your day with us, Ms. Bellafleur. So I had a couple of questions for you, but I think Attorney Hinton sort of characterized the town as being discriminatory in the people, I guess being discriminatory towards the tribes in passing a water ordinance. Were the residents fairly well aware of what was going on, and was the vote on that like really close or pretty overwhelming? Do you remember?
Vote, yeah, it was like 107-4. That was the vote on the ordinance, or the moratorium, and then the ordinance.
So they were two separate votes. You mean there was a moratorium at first and then they figured out an ordinance and then voted again on the ordinance? Is that what you mean?
I'm not sure how it went. I wasn't on the select board at the time.
Okay. All right. That was unfair.
For the ordinance, it was like 104 or 107-4.
Okay.
So.
And so I'm assuming that the bill, overstepping the ability of the town of Perry to vote on this is because they're assuming the town of Perry wouldn't agree to the land. And there was some, I think Attorney Hinton also made some reference to the fact that the town of Perry charged kind of an exorbitant amount or something for land that they already had. But I just wondered if you could help us understand a little bit more the town of Perry's perspective. I know this is sort of an open-ended question, but I think that there's a lot being said about the fairness factor and whether it's fair or whether it's not fair and whether it's discriminatory. So I need sort of your perspective from the other side on this. If you have a way to frame it for us, that'd be helpful.
I think the ordinance was written fairly. It covers anyone in the town. If I have property and I want to, drill a well that's going to produce massive amounts of water, I think I should have to go to the town and submit plans and give information and get approval. I don't think it was targeted at one group. It just so happened it coincided, it brought about because the town wasn't involved in, oh, we're gonna try to drill a well here and see how much water. They weren't involved in it from the beginning. And then when, people's wells were affected and they were coming to the town complaining, something had to be done before it went too far. So it's a fair ordinance. They have never approached the town with an application to continue on with, as far as the ordinance. I don't think it targets one group.
Right, and the ordinance isn't just a regular person digging their well and doing their well on their land. It's for large water, large water usage, large water extraction.
Exactly.
Right.
Yes, and I think in the ordinance. Yep.
And then, so how does the town of Perry, if you can speak to this, how do they feel overall about the idea of this land being put into trust land without circumventing the normal process, which would be that the town would vote on that? Because you all have in fact voted on allowing the tribe to purchase property and put it in trust land in the past. Is that right?
Yes, there is a parcel that was annexed, I think in the 80s or 80, that they annexed, and in lieu of future property taxes, the town was paid, $350,000. So it's not like it's never been done, but the town has not had a chance to poll anybody or have a public hearing to see how the town feels,
Mm-hmm. So for this, for the process that happened in the 80s, the tribes did come to you, did come to the town, sorry, not you, but came to the town, went through that process. But at this point, with this land, they have not ever initiated conversation about, can we also take this land and annex it and put it into our own?
Right. The town has not been approached or asked or, asked for a meeting to discuss this. So, and of course, we'd look at it, all the facts, and I don't know if it's the legislative body or the town as a whole that would make that decision. But we would seriously take it into consideration and look at all the information, but we have not been approached.
That's very helpful. Thank you.
Representative Newell, go ahead with your questions.
Thank you, Madam Chair. Good afternoon, Anne. How are you?
Good.
It's good to have you here. I have a few questions, and I know some of the questions that preceded my questions, you responded from the point of the district, as well as some additional questions just recently posed to you from the perspective of the town. I think I'd like to just kind of go back. We spoke on February 15th. I came before the town selectmen to let them know that this piece of legislation and to go over parts of the legislation, the proposed legislation, to the town selectmen. and encouraged the town of Perry to participate in this process. So I would raise a question of concern in regards to the testimony that was submitted on behalf of the town of Perry that indicated that there was no knowledge of this public hearing being conducted. Would you take a different position now after I've mentioned that I came to the town of Perry to speak directly to the town selectmen, yourself included, and encourage your participation in this process?
We were notified. It was, what, 2 days before the public hearing? So I guess there was probably misspoke in the testimony. We did know, but we did not have time to provide any testimony or be a part of the public hearing. We didn't have enough time.
Okay, I appreciate your response. And can I just circle back to questions just posed on the town of Perry's moratorium? I had mentioned in the conversations to the town that I recognized our relationship here in 2022, and that I didn't really want to go back to the politics that surrounded 2014 and the issuance of the moratorium. However, due to the number of inquiries in regards to that moratorium and what's been asked and the responses provided, I think I would like to refer to an article and just ask for your interpretation, if I may. Madam Chair, if I might, I have a copy of the Bangor Daily News article from October 23rd, 2013, in which the Bangor Daily News, the caption was Perry Selectmen seek moratorium to block Passamaquoddy Tribe's water project. And that the 3-person board adopted an article for the proposed moratorium and set a special town meeting November 4th to put the question to the town voters who must approve it. The moratorium would buy the town time to amend its land use ordinance and also adopt a water ordinance, explained by board chairman at the time, Ms. Karen Ray. The town must take steps to make sure that people are protected from the tribe's project, said Ray. We need the time to protect the people of Perry, she said. The article goes on further to describe the 10-day process. And it's my understanding that there was communication during this 10-day process between our environmental department, our director, and the town of Perry. And I believe there have been emails exchanged during that process. And that, as indicated in earlier testimony, remediation was made to 2 or 3 of the town residents that expressed effects by the town drilling. So I would ask you, Anne, in relation to the questions that were posed earlier and what I just read, what would be your position now as to whether or not this article and the questions and responses provided this morning earlier might indicate that this land use ordinance was directly as a result of the tribe engaging in a feasibility study to identify the groundwater located on tribal fee land.
Can you say the question again? Because I don't know what you are looking for an answer.
I think I was just looking for a response to what the prior town selectmen had indicated in feeling like the town of Perry and the town selectmen needed to protect the people from the tribe's project, and that they need the time by issuing the moratorium, thus opting to put the question out to put forth a town ordinance restricting land use.
I wasn't on the Board of Selectmen at that time. I can't speak for Karen Ray or who the three were before me, but I know they acted as they felt was in the best interest of Perry citizens. And when they're receiving complaints of wells going dry, they took the action they felt was needed. If you came to us now, we would take into consideration what you want to do, look at your plan, and work with you. So that's my feeling.
Yeah, I appreciate your response, Anne, and I would agree that that has been our approach with this piece of legislation. However, one additional question, if I may, Madam Chair, can you expand upon how Perry's hunting and fishing rights would be affected by the passage of LD 906?
Representative Powell and Anne, I'm just gonna, I think that I would like to move on. I know that I set out a time frame for how we were going to finish our work, at least for today, on 906. And I respect your question, Representative Newell. We will get to it at a different time. I know that the property is privately held fee land at this point, and I think we're all aware of that. But I did want to take one question from each of the three people who have their hands up, and then we're going to move on and see if there are questions for the operator, and then hear from the state public, the state water safety program. So one question from each of you. Representative Harnett, go ahead.
Thank you, Madam Chair, and thank you, Ann Bellafor, for being here today. And I apologize, I missed the first 2 hours of the hearing because I had a personal commitment I had to attend to. And my question's simple, because Representative Newell inquired into the area that I was concerned about. In 2014, when the moratorium was put in place and the ordinance eventually adopted, was there any entity other than the Passamaquoddy tribe who was proposing to draw more than 5,000 gallons of water a day through any water project? Excuse me?
Not that I'm aware of.
Okay.
Not that I'm aware of.
Okay, that's all. Thanks very much for being here.
Representative Babbage, one question, please.
Come on. Thank you. Thank you, Madam Chair. I would just say,
Is this a
for the
question?
committee's benefit, that
Is this a question, Representative?
it is. But I think we should avoid assessment of blame here and understand that reasonable people are trying to accomplish reasonable things from their own perspective. My question, I'd like to be corrected if these facts are wrong, that the PWD sends water to Eastport through Pleasant Point's Sapayex pipes, but in Eastport, they treat the water and they bleed the water through a modern infrastructure. And if that's, but my question, just correct me if I'm wrong on that. My question is this, and it's to Ms. Belfleur, and thank you for entertaining our questions. If the tribe does extract groundwater, if this process goes through and they are able to, at their own initiative, extract groundwater, how does that affect the Passamaquoddy Water District's income and water supply? That's what I'd like to know. Thank you.
Well, and that's a question the district has, you know, will we be tying into that? Or is it, will it, you know, how are the two things going to tie together? That's a question we have too.
So you really
I
don't
can't
have an
answer
answer
that.
for that at this point.
That,
I don't.
that appears to be the case, Representative.
Thank you very much. Thank you.
Representative Poirier, go ahead.
Thank you, Madam Chair. I would like a clarification of something Ms. Belfleur had mentioned a few steps back here regarding the way the water flows through the system. Just for clarification, so we all understand how it works. So it goes from the pump station through the piping, hits the tribal territory. It has 3 mains, you said. From those mains, the water district doesn't control any of that piping infrastructure. That's up to the tribe to do. Is that my understanding?
That's how it's always been. We don't, yes, they maintain their piping and their whole system, their systems.
So the water district has no authority or investment into those pipes once they hit off the main. So you don't know as far as if they've been maintained or that sort of thing.
Right, exactly.
Okay.
Thank you, Representative. And Representative Libby, I'm going to ask you to hold your question until, because we are definitely going to have another work session on this legislation, but we're going to move on and bring the operator on. And if Peggy, could you bring Mark McCluskey onto the panel, please?
He's on the same screen as me, so.
Oh, that's right. I forgot. If you don't mind.
I'll move
switching
places.
seats. Thank you. And Representative Babbage, I think your hand is residual. Is that? Thank you.
Yes, it is. Madam Chair, the one thing that did not get answered is would this change Passamaquoddy Water District's income? If anybody could answer that, but thank you.
Thank you. And we've been joined by Mark McCluskey. And Representative Libby, did you have a question for Mark McCluskey?
Yes, I do. I think Mark or Ann could answer my question, so I'm happy to address Mark and have him answer it. So my question is, I just want to clarify that I'm understanding how the water district works. Am I understanding correctly that Perry residents do not receive water from the water district, but instead have their own wells, and that's where the negative impact came from when their groundwater was disrupted versus the water source that is used and processed in Perry and then sold elsewhere? Am I understanding that correctly?
The way it works is there actually used to be some customers in the town of Perry, but due to, there was an old bay crossing that was taken out. And in this case, it was a long dead end line, and boy, we'd really have some trouble with those folks with the THMs if we kept them. So we actually drilled wells for those folks many, many years ago. And that eliminated any non-tribal customers in the town of Perry. And that was just in the section of Perry that we had to do that. The main transmission line runs from Perry when it leaves the treatment plant, finished water, all good, meeting requirements usually. And it goes down Route 190, and it's about 7 miles of transmission main to get into the city of Eastport. And it's approximately a mile from the treatment plant where we have our first meter pit that serves the reservation. And then consecutively, we have 2 more after that. And the water just is fed to the reservation off the transmission main and goes right down into the town of Eastport, a city of Eastport, sorry.
Okay, thank you very much.
Yep.
Representative Babbage, is your hand up with a question or is that residual? Okay. Committee members, are there other questions for Mark McCluskey? Representative Evangelos, go ahead.
Thank you, Madam Chair. Hi again, Mr. McCluskey.
Hello.
Could you tell me I'm not questioning anything bad, but I just want to understand who you are. Could you tell me what your job description is and who you work for? I'm just trying to get clear.
Sure, sure. I work for A.E. Hodgson Engineers. We're based in Waterville. And we've been water utility engineers for close to 40 years now. I've worked for the company for 36. I actually was the inspector on the water treatment plant when it was built here in Perry in 1989. So I've been involved with the district for a long, long time. My role and responsibility now is I work with the engineers in Waterville to develop these upgrades to the treatment plant as an engineering firm, but I'm also the designated operator for the water district. The state requires a class 4 licensed operator, and there's nobody employed by the district at this time that holds that license. So I take the responsibility of being the designated operator is what they classify me as. And I fill out all the monthly reports that are submitted to the state and oversee the operations at the treatment plant.
Okay, so I've got the right guy then.
Okay.
So the water that they drink in Eastport is the same water that the Passamaquoddies drink?
It comes from the same source. It comes from the same treatment facility.
Now,
but the difference here is, if I could, like Ann just said, the reservation has its own engineers. It maintains its own piping system, and you folks need to understand that the way trihalomethanes are formed is a reaction with the organics in the water and chlorine being added to that, and then the other component is the age of water. So, it may go right by the reservation in the transmission main perfectly fine, and there's a lot of high usage in Eastport, so the age of the water is less, and we form less THMs down in Eastport as opposed to the reservation that might have a lot lower usage water and a lot of lines that may be too large and very low use. The water sits in those pipes for a long time, forms the THMs, and that's why there can very easily be a big difference in the amount of contaminants in the water.
Now, these capital improvements that seem to have made in certain locations, are they paid for and financed by each individual jurisdiction, or is this the water district who paid for that?
The water district.
Has the water district made the same level of investment towards improving the conditions on the Passamaquoddy Reservation as they have in, say, Eastport? I mean, it seems like you're getting a different standard because of capital improvements in one location versus another. Explain why I'm having trouble.
I'll have to explain the history here, but the tribe has always maintained their own system. They've never come to us and said, hey, we need some money to replace a main on a certain street on the reservation. They've always hired their own engineers. They've always maintained their own pipes, and they've applied for money to meter every house on the reservation. That we have no idea how many people they serve on the reservation. We just recently received a copy of the distribution system map. I think they said they were going to send one, but I don't know if I ever actually get it. So we have no information on what's on that reservation at all. We do have a standpipe that is owned by the tribe, a water storage tank, and that was paid for by the tribe and is owned by the tribe, but it's actually leased to the district. So the water comes off the transmission main on Route 190, goes into that storage tank, goes back to Route 190, and then is distributed through the meter pits to the reservation. That's the only thing we really have access to and pay for maintenance on is the water standpipe storage tank that is leased to the district.
And as far as Eastport goes, you told me bleeder lines are inconsequential expense, but Is there anything in Eastport's infrastructure regarding the distribution of their water that came about as an investment by the water company that enhanced the water versus what the reservation's getting?
There's nothing that we do to the water that is done for the city of Eastport that we don't do for the reservation. It's all one water.
Okay, thank you.
Yep.
Representative Hagan, go ahead.
Thank you, Madam Chair. Can you remind me where the treatment plant in Eastport is? Is it right?
It's not in Eastport, it's in Perry.
It's in Perry. Okay.
Yeah.
So when the
So-
water, yeah.
Quickly, so Boyden Lake is our source. And there's a stream that comes out of Boyden Lake that feeds what we call the impoundment right in the yard of the treatment plant. And that's on Boyden Stream. We have Perry Station Dam right there that impounds the water, and we have our intakes to the treatment plant in that impoundment. All the water's extracted from that surface water impoundment, brought into the treatment plant and treated that way.
So when the water leaks.
Representative Hagan, my apologies for interrupting, but I feel like we're reviewing information that has been presented to this committee very many times today. And if you could perhaps ask a question that focuses on the policy issues rather than kind of the nuts and bolts of how the system operates, that would be appreciated. Thank you for understanding.
Chair, I just, it's a lot to take in, and I have absolutely no idea about anything dealing with any kind of water. So I was just trying to understand the process. And for the life of me, my earlier question to Mr. Hinton was basically, how can the water that goes to Eastport be fine, but not fine beforehand? So I was wondering if there was a scientific thing, and I'm sure it's been mentioned, but it's just been a lot today. And I don't seem to have it in my head, an answer for that.
Did you wish to pose that question to Mark McCluskey?
Oh, yeah. I was curious, if water leaves a treatment plant, then it should be good for consumption without that stuff. And I understand when water can sit in pipes that may be too large and whatnot, and then you add chlorine, you can have these difficulties. But at the same time, how is it that the town of Eastport never complains, Mark, or doesn't complain? And we have all this problem with the reservation.
I can't answer that. I don't speak for the residents of Eastport. I've investigated one complaint from the city of Eastport from a resident. The day after he had an issue, we were at his house. We tested the chlorine residual. We tested a few other things, and everything was perfectly normal. And what that was the operators were out flushing in the system. You've heard the term flushing. We rinse the system twice a year, and that stirs things up in the pipe. So he had a little bit of dirty water at that time, but the guy was right outside his house flushing, and we figured out that was the problem, and he was happy. He was all set.
Is that water?
As far as,
Yep.
I'm sorry, I didn't hear that.
Is the water tested as it leaves the reservation ever?
It never leaves the reservation.
It doesn't go through the reservation to Eastport?
No. There's a transmission line, just like your electric lines. It runs right past the reservation, just like it's running past your house, and we have a hookup to the reservation.
Thank you.
Yep.
Committee members, Representative Newell, Senator Keim, and Representative Libby, I know that your hands are up. I feel like the information that we're getting from Mr. McCloskey's information that we've heard multiple times, and I would just ask if you can make a note of your questions, and when we have reconvene for another work session, We'll make sure that he's here to answer those questions. At this point, we are going to we have two other people who we need to hear from today. Someone had requested Tim Woodcock, and I'm not remembering who it was, but whoever requested him, could you let us just know why, what questions you wanted to ask?
It was my understanding that he was an expert for the town of Perry on the ordinance and the impact of that. So I was going to ask him about that.
Okay, and are you unclear? Because I kind of feel like we've heard a lot about the ordinance and we understand that what the ordinance does. And but if I bring him on and you can ask him a question, but I'm just concerned that we're plowing the same ground over and over again, as the case may be. So first, let's start with Mr. McCloskey. We're going to thank you for being here, and we will invite you back at a future work session.
Okay.
And then I'll ask our analyst, Peggy, if you could please bring over Tim Woodcock. And welcome, Timothy Woodcock. If you could start by introducing yourself and again, telling us what capacity you are here in.
I appreciate that. I'm Tim Woodcock. I'm an attorney with Eaton Peabody in Bangor. And Eaton Peabody is legal counsel for the town of Perry. And so I'm here in my capacity as the attorney for the town of Perry.
And did you or your firm represent the town at the time that the ordinance was adopted?
I'm not aware that we did. I could check our files on that, but I don't believe we did.
Okay, and so I'm not sure how relevant your testimony is to the proposed legislation that is before us. But Senator Keim, why don't you ask your question and we'll just see how far we'll go with this line of questioning. Thanks.
So I was just wondering, really two things from a legal perspective. I guess the impact that you see of the ordinance that's currently there. And then my other question, if you can answer it, is in regards to changing, and maybe this isn't your expertise, but because the other thing when we switch from the town ordinance that's controlling water usage right now, but then if the bill passed and the Passamaquoddy had authority to adopt ordinances regarding drinking water within the Passamaquoddy Indian Territory, what that impact might be, because we're changing standards, and it's something we haven't yet discussed, but is a significant portion of this bill as well.
Well, first, with respect to the large water extraction ordinance, there's been a suggestion made that it was discriminatory and is unconstitutional. We reject that completely. It is not. It governs the extraction of more than 5,000 gallons of water per day, which ought to be a matter of any municipal concern. And it sets reasonable standards for getting permits for that, including filling out an application, bringing forth hydrogeologists who can testify to the effect of the extraction, and so on. These are reasonable steps that any municipality might take. And from what we understand, the Passamaquoddy tribe has never filed an application under this ordinance, so it has never been denied. With respect to the jurisdictional issue that you raised, as I think the committee is aware, the jurisdictional aspects of this bill would greatly change the authority of the tribe with respect to drinking water standards. They would qualify for treatment as a state status under federal law, which would mean that their regulations would be on par with the state of Maine. And I think effectively would negate the validity, or at least the effectiveness, of the large water extraction ordinance. And I would say, with respect to the part of the bill that would override the town's ability to give its approval to the land going into trust, it's not easy to answer that question if you do not know what the jurisdictional construct is going to be. If the tribe were to have very substantial jurisdiction over water quality, that could affect the municipality's decision. But at this point, as you have heard, no one has come to the municipality, the town, and made this proposal to them. I will say, with respect to the municipal approval process, that was part of the original settlement, and the idea was that the local people, when a proposal like this is made, should have a voice in it. They
Timothy
know most
Woodcock,
about the particular.
you're going beyond the scope, and I know you've been here since 9 o'clock this morning, so you've seen that we're really trying to focus on issues that are related to 906, and I think you've answered both of Senator Keim's questions. So I apologize for interrupting, but we do need to be aware of the work that remains ahead of us.
I do appreciate that, and I would only say the jurisdictional element is tied to municipal approval.
Thank you. Senator Keim, are you all set with questions for Timothy Woodcock?
I have, and maybe I am for him, but I did want to hear more about the idea of the impact that there might be in changing the authority, right, of who sets authority around water quality standards. So I think we haven't explored that yet at all. And maybe if you're wanting to wrap up this this work session, that it's difficult to move forward, but not be able to move forward. I feel like I'm going like, oh, you can ask, oh, you can't ask. So I don't know. It's difficult to kind of follow a line of reasoning, knowing that we're supposed to only maybe ask one question or maybe not. So I don't know if you want to end the work session. I'm fine with that, but I do need to explore the impact, obviously, of the changing of what guidelines are going to be set up. Whether it's going to be the tribes or federal law or state law. I mean, I think those are significant changes, but I don't really understand them.
Yes, and I also have been wanting to move on to that topic as well. And I know that it looks like committee members do have additional questions for Timothy Woodcock, but I'm going to ask you to just please save those questions, write them down, because we will have to convene another work session on this bill. And I do know that Michael Abbott from the Maine drinking water program has been waiting patiently all morning to answer our questions about the current authority over drinking water, safe drinking water. And so I will bring him onto the panel and hear from him. And Timothy Woodcock, thank you so much for being here this morning and this afternoon. Representative Newell, your hand is up, and I wanted to recognize you while we're waiting for Michael Abbott. Did you wish to be heard? No, okay. Michael Abbott, welcome, and Representative Evangelos, is your hand up for a question for Michael Abbott?
Well, no, I did want to speak to Mr. Woodcock for a minute, but if you want to move on, I'll let it go. It's up to you.
Yeah, I ask not that you let it go, but that you make a note of your question, because as I indicated, we will have him back for our additional public work session on this bill. Michael Abbott, thank you very much for joining us today. Could you please introduce us and let you know what your title is and your responsibility is with regard to the Passamaquoddy Water District?
Yes, good afternoon, Senator Senator Carney, Representative Harnett, and members of the committee. So my name is Mike Abbott. I am the Environmental Health Director for the state of Maine. So my division is within Maine CDC. It includes, among other programs, includes the drinking water program. And the drinking water program is the regulatory authority for public water systems in the state of Maine.
Thank you very much. The committee members. And so let me just clarify that currently your department has authority with respect to the Passamaquoddy Water District.
That's correct, Senator. So the Maine Drinking Water Program has granted regulatory authority from the US EPA, Environmental Protection Agency, to administer the Safe Drinking Water Act, which is the federal laws and standards applying to service of public water nationally, and we're the authority that administers that in Maine.
Thank you very much. Committee members, are there questions for Michael Abbott? Go ahead, Senator Kime.
Thank you. I'm wondering if you can just talk to us about the changes in regulation if we were to, so if rather than having it be under state jurisdiction, if it's under just federal jurisdiction, are they more restrictive or less? And then if the Passamaquoddy tribe had the authority, what then happens? But the water goes also to Eastport. I'm just wondering, does that mean that they control the water standards for everyone downline of them as well, and possibly upline, like they control then the water source? Could you help me to kind of just broadly understand what the implications could possibly be, even though I understand the tribes also probably get to create their own rules?
Okay, sure. I'll do my best, Senator, to answer that. So again, just currently the Passamaquoddy Water District is subject to all the requirements under the Safe Drinking Water Act. And again, the Maine Drinking Water Program administers those regulations with authority that has been granted to us from EPA, which is the federal regulatory body. So if the water district was to be under direct federal regulation, it would still be subject to the same requirements of the Safe Drinking Water Act, just administered by a different regulatory body. So meaning directly from the federal EPA rather than the Maine authority. So and then, the other scenario you mentioned, if the tribe was given authority to regulate water within their territory, I think that presents a very complex scenario, and I'm not really clear on exactly how that would work, because then you would have a water district regulated in part of the distribution area or part of the service area by one regulatory authority and then by another regulatory authority within the tribal territory. So I'm not exactly clear on how well that would work or how it would even be implemented. But I think the short answer, the overall answer is that regardless of who or what combination of authorities regulate the water district, the standards that they would have to adhere to are the same, and that's the water quality requirements under the Safe Drinking Water Act.
So then you're saying you don't understand how the authority how that would practically work out, but yet you're also saying that there wouldn't be any difference.
Well, if we're talking about the regulatory authority under the Safe Drinking Water Act, the requirements would be the same, whether the administration of that authority was through the drinking water program as it currently is, with oversight from EPA, or if it was directly from EPA to the tribe to regulate within their territory, or I I guess the scenario that the only scenario where the requirements would change would be as if a regulatory authority, say for instance, if the tribe were to be able to develop new standards that were beyond or in addition to the Safe Drinking Water Act requirements.
So you're saying that's questionable because they would be given the authority to make something more strict, right? I mean, that because if they become a state entity, the same as the state, we can create laws that are more strict than the federal government, but not more lenient than the federal government.
I'm not sure that that's within his scope of knowledge. Could you clarify
at
that,
this point,
Mr.
I would be speculating. So I'd rather not.
Okay.
And then on how that would work.
And then to my question about whether or not then that could like if the authority could then spread to the source of the water as well. Do you have any information on that?
My belief is that the source and the district itself, meaning the non-tribal entity, the Passamaquoddy Water District, will continue to be regulated by the state. But I don't know. Again, this is, some of these legal questions are beyond my expertise, but I don't foresee a scenario where one part of the system would have authority over the rest of the system. The district is going to continue to be regulated by under the Safe Drinking Water Act.
Thank you.
Representative Evangelos?
Thank you, Madam Chair. Got to flip over to a different screen here while I ask the questions here. I'm on the new well and new source approval site for DHHS and Division of Environmental and Community Health. And it looks like there's a collaborative process between the agency so that a community water supply, setbacks on sewer systems, things like that. But
right,
you're generally in the business of making things happen so that the community can get water. Is that correct?
So when a water district wants to develop a new source, the new well approval process basically controls that so that we can ensure before the new source, whether it's a well or a surface water body, goes online and is used to serve water to customers, it has to meet, again, I'm going to keep saying Safe Drinking Water Act requirements, but that includes many, many water quality standards to make sure the water is safe to drink or can be treated to make it safe to drink. And it also has to be, there's a process where we referred earlier, I heard discussion earlier of the feasibility tests or the pumping tests that occurred on the wells that would be considered for on the tribal land. That, part of that process is to determine what the sustainable yield of a well is, so determine how much water can be available there and used on a continuous basis. And so that whole process is necessary for us, the regulatory authority, to permit the well as an acceptable public drinking water source. Did that answer your question?
Yes, but there's a difference between that and telling somebody you can't drill a well, period. You have a certain standard, people meet the standard, whether it's you're saying that the federal and state standard are merged because of the Safe Water Drinking Act, it's the same standard, correct?
Right. Our criteria for permitting a well, as you've mentioned, has to do with setbacks to potential contamination sources and ensuring that the water will be safe to drink.
Okay, thank you.
Representative Newell?
Thank you, Madam Chair. I'll be sure to unmute myself this time, but I'm holding my prior questions. Good afternoon, Mr. Abbott. How are you?
I'm fine, Representative Newell. How are you today?
It's good to see you again.
Yes.
Couple of questions, if I may, Madam Chair. Mr. Abbott, can you speak to your working relationship with the tribe through the multi-stakeholder meetings that have occurred over the past 2 years, and what you felt was at issue here in trying to
Sure.
find resolution to?
Sure. Yeah, I would say, so I believe, was it 2019, we started a process where several stakeholders got together and started discussing the water quality issues. That included the state, and I was a representative for the state, included the EPA, Public Health Service, the Water District, their engineers, A. Hodgson, and people from the several members of the tribal community, including the Environmental Health Department. And we, I do want to say, that, the question of whether or not there are occasional, at least, water quality issues, that's nothing we've ever disputed. Any surface water body can be a wonderful drinking water source, but they also sometimes come with a set of challenges. They can be complex to manage, to treat. And also, as we've heard discussion today, water quality can be complex to manage within distribution systems, the piping networks, and within different parts of the piping networks. So I think we all collectively had a common goal of trying to discuss ways to improve the situation, to improve the water quality for the residents of Sapayak, for the residents of Eastport, for the entire system. We discussed a lot of different options, and long-term and short-term. One of the long-term options was a feasibility study, which I think Attorney Hinton mentioned, to look at potential alternative sources for the water district, to maybe be able to avoid some of the challenges with the current source. As mentioned, the current source has a higher organic content, and the water quality can be challenging to manage, especially in a big rain event, a big snow melt event, or even a big wind event. We moved in the direction of trying to do anything possible to improve the water quality coming out of the source. So the reason we moved toward the idea of I think I've heard it referred to as a polishing system, but it's a granular activated carbon treatment system. So the way that the disinfection byproducts like trihalomethanes can form is, and I'll make this really short, don't worry, but the organic content in the water, the goal of the treatment process is to filter out as much of that as possible and suspended sediments and turbidity before the water goes into the piping. And that's what the treatment plant does, but it has limited capacity or ability to filter out some of those dissolved organics. And so what the carbon treatment system will do is take out the rest, so that when leaving the treatment plant, now when the chlorine is added, there won't be organic content for it to react with and create those disinfection byproducts, which, as Mr. McCluskey mentioned, can even become worse over time as the water sits in the pipe or tanks. So that's the solution I think we collectively moved toward. And then we worked on ways to finance that through our state drinking water state revolving fund, through assistance from the federal government. And actually, Wabanaki Health was able to come up with a portion of that funding. And so that's the project that's in the pipeline now. We all had hoped that would be up and running well before today. But, not to make excuses, but the, supply chain issues, staff shortages, everything else associated with the recent pandemic have unfortunately delayed the production and delivery of that equipment to the treatment plant. But and so currently the hope is it will be installed by June of this year, and possibly even sooner. And we do think that's going to create a substantial improvement in water quality throughout the system. We also, though, acknowledge, as was discussed again earlier, there's no guarantee of that or no certainty as to how, exactly how much improvement we'll see, or how difficult that may be to maintain, or how expensive it may be to maintain as treatment media needs to be replaced. So the other thing in parallel parallel that we'd like to see happening is the feasibility study to look at potentially supplementing or replacing the source at some point down the road to make the system even more stable and easy to manage. I'm sorry, Representative, that was kind of a long-winded answer, but I hope that addressed.
Yeah, I appreciate it very much, Mr. Abbott. Senator Carney, if I may, Mr. Abbott, you mentioned the challenges by the district, and we all agree that there are challenges. Can you kind of elaborate from the perspective of the state in the level of funding that has gone to the Passamaquoddy Water District in comparison to other districts? And why, if you find that number to be higher, why would that be than any other district? And just a quick second question, there's been a lot of uncertainty as to whether or not citizens of Sabayak are the only ones that are affected by this water versus citizens in the city of East Fort. I'm referencing in particular what's located on the district's website, and that is the Consumer Confidence Report. Could you speak to those as well? I have 2018 and 2019 in front of me. And I would like to mention too that there has been testimony provided to this committee by members of East Fort, and they speak to their perspective of what the water quality is to them. So Mr. Abbott, that seems like a really long question for you.
Okay, well, I'll do my best. So to address the first part of your question, I believe it's, well, just to explain how the funding works, we have a capitalization grant every year from the EPA. We combine that with state funds and interest and repayments from previous years of the funding program. So each year meaning the drinking water program, we receive applications for projects from public water systems, and our funding has to go to a public water system from all over the state. And unfortunately, every year we receive millions and millions of dollars worth of requests for our funding program, which is typically a low interest loan, and sometimes a portion of that is principal forgiveness can be forgiven based on the economic status of the area or the district. So we receive all these applications and we score them according to a very long list of criteria, but essentially the ones that are most critical for protecting public health. And not that they all aren't, but we have to somehow prioritize our projects. I mean, in Maine, we're replacing pipes every year that are over 100 years old throughout the state. So we are, we have limited funding, although in the next few years that's going to increase thanks to the federal infrastructure bills. So to answer your question, I believe it was somewhere around $16 million has been awarded to the Passamaquoddy Water District over the years since about 1998, when the state revolving, or soon after the state revolving fund program began. And a lot of that has gone to replacing repairs and upgrades to the treatment plant and repairs and upgrades to the distribution system. I don't have here in front of me exactly what all those are or how that compares to other water districts. I know many water districts in the state have been awarded at least or more that much, but there's also a very wide range of sizes of water districts. We have the Passamaquoddy is a relatively small water district, but we have a lot of those in Maine. In fact, I think we have mostly small water districts in Maine, but we do have districts up to the size of a Portland, which is 180,000 customers. So obviously their projects are going to be bigger. I think to talk about your second part of your question, and just to add on to that, we continue and will continue to evaluate projects as they come in based on need and criticality, I guess, of repairs and upgrades, and will be available to support future projects in the Passamaquoddy Water District at Pleasant Point, wherever they need to occur. But our funding does have to go through a regulated public water system. To address the second part of your question, so the water quality at any point, again, to get back to what I said earlier, managing water quality throughout a distribution system is a complex process. Mr. McCluskey mentioned there are some bleeders installed in the town of Eastport, which is used a lot for large water systems or where there is a long transmission line where that water can, if it's not being used fast enough, can basically stay in the pipes longer than we would like. And so that bleeding process just basically releases some water all the time so that the water doesn't sit in the overall distribution system too long. That may be helping to lessen the some of the water quality issues that seem to be more prominent in Pleasant Point. I don't know that for sure. I also don't know the specific age or condition of the pipes in different parts of the system. There may be some upgrades that could occur within Pleasant Point to the piping or the storage tanks that would, or installation of a bleeder that could help improve the age issue. I do believe, however, that the real origin of the problem is with the source itself, as has been mentioned many times, and the challenges was managing that water quality because it's not stable. It changes a lot according to weather conditions and everything else. So anything we can do to improve the water quality that's basically coming out of the treatment plant into the system is going to probably have the biggest impact. I hope I came close to answering your questions.
Thank you, Michael. I think you did. Representative Newell, if it's okay with you, I'm going to move on to a question from Representative Libby, and then I feel that we need to table this bill and pick up our work session at another date. Representative Libby, go ahead.
Thank you, Mr. Abbott. Thank you, Madam Chair. Thank you for being here today, Mr. Abbott. I found a lot that you had to say very helpful. If this bill passes as amended, does the state maintain any oversight of feasibility testing as it is written now? Or would the state not have oversight of feasibility testing on tribal land?
Okay, thank you for your question, Representative. I think just to make sure I'm clear about before I answer. So feasibility testing, I think I was referring to feasibility studies, which is really looking at, what are all the options available to the water district to improve water quality. But I think you might be, when you say feasibility study, also referring to like
let me clarify.
Okay, yeah.
Let me clarify. So, because I'm coming at this from not understanding water like you do.
That's fine.
So it seems like the source of a lot of this, I'm delicate here, maybe a little bit of conflict or disagreement on both sides, is stemming from the feasibility testing that was done in 2013 that extracted a large volume of water over a short period of time and did, in fact, harm a number of wells, some irreparably. So my question would be, it seems like from what you've said that currently the state has oversight over those types of feasibility studies, testing, whatever that's worded. And I'm not sure that they had any oversight over what was done in 2013, but would we, as the bill is currently written and amended, would the state have any oversight moving forward over any of this similar feasibility testing on tribal land in Maine?
Okay. Okay. Well, that does get into some a bunch of interesting legal and regulatory issues, but let me do my best to answer that. So we did and would continue to have oversight on the new well approval process for any well that was being put in to serve a public water system. And, again, our requirements are about making sure the water quality is acceptable, and also part of the we usually refer to it as pump testing, which actually, when I think about it, is not a more useful term than feasibility testing. So I don't know, but the pump test is after you've drilled a well and found that, oh, good, we drilled a well and we've got some water, and the water looks like it's good quality. Let's pump it to see, will it hold up at however many gallons a minute? And so will it actually be a usable source for us? Will it be enough to use as a water supply? And will the water quality hold up over several days of testing? So that process is used for that. We don't, to back up a little, any property owner has the right to drill a well and use the water to, under Maine state law, I think it's a beneficial use on their property. However, they are also responsible if they create harm to other neighboring properties' water supply, which, I think was the case here, that the steps were taken very quickly to correct the effects on the other wells. So in the case of that pump test, I believe, one technique that's often used is to pump a new well at pretty high rate to see if it will hold up. And part of determining if it's sustainable is will the well itself could be able to continue pumping for several days, and what happens, outward from that well. And if it does have undue impacts on other wells in the area, that's an indication that probably a lower pumping rate would need to be evaluated to see if that well could be used without having adverse impacts. So, I think it was unfortunate in this case that the initial testing created impacts and kind of, led to the everything we've talked about, the moratorium and the inability to continue evaluating those wells. But to answer your question in more general, any future well exploration, whether it's by the water district or by the tribe, to create a well for public water supply use would be subject to we would have that same oversight in ensuring that the water quality is safe to drink, and safe to use, and that it could be used in a sustainable manner before allowing it to be put online as a public water source.
Whether on tribal land or not.
Right. If it's going to be used in a public water system, right.
Okay. Thank you.
Thank you for your questions. And Michael Abbott, thank you so much for being here today, listening so attentively and providing us with the answers to our questions. And we are going to send you back to the attendee part of the meeting, and we may have some follow-up questions for you. We would reach out to you later.
Sure, anytime. Thank you.
Thank you. So committee members, at this point, I want to talk a little bit about where we're headed. I would like to have a motion to table the work session on 906 and let us take up some of our other bills and reopen this work session in the future. Senator Sanborn?
Thank you, Senator Carney. I move to table.
Is there a second? Seconded by Representative Evangelos. And committee members, let's initially do this with a show of hands. And if we need to take a roll call, we can definitely do that. But if you're in favor of the motion to table, please use your actual physical hand and hold it up to the screen. It looks like it is unanimous among those who are present in the meeting at the moment. And so 906 is now tabled. We are going to open our work session on our next bill, and that is LD 1907. And Representative Hagan?
Yes, thank you, Madam Chair. I was under the understanding we were going to take a few minutes a break.
Yeah, thank you for that reminder. I was too anxious to plow ahead. let's go into recess until 2:05, please.
You aren't there by chance, are you?
I'm here, Chris.
Hi, Soupy, did the chair announce that we're staying on schedule as far as what the next bill is?
We just tabled LD 906 and
Right.
I believe they're talking about that right now.
Oh, they're still on 906.
No, we just tabled it.
But had they announced what we're doing after the 5-minute break?
I think I see Tom coming
1907.
on.
1907.
Okay, thank you. We're staying on. Thank you then. Yeah.
Yep.
Hi, committee members. Sorry, I was holding everybody up. I apologize for the delay. I would like to just briefly go over where I would like us to go today and ask for the committee's feedback and hopefully agreement with that. The next bill on our schedule is LD 1907. It's Representative Collings' resolve about reviewing state lands and waterways that have sacred, traditional, or other significance to the Wabanaki tribes. And what I would suggest is that we ask Peggy to provide us with the bill analysis, and we can ask questions of Peggy. But since we had previously decided that we weren't going to vote on bills today, and because both LD 1626 and LD 585 may have implications for 1907, I would ask that we perhaps hear the bill analysis, ask any questions we have of Peggy, and then table that, because I think we'll be able to talk about the policies underlying 1907 a little better after we talk further about 1626 and 585. So committee members, is that okay with people? Maybe I'll ask the question in a reverse way. If somebody is not in agreement with that plan, could you just raise your hand and let me know? Because I want to be sensitive to the needs of the committee, but also do our work in a way that maybe works out well for us as a committee. Okay, it looks like everybody is okay with that plan. And so with that, I'll open the work session on LD 1907, an act to review state lands and waterways that have sacred, traditional, or other significance to the Wabanaki tribes. And I'm going to bring the bill sponsor. I'll ask Soupy if she could bring the bill sponsor, Representative Collings, onto the panel, which is a courtesy that we give to our bill sponsors. And then Peggy, if you could take us through the bill analysis, we'd appreciate that.
I would be happy to. Thank you very much. So LD 1907 is an emergency. It would create a new commission, a commission to review state-owned lands and waterways. That would be an ongoing permanent commission, kind of housed within the Bureau of Public Lands. Is that what it's called? Parks and Lands. And it would consist of several members, one member representing Parks and Lands, and then people representing the Department of Inland Fisheries and Wildlife, Marine Resources, members representing the Passamaquoddy tribe, the Penobscot Nation, the Holton Band of Maliseet Indians, and the Aroostook Band of Micmacs. The duties of the commission would be to look at state-owned lands and waterways that have sacred, traditional, or other significance to the tribes here in Maine, to examine the processes that are used elsewhere, either under federal law or other states or other jurisdictions, to return lands to tribes, and also look at the funding sources that would allow that to happen, and then to make recommendations to the legislature with regard to the transfer of lands. They wouldn't actually have any authority to take action, but they could make recommendations to the legislature. The legislature would receive those recommendations. The Inland Fisheries and Wildlife Committee, the Marine Resources Committee, the Agriculture, Conservation, and Forestry Committee, and each of those committees would have the ability to report out legislation. The commission would be able to hold public meetings, public hearings throughout the state. And I just wanted to touch base on a couple of things that were brought up in the testimony. One is the governor's office opposes it because they believe that there is a sufficient process for this now, and pointed to a couple of bills, one that had already passed last year and one that is in the process this year. And Maine Indian Tribal State Commission, not testifying against, neither for nor against, identified themselves as a resource at the Maine Indian Tribal State Commission. It was established under the Implementing Act to provide kind of a resource for the state and the tribes to explore different ways to improve the relationships between the state and the tribes. And so that's something to think about with regard to changing this or going forward with this bill. I had some questions about whether there was any kind of logistical support that was going to be provided. The freedom of access law, this is just an aside, would apply to this commission. So all their meetings and, you know, all their records would be public. And I asked if this is an activity that the Maine Indian Tribal State Commission can perform or participate in or assist with. And the Maine Implementing Act does require review by MITSEC before lands are added to the Passamaquoddy Indian Territory or the Penobscot Indian Territory. We don't have fiscal information yet. I'd be happy to answer any questions.
Thank you. Committee members, are there questions? I see a couple. Representative Harnett, your hand was up first.
Thank you very much, Madam Chair. Thank you, Peggy, for your bill analysis and for the overview. I want to ask you a question, or I think it's a question, but regarding the Freedom of Access Act, we heard testimony about concerns that identifying sacred properties or properties that were deemed sacred to our First Nations could lead to possible damage, vandalism, or other bad things happening. And, you know, I understood that concern, and I think it's valid given the experience around the country. But unless there were exceptions created, the Freedom of Access Act would prohibit any of those discussions being shielded from public view. Am I accurate in that regard?
I believe you are accurate. And kind of something related to that maybe is the information about some trails is there's an exception in the Freedom of Access law that allows some publicly available trails, some information about those to not be public records, or I mean, I think you would need an additional language to make that information confidential. But
Okay.
I think that's your question.
Right, but the statute as drafted would not allow for that.
No.
Thank you.
Representative Thorne, go ahead.
Thank you, Madam Chair. And Peggy, I've read the preamble a few times, and this is just, again, to help out a poor freshman that can't understand. I'm trying to figure out the aspect around this bill that constitutes an emergency. Is it something you can help me understand? I didn't really see if I saw what the emergency clause consisted of.
I think the idea is to put this in place in time to make recommendations by November 15th to the upcoming legislature. So if this is not an emergency and you adjourn mid-April, 90 days, May, June, July, mid-July. So I think the sponsor was saying that's not enough time for them to go through the process, at least for the first year, to identify lands and hold meetings, hold public hearings, get input, and then draft up the recommendations.
Okay, so either way, we hand it off to the 131st. This just gets started.
Yes, that's my understanding, that that would be an ongoing obligation to report by November 15th, and whichever legislature is in session then would take those recommendations and go forward. You're right, if they submitted them in November of this year, they would actually have to go to the 131st unless you have a special session after November 15th and before December 3rd or whatever.
Okay. Thank you. Thank you, Madam Chair.
Representative Babbage?
Yes, thank you, Madam Chair. I just wanted to check with Peggy. MITSEC is currently subject to FOA. Is that right?
I don't know that that is true.
Thank you. That's
I don't know of an exception, but I'm not sure that MITSIC would say that they are subject to FOA. I guess I would say they probably are subject to FOA since the law court has said the tribes are subject to FOA. So I guess there wouldn't be any reason for MITSIC not to be subject to FOA.
Thank you. Committee members, any additional questions for Peggy? Is there any information we'd like Peggy to follow up on before we table this legislation? Representative Newell?
Thank you, Madam Chair. Maybe I misunderstood, but this is just bill analysis with no additional questions from anyone in the audience, and then a table. Is that correct, Madam Chair?
Yeah, I had suggested that because, and I don't, this is a very important bill, and I don't mean to rush it. I thought it was really important for us to receive the bill analysis and ask questions of Peggy. I think that as we continue to go through our other public hearings, I mean, our work sessions today, that it may help inform our discussion of 1907, and that we could then come back for another work session and a more robust discussion of 1907 prior to voting on it.
Okay, thank you, Madam Chair.
Yeah, and I'm sorry that I didn't clearly convey that. I thought that I had, but appreciate your raising the concern. Representative Reckitt?
Did I hear you say that the contention is that there's a subset of state government that is now in charge of this sort of thing? Did you say that?
Is that a question for Peggy?
Yes, yeah.
I maybe what I said was it would be, as it's written, it's kind of housed within the Bureau of Parks and Lands. Is that what you're thinking?
Well, I was thinking that you said something, or maybe you were reporting about the governor saying it's already being done or something like that.
So the governor's testimony, Jerry Reed's testimony, was the only opposition testimony that was filed. And their thought is that this is already happening, that you don't need a commission to do this, to identify these lands, that they will be identified. And there was a bill last year that transferred land to the Passamaquoddy tribe, and there's another bill pending.
All right, thank you. That's what I just wanted to understand. Thank you.
So Peggy, can I clarify, was his testimony that there is some entity that's responsible for this type of process, or just that there has been activity related to returning lands?
Right. Well, thank you for asking that. Really 2 points. One, there has been activity returning lands. And the other is that you have bills still in front of you that establish a consultation process. And I think the governor's office's thought is that that consultation process would also cover these issues, and that you wouldn't want to shortchange that consultation process with the state and the tribes.
Committee members, any additional questions for Peggy? I did have one other thing, Peggy. Could you please do a slightly deeper dive into whether MITSIC is subject to the Freedom of Access Act?
Sure. I wasn't really thinking about it, and because kind of an intergovernmental, they are an intergovernmental entity that has tribal members on it and state members on it. Usually we think of the freedom of access law applying to anybody who gets any kind of funding, a certain amount of funding from the state. They're established by statute. They probably fall into that category. But the only, kind of idea saying that maybe they aren't covered is that because half of the members are members of the three federally recognized tribes, and are they subject to the Freedom of Access Act? And then, oh, that's right, there was a law court decision that said the Freedom of Access Act does apply to the tribes when they're acting in their governmental authority. So that would, I think it probably would make sense to consider MITSIC as being covered by the Freedom of Access Act, if only to make sure that if there were things that were important for them to be able to discuss and not disclose, such as locations of sacred lands so they wouldn't be desecrated, then I think you do need to write that into the statute someplace, whether it's MITSIC's statute or you put it in the Freedom of Access Act as an exception.
Thank you.
That would make it very certain that they wouldn't have to disclose that information, regardless of whether everybody agrees or not that they're covered by the Freedom of Access Act.
Okay, thanks. That's very helpful. Representative Newell?
Thank you, Madam Chair. Not to delay this any further, but just a quick question to Peggy, as she mentions the consultation process, if I heard that correctly. Is that relating to the proposed legislation of LD 585?
Exactly.
Okay, so then, okay.
And the governor, and the testimony is that the governor supports that, actually the amendment to 585, including the consultation process.
Okay, all right. Thank you, Peggy.
Representative Babbage?
Thanks. I just wanted to ask, given the line of commenting here that we've gone through, I know that the identification of sacred lands and establishing a process by which they'd be evaluated and perhaps returned to the tribes is a national initiative. And I wondered if, well, two questions, I guess. One is it forthright and simple like this, or is there something we can learn from other states? And then secondly, the forward consideration that we just mentioned, I'm trying to balance weighing the return of lands with the public's right to know regarding what we consider before us. I assume at some point the identification of these places will become public knowledge to be discussed. Is that right? Is that how it's handled?
It would have to be, if it's going to be covered by legislation, to actually transfer ownership away from the state. So at that point, they would be completely public and identified.
Okay. Thank you.
Yeah, thank you for those questions, Representative Babbage. And I think that this is maybe a good place to pause on 1907, because there are, I too took to heart the concerns about desecration if land is mentioned as being a sacred place. And I think that that's something that we need to carefully address. And we do have the Freedom of Access Act concerns that we're not, that we just need to spend some more time thinking about, actually. And so with that, I would ask for a motion to table LD 1907. moved by Representative Babbage, seconded by Representative Harnett. Is your Representative Harnett, is your hand up for a question or to second? The second, okay. All right, and again, committee members, if you are can vote with your actual physical hand, and if we need to do a roll call, of course we will. But for those who are in favor of the tabling motion, please use your actual physical hand. Okay, it looks like we've got just everybody stay in one place. Awesome, counts us.
I get 11.
Okay, I do as well. Thank you, committee members. And Representative Collins, we really appreciate you bringing this legislation forward, and thank you for your patience today and for joining us. And we will be rescheduling 1907 for a second work session and a vote in the future, and we'll let you know when that is, of course.
Thank you.
Thank you. Okay, committee members, our next work session is going to be on 1626. And before we officially open up that work session, a couple of things. Just want to say hello to our analyst, Janet Stocco, who has joined us. And committee members, I'm a little concerned that 1626 is going to take us quite a bit of time. I don't know whether we feel comfortable right now agreeing that we're going to have to reschedule 585. I would love to get a sense from the committee if committee members feel that that we are going to need to spend more than, say, 3 or 4 hours on 1626. Senator Sanborn?
I don't have a good sense of how long 1626 will take. I was extremely surprised by how long this morning / this afternoon's bill took on the water district. But I just wanted to let the committee know that I have to leave at 3:45 for a memorial service. So that's my parameter. And so I certainly would hope that we would be able to, I would love to be able to participate in 585 if that was possible.
Committee members, does anybody feel like we're going to zoom through 1626 in the next 3 hours? No. All right. Then I think what we'll do is we will reschedule 585 for the next possible opportunity. And with apologies for all who waited in the waiting room for a significant part of the day, we appreciate you being here. And again, it's hard to predict our how long work sessions will take. Before we do move on to 1626, I know that Representative Evangelos had a request with regard to the bill that he's the primary sponsor of. I'm not sure if that's why your hand is up, Representative, but 1568. And did you wish to address us on LD 1568, Representative?
Well, I was going to get around to it. Yes, so I was just going to say, I do have a good feeling of how long 1626 will take. I'll leave it at that, but it's going to take an extended period of time. Yeah, if we've actually are on the 1 o'clock work session as well, if I would be recognized to speak. You may remember last year when we heard 1626 and 1568 were on the same day, but we did very, very limited hearing and carried things over. I had indicated at that time that because 1568 and 1626 were highly identical, that I didn't want to hold dual hearings, and I gave my word I couldn't withdraw the bill. So if I'm in order, I'm going to make a motion ought not to pass on 1568. We can actually cross one off our list today.
I'm going to ask you to hold off on your motion because we need to officially open up the work session on 1568. And so let me do that, and then we'll take your motion.
Yeah,
and so,
smiling.
So we are going to open up our work session on LD 1568. an act to implement the recommendations of the task force on changes to the Maine Indian Claims Settlement Implementing Act, sponsored by Representative Evangelos. And Representative Evangelos, you are recognized.
Madam Chair, I move ought not to pass. I've already stated the reasons.
Thank you. And Representative Harnett, is that your second? Okay. So we have a ought not to pass motion by the bill sponsor and a second by Representative Harnett. Any discussion on the motion? Okay, I am not seeing any, and this will be a roll call vote. And our committee clerk, Susan Panett, has magically appeared on the screen, and you can proceed with the vote, please.
Very much, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Keim. Senator Keim is absent. Representative Moriarty. Representative Moriarty is absent. Madam Chair, I have 12 members voting in the affirmative, 0 in the negative, and 2 members are absent. That is the vote of the committee.
Thank you very much. And so the ought not to pass motion carries 12-0 with 2 absences. And with that, we will close the work session on LD 1568. And thank you, Representative Evangelos, for bringing the matter forward.
You're welcome.
Okay, committee members, and now it is time to move on to the work session on LD 1622. This is an act implementing the recommendations of the task force on changes to the Maine Indian Claims Settlement Implementing Act, sponsored by Representative Talbot Ross, and committee analyst Janet Stocco is here to take us through the bill analysis. And Representative Thorne, did you wish to be recognized?
Just for the record, Madam Chair, you did say 1622.
Oh,
and it's
excuse me.
1626.
Thank you. I sometimes get my numbers mixed up.
That's what we're here for.
We're opening the work session on LD 1626. Does anybody need any additional clarification on that? I think we're all set. And Janet, we'd love to hear your bill analysis. Thank you.
Okay, I'm sorry that it's so long, but it's a very complicated bill, and I wanted to give you as much information as I could. So I hope that's okay. So the bill implements many of the recommendations of the task force on changes to the Maine Indian Claims Settlement Implementing Act. That report was issued in January of 2020 after several meetings in 2019 over the summer and fall. And when I talk about the current laws, I'll be talking about the Maine Indian Claims Settlement Act, which was passed by Congress, which I'll refer to as the Federal Settlement Act, and that actually ratified Maine's own act to implement the Maine Indian Claims Settlement, which is commonly referred to as the Maine Implementing Act. I know that that sounds funny, that the Maine Act was to implement the Indian Land Claims Settlement, and the Federal Act is actually what ratified it. But I did staff that task force, so I finally learned how that worked, that the Maine law passed first, And then the federal government had to ratify that act. So for that reason, the both of those acts have an effective date of October 10th, 1980, which was when the federal act became effective because it was necessary to make the Maine law effective. And I did want to say that ordinarily in a bill summary, we'd just put the summary there and not talk about other things, but there are so many different sections of this bill that I thought sticking different concerns that were raised by the Attorney General's office or by the tribal attorneys whose proposed amendment was sponsored by Representative Talbot Ross, I thought sticking them all at the end would be a disservice to you. But I didn't want anybody to think that I was taking any positions by putting those concerns throughout. I just thought it would be helpful to you, and that was the only reason I made that choice. So I did want to point out that the bill does not address the relationship between the state and the Micmac Nation, which was formerly known as the Aroostook Band of Micmacs. That issue was specifically set aside by the task force. There is one provision of the bill about consultation, I believe, which we'll get to, which does include that tribe, but otherwise, this bill primarily and almost exclusively involves the relationship between the state and the Passamaquoddy tribe, the Penobscot Nation, and the Holton Band of Maliseet Indians. And the general overall goal of the bill, the way it's written, is to declare that within the Maine Implementing Act, that these Wabanaki nations, and I use the phrase affected Wabanaki nations throughout the bill summary just to describe those three tribes, that they enjoy all the rights, privileges, powers, duties, and immunities of other federally recognized Indian tribes within the United States. So the first thing that the bill does is put that purpose right in front in the legislative findings and declaration of policy section of the Maine Implementing Act. And if you look, the tribal attorneys have one theme you'll see throughout the summary is that there is some dispute over the validity of several provisions of the Maine Implementing Act, and they involve the Holton Band of Maliseet Indians. So there was a law passed, it's the Public Law 1981, Chapter 675. It was passed by the Maine legislature. So it is enacted, and so those provisions were enacted, but it had a contingency clause that certain things had to happen at the federal level. And the band takes the position that those things did not happen. None of that affects the fact that this bill could be passed. If you wanted to pass this bill, you don't have to resolve the dispute about whether the 1981 law ever took effect. I don't mean to suggest that that's really an issue for 1626, but I did want you to understand, if you look at the tribal attorney's proposed amendment, it does a lot of things about saying repealing and replacing and changing some of the introductory language to different sections of the bill. And it's my understanding from speaking to the attorney for the Holton Band of Maliseet Indians that the reason it does that is if you just repeal and replace those provisions, then you never have to address whether they were ever effective in the first place. You would just repeal what was enacted and just put in as new law, whatever it is that you're all agreeing going forward as a legislature, those provisions should say. So you'll see that concern throughout, and it's just to explain my understanding of why the proposed amendment changes some of that prefatory language in those sections of the bill.
Janet, could I'm sorry to interrupt you. I just
No,
had
go ahead.
one point that I wanted to mention, 2 points actually, and a question for you. First of all, the bill sponsor's not available. She has to be in a different committee right now. And then secondly, because I think everybody on this screen knows this, but members of the public who are watching or listening in might not know this, but OPLA staff are a nonpartisan staff of the legislature. And Janet, as the OPLA analyst, is also a nonpartisan staff member. And so I wanted those who were not familiar with that to be aware of that. And then finally, Janet, would you like us to interrupt you with questions? Would you like to pause after every couple of sections? What would be easiest for you?
I don't mind being interrupted. It is a lot of material, and there may just simply be questions that I don't know how to answer. I know there are many folks still in the attendee room who may be able to answer them better than I. I have studied and studied and studied this bill, but I do have limits to my knowledge of the intricacies of federal Indian law, and I don't want to pretend to you to know more than I do.
Thank you. So committee members, if you have a question for Janet, please raise your hand and she will endeavor to answer it. If it is a question that someone who's in the attendee part of the meeting will answer, then I would just ask you to make a note of it so that we can hear from Janet with regard to the bill analysis, and then we'll go back and bring in persons from the attendee space. Senator Sanborn?
Janet, I'm reading through your bill analysis. I'm sometimes a little confused when you say the proposed amendment, whether you mean the proposed changes that are proposed by the bill that would amend the main implementing act, or whether you mean that there's an amendment to the bill that we had before us, or to the amended version of the bill we had before us that's being proposed, but that hasn't been presented to us yet as an amendment, but is being proposed as a proposed amendment by the tribal attorneys. So I hope that I'm sorry if I made that more complicated than it needed to be, but the word amendment is used throughout your bill analysis, I think, to mean 3 different things potentially. And so I'm hoping you can just highlight for us where what you mean is an amendment that is being suggested by the tribal attorneys, but hasn't been incorporated into a draft, versus where you're talking about the most current draft of the bill language itself or something like that. I don't know if I made that worse than it was before.
No, I understand, and it is a very good point. I couldn't think of a synonym for amendment. So anywhere it talks about current law, obviously that's what that is. There's a lot of charts, and so the current law is current law. And then usually, maybe even all the time, the middle column is LD 1626. So I talk about how that bill as written right now would amend current law. And then the tribal attorneys do have a proposed amendment. It was sponsored by the bill sponsor. That's the only amendment I know about. And so I tried to identify if it's the tribal attorney's proposed amendment, there should be a heading on top. I try to put that heading every time, but if we get to a place and I didn't, we'll point it out so everybody can immediately mark it right on their paper so that we can be clear. And I am sorry, I do agree that that is confusing, but just so everyone knows, we have a bunch of other bills that I happen to be staffing that the hearing that was most recently had was on a proposed amendment. The hearing you had on 1626 was on the bill as written. And so we're starting with that slate. And then since that hearing, the tribal attorneys have proposed an amendment that is sponsored by the bill sponsor. And that is discussed here so that you know what their proposal is to the extent I understand it, because I had to review it as, you know, everybody else did within the last couple of days. But you did, unlike some of the other tribal bills, you had the hearing on the bill itself. So are we ready for the next topic?
Yeah, and thank you so much, Janet. And I just wanted to also thank you for the voluminous materials you prepared to help us understand all of the legislation today.
You're welcome. I do not lack for verbosity. I can speak and speak and speak. So I do want to point out, this is going to become clearer later in the bill analysis, but the general statement, the idea behind 1626, as discussed in that topic too, is to apply federal Indian law and all the rights and powers and immunities and duties that the other federally recognized Indian tribes have across the country to the 3 affected Wabanaki nations that are mentioned in the bill. There is a concern raised by the Attorney General in his testimony that it may be more difficult to apply those rights and immunities and all of federal Indian law to the Halton Band and Maliseet Indians than it is to the Passamaquoddy tribe and the Penobscot Nation. And we'll get to that in a minute, but I did just want to point it out because it does affect that overall purpose part of the bill. But we'll talk about it more in a minute. Another thing that the overall purpose part of the bill talks about is reservation of treaty rights. So the bill adds language to the legislative findings and declaration of policy provision of the implementing act, which indicates that the negotiated settlement of the land claims in the 1970s affirmed, quote, the reservation of rights embodied within the specific treaties that gave rise to the claims at issue, end quote. The bill also references reserved treaty rights as a limitation of the state's authority to regulate tribal members' fishing, hunting, trapping, and other taking of wildlife off of tribal lands in a new provision of the bill that's quoted there, or cited there, excuse me. So the Attorney General had a concern about the reservation of treaty rights provision in the purpose clause, and then later on in the fishing and hunting provision of the bill. And the Attorney General's concern was that there might be some ambiguity and a potential for litigation by including references to reserved treaty rights, because it's the Attorney General's position that in Section 12 of the Federal Settlement Act, the state was discharged by Congress, and all of its political subdivisions, were discharged from any claims arising from any treaty or agreement with, on, or behalf of any Indian nation or tribe or band of Indians in Maine. So that, in the Attorney General's opinion, the reference to reserved treaty rights is at best confusing and is at worst, I think we would say it would just be inaccurate. But that is out there as an issue. The next topic, as I broke it down, at least the way I understood it in my mind, would be the applicability of this phrase that's newly defined through LD 1626 of federal Indian law, and the inapplicability of state laws to the three effective Wabanaki nations unless authorized specifically in the Maine Implementing Act, or state laws might apply if it's specifically authorized by federal Indian law. So as the bill is written, except as otherwise specified in the Implementing Act as it would be amended by 1626, federal Indian law applies with regards to the rights, privileges, powers, duties, and immunities of the affected Wabanaki nations. Current law, by contrast, provides the state with significant authority over Indian affairs in Maine. The bill defines federal Indian law as the United States Constitution and all generally applicable federal statutes, regulations, and case law, and subsequent amendments thereto, or judicial interpretations thereof, relating to the rights, privileges, duties, powers, and immunities of federally recognized Indian tribes within the United States. So this definition, as it's written, explicitly recognizes that federal Indian law is not static, but evolves as federal laws are passed and amended, and as federal courts interpret the relevant statutes and regulations and their application to federally recognized Indian tribes, nations, bands, and other groups. So if you look at the chart that's on page 3 of the bill analysis, and for anyone listening, the bill analysis is posted on the electronic committee file if people wanted to follow along. I'm happy to share my screen, but it's a wide bill analysis and the text might be really small, but we can do that if you want me to at some point. I cannot hear you, sorry.
I know, I was muted. I'd muted myself. I think this chart is such a helpful kind of snapshot of a very important issue that's kind of fundamental to understanding the bill. Could you just, I'm not going to ask you to share every page, but I think if you could please share the chart on page 3, I think that would be really helpful.
Certainly.
Thank you.
Sure. So as I mentioned before, most of the charts in the bill analysis, the left-hand side is the current law and the middle is the bill as written. Actually, all of the charts are like that. And then on the right-hand side, I generally list Attorney General's concerns, although in the taxation provision, because a lot of amendments were proposed, it made more sense to list those there. But that's the general setup of the bill analysis. And then anytime I use this type of indicator, this triangle that's filled in, that refers to an Attorney General concern. And then there's, I'm just going to scroll up for a second so people understand the way the bill analysis works. If you see this sort of 4 diamonds indicator, that's to try and signal to you it's a tribal attorney proposed amendment. And if it's a regular old thing, that's me talking to you. If it's a regular old, I know some people don't like the term bullet point, so I'm trying to avoid saying it, but I can't think of another word right now. So currently, under the Maine Implementing Act, it says that state law applies to all federally recognized Indian tribes, tribal members, and tribal lands and natural resources in the state, except as otherwise specified clearly within the Maine Implementing Act. And that's section 6204 of the Maine Implementing Act. If you look also at the Federal Settlement Act, in section 6E1, Congress gave advance consent to the state and to the Penobscot Nation and the Passamaquoddy tribe to agree with the state to amend the Maine Implementing Act regarding several matters, including the application or enforcement of civil, criminal, or regulatory laws of the state or the tribe's laws within their respective jurisdictions. So that's advance consent by Congress to an amendment to the Maine Implementing Act to change those, the application and enforcement of state versus tribal law for those two tribes. Also advance consent for the allocation of state and tribal government responsibility, which may be concurrent. It specifically mentions in the Settlement Act over specified subject matters or geographic areas. And there's advance consent for the amendments to the Maine Implementing Act regarding the allocation of state and tribal court jurisdiction. There's a slightly different language applying to the Houlton Band and Maliseet Indians and the advance consent Congress gave to the state and to that band as far as changes to the relationship between the state and the band. And so in section 6E2 of the Settlement Act, Congress authorized the state and the Houlton Band and Maliseet Indians to execute agreements regarding state jurisdiction over lands owned by or held in trust for the benefit of the band or its members. So when Congress ratified the Maine Implementing Act, it provided, as it does today, that state law applies to all of the Indian tribes and their territories and their tribal members unless otherwise specified in the Implementing Act. But Congress did understand that that might change and so gave advanced consent to certain changes being made. Now, if you look under the bill, it repeals that 6204 provision, which makes state law generally applicable, and it enacts a new provision providing that the state and the effective Wabanaki nations agree under the Federal Settlement Act that the laws of the state do not apply to those affected Wabanaki nations and their members and lands, except as otherwise provided in the Implementing Act or federal Indian law. So it's the reverse idea. Under current law, state laws applies unless it says otherwise. Under the bill, state laws would not apply unless there's some specific statement otherwise. And just to give you examples, what would that mean? Where would that allow state law to apply? So under the Maine Implementing Act, even as amended by 1626, state criminal laws would still apply as far as defining crimes that occur on tribal territories. In addition, under federal Indian law, there are examples of when state law would apply to tribes and tribal members. And so there are some provisions of federal Indian law, that body of law, about income tax, for example, state income tax could still apply to a tribal member if they earn income off of tribal land, or even if they earn income on tribal land if they're not a resident of tribal land. So there are specific examples of where state law would still apply, but the default would be that it doesn't. In addition, the bill enacts a new provision right in the purposes clause that provides that the state and the affected Wabanaki nations agree under the Federal Settlement Act to adopt the application of federal Indian law regarding the rights, privileges, powers, duties, and immunities of the affected Wabanaki nations. And it enacts that definition of federal Indian law that I summarized for you before, because that came right out of the bill summary text, but it's quoted here. So it's the different laws and constitutional provisions and the judicial interpretations of them. So there are both the tribal attorneys and the Attorney General had some comments on these provisions. So the Attorney General expressed concern that while it is clear under 6E1 of the Federal Settlement Act that Congress gave advance consent to amendments to the Implementing Act, which, as the Attorney General testified in written testimony, would probably cover almost every change that's in this bill, as long as it involves the Passamaquoddy tribe and the Penobscot Nation. In 6E2, while Congress gave advance consent to the band the Holton Band of Maliseet Indians and the state entering agreements over jurisdiction, it didn't specifically provide that there could be amendments to the Maine Implementing Act. So that was just a concern raised. The tribal attorney's proposed amendments would change a little bit the provisions that we just talked about. So in 62022, which is in the purposes clause, it would clarify that they want under the bill, federal Indian law would apply not just to the rights of the nations as nations themselves, but also their tribal members and land or other natural resources. In addition, the definition of federal Indian law would be slightly tweaked to include common law, and also to clarify that the case law that's being referenced in that definition of federal Indian law includes case law interpreting, implementing, applying, or enforcing federal laws or regulations. There's also in the tribal attorney's proposed amendment a provision that I must admit I do not entirely understand what the purpose is of that provision, so I would defer questions on that to the tribal attorneys, but it does rewrite 6216, which is the provision of the bill, which provides that state laws generally don't apply, and that it also affects the next topic here, subtopic 5, which is about specific federal laws and regulations that have been enacted applying in Maine. So I can't really comment on this amendment. I wanted you to know it was there, but I'm not entirely sure of the purpose for it. I'm sure there is a clear purpose. I'm just not entirely sure of what it is.
So committee
I was
members.
just pausing, sorry, to see if you
Okay.
had questions on the chart.
Yeah, and I was just going to prompt committee members if anyone had a question on the chart, or Janet has covered sections 1 through 4, and wondering if there are any questions on sections 1 through 4. I'm not seeing any hands up, Janet, and I think probably it makes sense to end the screen share right now. That was a particularly helpful chart, and it was great to have the visual as well as hearing you explain it. Thank you.
So the next topic is about the applicability of specific federal laws. So these are laws passed by Congress. We're not talking about some other type of federal law like court cases. The next topic is specifically federal statutes and then regulations implementing those statutes and how they would apply in Maine if those laws and regulations are for the benefit of Indians. Excuse me. So under current law, which is in the left-hand side of the chart, and we're talking here about the Federal Settlement Act itself, there's a provision, section 6H, that states that any federal law or regulation predating the act, so this is before October 10th, 1980, that affords special status or rights to any Indian tribe, Indian lands, or land held in trust for Indians, and that, quote, affects or preempts the civil, criminal, or regulatory jurisdiction of the state, and it specifically includes laws relating to land use or environmental matters, does not apply in Maine unless specifically stated in the Federal Settlement Act. So that's the general rule for any laws that were already on the books prior to the enactment of the Federal Settlement Act in 1980. There's a second section that's important here as far as looking at federal laws for the benefit of Indians, and that's section 16B of the Federal Settlement Act. And it provides that any federal law for the benefit of Indians or Indian tribes enacted after October 10th, 1980, and which would affect or preempt the application of the laws of the state of Maine, does not apply within the state unless the federal law is specifically made applicable within the state of Maine. So what does that mean? It's my understanding that what that means is when Congress passes a new law, for example, if they passed a federal law called Recognition of Janet Stokoe on November 1st forevermore, and it only applied to Indian lands, if that law did not say, and it specifically applies in Maine, the idea is that it wouldn't apply in Maine. At least that's how courts have interpreted it so far. Obviously, every court case is different, every fact pattern is different, but that is the general rule. And I'm fine with you supporting the enactment of such a federal law. So under the bill, under the purposes clause 62022, the state and the affected Wabanaki nations would be memorializing an agreement under the Federal Settlement Act that federal laws and regulations for the benefit of Indians and Indian tribes, or that afford a special status to any Indian tribe or lands, I said it twice, applies to the affected Wabanaki nations unless otherwise stated in the main implementing act. So again, this is flipping, it's not a presumption, but you can think of it that way, it's flipping the idea. So under current law, it doesn't apply unless we say so specifically. And under the bill, it would say it does apply unless we say it doesn't specifically. And this would be as a matter of state law. There's similar language in 6206, subsection 1 of the bill. And then if you look at 6216, which is towards the end of the bill, that section, so the first one I just read to you is sort of the purposes clause, but then 6216 sort of gives you the meat of it. And it says that because state law does not apply and so cannot be affected or preempted, because remember, we talked about that earlier on, the general presumption is going to be now that state laws don't apply to the tribes unless otherwise specifically provided. So because that state law is not applying, it can't be affected or preempted. So federal laws and regulations that you would think of otherwise as not applying under the Settlement Act would in fact apply to the affected Wabanaki nations, their members, and lands in Maine, with 2 exceptions that are specified in the bill. And the first would be criminal laws. So any federal laws that would conflict with the jurisdiction over crimes and juvenile crimes that's specifically described in the Maine Implementing Act, and we are going to get to that later, those wouldn't apply in Maine. And the Indian Gaming Regulatory Act and its implementing regulations would not apply in Maine. The Attorney General raised the same concern related before throughout the bill about the concern about whether this kind of change can be made to the implementing act for the Halton Band and Maliseet Indians. In addition, the Attorney General raised the concern generally of whether the bill could effectively make Section 6H and Section 16B of the Federal Settlement Act nullities by just effectively making them not purposeful. And to the extent that a court says that you can't do that as a matter of state law, just render those 2 provisions of the federal law inapplicable, then the Settlement Act would control over the Implementing Act. So I don't know how strong that argument is or isn't, but there is a concern basically of whether you can effectively do this, the way that the main, the way that LD 1626 is written. There is also a specific concern about IGRA, but I think it makes more sense to talk about that under gaming because it's a very specific thing related to IGRA itself. So the tribal attorneys proposed amendments. Again, I want to remind you that they would propose amending 62022, which is in the legislative purposes provision, to clarify that federal Indian law doesn't just apply to the Wabanaki nations, but also their tribal members and land or other natural resources. And then also, as I mentioned before, the proposed amendment redraft 6216, and that's the provision towards the end of the bill that talks about the fact that state laws are not going to generally apply, and because they don't apply, the effects of those 2 provisions of the Federal Settlement Act are sort of rendered null and void, and unless the Maine Implementing Act specifically says otherwise, all the federal laws and regulations for the benefits of the Indian tribes or nations or their land would apply in Maine. I don't understand precisely why they redrafted it. I think it comes to the same substantive effect, but I would defer to them to understand why they think the language needs to be changed a little bit to get to that effect. The next big provision of the bill talks about tribal lands and their acquisition. And so the bill expand. Yeah.
Jen, I'm so sorry to interrupt you, but this seems like a good place to pause and see if there are any questions as well.
Certainly.
We're now moving on to a different subject matter, and just wanted to prompt people to ask now if they have questions, and Representative Harnett does.
Thank you, Madam Chair. Thank you so much for this, Janet, and I will endorse recognizing a day named in your honor under federal law. A simple question, I think a simple question. Your discussion of the section 6202 parens 2 in the original bill, that would apply to all federal laws, meaning those that predated and postdated the Settlement Act in 1980. Is that right?
Yes, and to the extent that I think it applies to both, but to the extent you might interpret it as not, it's very clear under 6216 that both predating and postdating the Federal Settlement Act, that the intent is to apply both types of federal laws to Maine unless the implementing act specifically says otherwise.
Thank you.
Representative Thorne, go ahead with your question.
Thank you. Judy, you mentioned something about not that long ago when you said you weren't sure if this was a legal change. Could you talk about that a little more? If this bill was...
Oh, I think that, and I could be wrong, so correct me if I'm wrong. I think what I was referring to is, so 6216 is the provision of the bill as drafted that would make all of the federal laws pass for the benefits of Indians and Indian nations and their members. That is the provision 6216, which would make them all applicable in Maine unless otherwise stated. That provision has different paragraphs and a structure in the bill that are changed in the tribal attorney's proposed amendment. I believe that the goal of the language in the proposed amendment is the same. So I don't think the goal has changed. I just don't know why they've proposed different language, and I wouldn't want to speak for them on that point. I am sure there was long and hard thought through, but I just don't understand the reason for the revision of the language.
And the bill would change that language of the provision?
The bill enacts 6216. It does not exist in current law. So current law is the Federal Settlement Act on this point. And the Federal Settlement Act says that laws passed by Congress and the regulations implementing them before October 1980, and then in a different provision of the Settlement Act after 1980, they're for the benefit of Indians. That's the phrase is much longer in the Federal Settlement Act, but I'm just going to use that as shorthand. They're for benefit of Indians. They don't apply in Maine unless it's specifically specified in the Federal Settlement Act for any law that happened before 1980, or unless the law as passed by Congress, it was passed after the Settlement Act, unless it says it applies in Maine. That's how the Settlement Act works. 6216 is a new provision that would be added to the implementing act by the bill, and it would say the opposite, that those do apply in Maine because the reason they don't, oh, sorry, I'm being very too much shorthand. They only don't apply in Maine, those federal laws, if they affect or preempt state jurisdiction. So if there's a law passed by Congress and it does something for the benefit of the tribes and it wouldn't affect or preempt state's jurisdiction, it applies in Maine. But if it does affect or preempt state law, then it wouldn't apply in Maine under the Settlement Act under current law. And the bill says, nope, we're going to apply it in Maine unless we specifically state otherwise.
And there's no override as far as federal or state, which...
No, the state law could apply otherwise. So, for example, the bill before you does provide otherwise as far as criminal laws. It says we're not going to have federal laws that conflict apply in Maine. And it also says to the extent of federal Indian law. And there are some doctrines and tenets of federal Indian law that say state law can apply to tribes or tribal members in certain situations, and that would still control.
Okay, thank you. Thank you, Madam Chair.
You're welcome. And I did, Representative Thorne, I did just put a little asterisk on my bill analysis too, just to raise that issue with the tribal attorneys at the appropriate time. Representative Newell, go ahead with your question.
I think you just provided a response to my question, Madam Chair. I was just wondering at what point would we bring in the tribal attorneys? I think to this particular point that Janet is making, thank you, Janet, for being here and just providing so much helpful information. But I do believe Corey Albright could speak to this as well.
Okay, let's both try to remember to ask him when he's on the panel. Thanks a lot, Representative. Go ahead. You can continue, Janet. I think we're good with questions for now.
Okay, so the next part of the bill talks about tribal lands and acquisition. And I actually personally think that the chart is helpful here. You don't have to agree, but if you would want me to share it, I will do.
Yeah, go ahead. Thank you.
It's a lot of different provisions. So I think in chart format, you may have noticed. So that's the way I wrote this. So the bill expands the potential tribal lands subject to the jurisdiction of the affected Wabanaki nations. I'm sorry, I keep mispronouncing that. I'm really nervous. Referred to in the Maine Implementing Act as the Passamaquoddy Indian Territory, the Penobscot Indian Territory, and the Holton Band Trust Lands. So if you're reading through the bill or current law and you see Holton Band Trust Land or you see Indian Territory, these are the lands we're talking about. So the bill expands the potential lands that could become part of the Indian Territories or Holton Band Trust Land, and it revises the procedures for the addition of new tribal lands as is described in this chart. So first of all, if we look specifically to the Passamaquoddy tribe, Passamaquoddy Indian Territory is defined in the bill in several sections, and it is the land over which the tribe has jurisdiction. And so under the current Maine Implementing Act, that includes the Passamaquoddy tribe's reservations, and there are specifically described lands within the definition of reservations. And as long as those specifically described lands are owned by the tribe or by the U.S. Secretary of the Interior. So from now on, when I talk about secretary, I'm talking about the U.S. Secretary of the Interior. So if the U.S. Secretary of the Interior owns those specifically described lands on the behalf of the Passamaquoddy tribe, so if it owns it in trust for the tribe, or if the tribe owns those lands themselves, then those lands are considered part of the reservation. There is specific mention of specific lands within the town of Perry that may only be included within the tribe's reservation if the tribe pays $350,000 to the town within 120 days of July 16th, 1986. So that clearly has passed. And if any commercial development is approved by the voters of the town. So the bill does change the definition for the reservation to repeal the requirements for that payment of money and for the approval of commercial development by the town of Perry, so that if the tribe were to purchase or if the Secretary of the Interior were to purchase on its behalf, the specifically described land within the town of Perry, it would become part of the reservation. It is not the whole town of Perry. It is specifically described in that portion of the law. The next part of the Passamaquoddy Indian Territory under current law is up to 150,000 acres of land acquired with Settlement Act funds by the Secretary for the benefit of the tribe. And it's only within specifically described geographic areas of the state. So there's a whole list of different townships and different areas where that land can be purchased. And it's on pages 5 and 6 of the bill. You'll see it all stricken through. And those are the only areas where those 150,000 acres can be purchased under current law. So the bill would repeal those specific descriptions of where the 150,000 acres can be purchased, and it would instead say that there could still be a total of 150,000 acres of trust land, but it could be acquired anywhere within Aroostook, Franklin, Hancock, Penobscot, Piscataquis, or Somerset counties, And if the land is in trust before the effective date of the bill, then it would just become part of the Passamaquoddy Indian Territory. If it's not already in trust on behalf of the tribe on the effective date of the bill, and that land is within a city, town, village, or plantation, then the tribe and that local government would have to enter into an agreement for this land to become part of the Passamaquoddy Indian Territory. So that agreement would have to require the tribe to make annual payments in lieu of property taxes, or to make an agreed to alternative payment to the local government. It would also have to, the agreement would also have to provide for cooperation and mutual aid regarding law enforcement responsibility, and would have to require the tribe's use of the land to comply with local zoning ordinances, or to be consistent with existing uses, or to be agreed to by the local government. So if the tribe and the local government were not able to agree within 90 days, certain notices being given, then an arbitration panel would have to select between the tribes and the local government's last best offer on these items, and it would impose as an arbitration decision what that agreement would be. So just to be clear, just to recap, if you look at the current law, there's up to 150,000 acres of land can be placed in trust status that can become part of Passamaquoddy Indian Territory, but only within those specific townships and areas described in current law. Under the bill, instead, it would be anywhere within those counties, but there would have to be agreements if that land was within the authority of a local government. So there would have to be an agreement with that local government before it could become part of the Passamaquoddy Indian Territory. The Attorney General asked if Washington County was intended to be included. I did note that the tribal attorney's proposed amendment doesn't add Washington County, but I absolutely think you should ask if it was intended. I just wanted you to know it wasn't added through their amendment or proposed to be added. The Attorney General had some other concerns about whether it would be confusing to people to know which areas were trust land if you get rid of the specific geographic designations. And they had some specific concerns in the Attorney General's office about the arbitration provision, about some of the details and the mechanics of it, because they pointed out that there's no details about the size, composition, or selection of the arbitration panel. And the Attorney General wondered if it was the best approach to say that the panel would choose the last one of the two last best offers, so either the government's or the tribe's offer, and instead of allowing the panel to impose some kind of compromise between those two offers. Yes, I don't mind that question now.
Thank you. Go ahead, Senator Sanborn.
Thanks. Janet, I don't know, maybe the rest of the committee is really clear on this, but I don't know if this might be a good time for you to help us understand the difference between fee land and trust land.
Sure, to the extent I understand it. So fee land is just like if any purchaser of property typically buys property. Now, if you're me, the bank actually owns it because they have a mortgage deed on the property. But if you're lucky enough and you paid off your mortgage, then you have that land in fee. That's yours. You have the whole, what they call in law school, bundle of sticks of rights over that property. Trust land is not owned by the tribe or the Penobscot Nation or whatever federally recognized Indian tribe you're talking about. Trust land is owned by the federal government. We talk about it being the U.S. Secretary of the Interior, but really it's the federal government that owns the land, and they own it for the benefit of the tribe. So that has some implications. For example, if you think about real property taxes, the tribes can't tax the federal government for the ownership of that land. So it's different than fee land in that sense. And the way that the Maine Implementing Act works is it defines the affected tribes' authority over lands to only include reservation land where specifically defined and trust lands. So if the tribe, as a tribal government or a tribal member, purchases land just like you or I would and owns it somewhere in the state, that is not within the jurisdiction of the tribe. It has to be under the Maine Implementing Act through this very specific process, either in the reservation land as described, or it has to be purchased as trust land by the federal government.
Are you all set, Senator Sanborn?
Yes.
Thank you. And Representative Newell?
Thank you, Madam Chair. Janet, just in response to the Attorney General's question on whether or not the Passamaquoddy tribe would want to include Washington County, can we note that as they would like to have Washington County included, and I believe that may have just been an oversight in drafting.
Okay, perfect. Thank you. Okay, ready to go on?
Thanks.
Sure. So under the current structure, the main implementing act, there are more specific provisions to Passamaquoddy Indian Territory than Penobscot Indian Territory. So in addition to this 150,000 acres of land, there are a couple of other sections. So first, there's a provision that says that up to 100 acres in Calais may be acquired by the Secretary for the benefit of the tribe and then become part of Passamaquoddy Indian Territory if that purchase is approved by Calais and if there's a tribal state compact negotiated under IGRA. The bill would amend that and remove the requirement for local government approval and a compact under IGRA, so there would just be the allowance to have up to 100 acres in Calais. And I don't know my geography well enough to know if Calais is within Aroostook County. It may be. Is that true? I don't know where it is.
I think it's in Washington County.
Okay, thank you.
But
so then I would note that if it is within Washington County and if the tribe wants to include Washington County within this provision above, then it may make sense not to have this part of the bill there. I would defer to the tribe, obviously, on what they want to propose to you. But if it's part of this other provision, it doesn't make sense to have a separate provision about Calais. That would just be my observation. And I'm sorry for not being good at geography. It's never been a strong suit of mine.
I'm not 1,000% confident in my answer either, Janet.
Madam Chair, can I ask a question? While
Please
we're right
do.
here?
Yes, go ahead.
Calais is in Washington County, and I guess my question is, this portion about Calais specifically says that it removes the requirement for local government approval and tribal state compact. So is it in a separate section because it doesn't have the same provision about the effective date of LD 1626, and that it then needs to have an agreement and arbitration if necessary?
So that's where it mattered to me, the geography. So right now, under current law, there's 150,000 acres up to that can be purchased, and there's very defined spaces, and that's not spaces, but geographic areas. And that's in section 6205, subsection 1, paragraph B. There is a completely different paragraph about these 100 acres. And the bill amends that specific paragraph to get rid of the requirements that are just applicable to these 100 acres. But if Calais is within Washington County, I would pose the question of whether this 100 acres should still be without local government approval, which may be the purpose. That's how it's written.
Right.
But I don't know if it's intended to be included in the other 150,000 acre provision. I just don't know, because I didn't, first of all, realize where Calais was, and second of all, Washington County wasn't in the bill.
Okay, thank you.
So there are, so that was paragraph C. Remember, paragraph B is the big 150,000 acre paragraph. Then there's C, which is specific to Calais, and then there's paragraphs D to E, and there's more than one D. There's like a D1 and a couple of other ones. And if you look in those paragraphs, they talk about other specifically described lands in Township 19, Township 21, and Centerville, if acquired by the Secretary, so the U.S. Secretary of the Interior, for the benefit of the tribe. So those also could be included within Passamaquoddy Indian Territory if they're purchased by the Secretary in trust for the tribe, and the bill doesn't change those provisions. There is a new paragraph F, which is added, and that would include, without the need for local government approval, lands held in fee by the tribe before the effective date of this legislation that the tribe requests the Secretary to place into trust status if those lands are within the specific counties mentioned above and the acreage restrictions mentioned above. But this is a different paragraph. So this paragraph doesn't require local approval. It doesn't require the agreements that we talked about before. It would just say, if you're in one of those counties and the tribe already owns this land as fee land, then it could become part of Passamaquoddy Indian Territory if the request was made to the Secretary to place it into trust status. The Attorney General did note that the way that the bill is written, it just talks about the tribe's request for the Secretary to place it into trust status. It doesn't require that the request be granted before Passamaquoddy Indian Territory status is afforded to the land. We don't know if that was purposeful or not purposeful, but that was, and it may be purposeful, but that was the concern raised by the Attorney General. This next part is not as clear in my chart as it should be, so I want to be very careful and make sure I explain this analyst note to you, because I think it's important and I don't know if it's a drafting error or not. So under current law, which is in 6205 subsection 5, and that applies to both the Passamaquoddy tribe and the Penobscot Nation, other land can be included in the Indian Territory if it's held by or acquired in trust for the tribe. Other land that is held by or acquired in trust for the tribe can be included within Indian Territory if it's recommended by the Maine Indian Tribal State Commission, if it's approved through state legislation, and approved by the legislative body of the city, town, village, or plantation, if any. And if you look at that part of the bill really carefully, and well, it's in current law, but you can see it in the bill because it's struck through there. It is written to talk about that land being within the Indian Territory. The bill would repeal that provision and enact a new subsection, which would say that other land acquired by the Secretary in trust for the tribe in accordance with federal law, which would include the Federal Indian Reorganization Act, that what the bill actually says is nothing in the law would prohibit the Secretary from purchasing in trust for the benefit of the tribe other lands in accordance with federal law. And if that happens, local approval would not be required unless land is within one of the counties listed above, in which case the local agreement described above would be required, or local approval would be required if it's required under the Indian Reorganization Act. Now, why did I say there was something weird here? I'm not clear if this is meant to be part of Passamaquoddy Indian Territory, in which case that's not the way it's written currently, or if this part of the bill is just expressing a statement that aside from Passamaquoddy Indian Territory, Maine law is recognizing the right of the Secretary, so the U.S. Secretary of the Interior, to purchase other lands in trust for the tribe. That becomes an issue later. It's really a drafting issue to know whether throughout the bill there are references to trust lands. And it's really complicated. We don't need to get into that weeds now, but it's just important to note that I'm not clear whether this specific paragraph here, 62056, sorry, it's not a paragraph, it's a subsection, is intended to be part of Passamaquoddy Indian Territory or a separate type of trust land that Maine law would be recognizing that the tribe could have.
Thank you for highlighting that, Janet. That's something we can we'll definitely follow up on.
And then the Attorney General raised the concern of whether there is authority to have a separate acquisition process for trust land, because the Federal Settlement Act right now says that other than under the Federal Settlement Act, there's no other authority to acquire lands or natural resources and trust for the benefits of Indians or Indian nations. And the Federal Settlement Act talks about this 150,000 acre limitation. And so the Attorney General was just wondering if this is outside of that process. Is it allowed under the Settlement Act? There is a current provision of law also that applies to the Passamaquoddy Indian Territory, which says that if title is transferred to a non-member of the tribe or the land is then the land would no longer be part of the tribe's Indian territory, and the bill would repeal that. So my understanding of how that would work is if something becomes part of Passamaquoddy Indian Territory, then it would stay with Passamaquoddy Indian Territory, even if later on title is transferred to a non-member. Penobscot Indian Territory is defined. You're going to see a lot of very similar provisions here. So there is a definition for the Penobscot Nation Reservation. It includes specifically described lands if owned by the nation or the secretary on its behalf. And there's no change to that provision of the implementing act by the bill. In addition, the Maine Implementing Act would provide that up to 150,000 acres of land acquired with Settlement Act funds by the Secretary for the benefit of, that should say, nation, within specifically described geographic areas of the state would be included within the Penobscot Nation's Indian Territory. Just like with the definition of Passamaquoddy Indian Territory, the bill amends that, repeals the provision that has very specific geographic limitations on where the land can be, and instead replaces it with this provision that would say a total of 150,000 acres acquired within those specific counties. So Aroostook, Franklin, Hancock, Penobscot, Piscataquis, and Somerset counties. Again, the question raised by the Attorney General's office if Washington County was intended to be included. And again, there would have to be that agreement as long as the land wasn't already in trust before the effective date of the act. If it's in one of those counties and it has a local government, then the nation and the local government would have to enter into that agreement with all of the same terms that were required when we talked about land becoming Passamaquoddy Indian Territory if it's placed in trust within one of those counties. And so the Attorney General's concerns were the same for that provision. There is a question. Am I allowed to take it?
Yes, yes, please do.
Thank you. So Janet, I'm looking at your chart, and so I'm going to ask a question about what's not there, which is that there is no similar provision in your chart with regard to Penobscot Indian Territory regarding lands already held in fee prior to the passage of 1626. Is that an oversight, or is it drafted differentially for the Passamaquoddy and the Penobscots with regard to fee lands?
It's not a chart oversight, but whether there was an intent to be different, I can only assume yes, because that's the way the bill's drafted, but certainly I would ask the attorneys or the chiefs if you wanted on that question.
And so if it were to be intentional, what happens to fee lands that are owned by the Penobscot Indian Nation under LD 1626 that weren't acquired with settlement funds, or maybe are outside of the 150,000 acres? It would appear that those couldn't be put in trust by 1626. Is that how you read it, or would they be able to transfer those lands into trust by request, but they would be required to comply with the local agreement provisions that are similar?
I'm just double checking the fee land thing that's not over here. Just one sec.
Yep.
Okay, so the difference, the thing that's missing here for the Penobscot Nation is the ability to place lands that are already held in fee in trust and become part of the territory, Indian Territory, without local government approval. And that's not here. So you can still have the Secretary of the Interior purchase the land from the tribe, because if the tribe, sorry, the nation, if the nation owns it in fee, it could be purchased from them with Settlement Act funds and then
Okay.
be placed into trust, but these rules would apply.
Okay.
That's how I interpret it, and I'm happy to be corrected by others who are listening.
Right. Okay. So Senator Carney, when the appropriate time comes, I'll want to understand from tribal attorneys the intent there with regard to Penobscot Indian lands. As I sit very close to some in Carabasset Valley right now, as I am watching this hearing.
Thank you. Yeah, I've noted it as a question, and if you can also note it, we'll definitely follow up. Thanks.
And I did want to say, since I made this chart, there was a submission of maps of all the fee lands from the Passamaquoddy tribe. So you should have that. That was sent to you, and it is in the electronic committee file. So you would have, I think, some idea of what we're talking about as possibilities under that provision that's not provided for the Penobscot Nation. So again, we have the current law and the difference here with the new law. So under current law, other land other than those 150,000 acres in those specific geographic areas under current law, other land, if recommended by MITSIC, approved through legislation and approved by the legislative body of the local government, could be included with Penobscot Indian Territory. The bill repeals that provision and replaces it with a new subsection that doesn't refer to Indian Territory. And by the structure of the way this provision of the MIA is written, it doesn't look like it's included with Indian Territory. And that was my question, was that intentional? So other land could be, the bill says nothing in this law prevents the secretary from acquiring other land in trust for the benefit. Sorry, you can see I did a lot of cutting and pasting. That should say nation again, under the Federal Indian Reorganization Act, and local government approval would not be required unless it's within one of those counties listed above, in which case you have to do the local agreement, or if it's required by the federal law itself. And again, the provision which applies to both the Penobscot Nation and the Passamaquoddy tribe about land that is transferred to a non-member no longer being included in Indian Territory, that's going to be repealed vis-a-vis both tribes. So those two provisions are fairly similar, and they're both in 6205 of the Implementing Act. Holton Band Trust land is treated differently. And this is where we get into the question about the effectiveness of the 1981 law, which is what enacted 6205-A, which is what defines Holton Band Trust land. And so it looks in the bill as a markup of 6205-A. If you were to agree with the tribal attorney's amendment, you would just repeal 6205-A and write it anew with the language that you want it to say. And then you wouldn't have to get into the question of whether the 1981 law ever took effect. You could just start afresh. And so currently, Holton Band Trust land is described as land or natural resources acquired by the Secretary for the benefit of the band using federal land claim settlement funds, only if the Secretary files a certified copy of the instrument of conveyance with the Secretary of State. And there's proof of the existence of a Holton Band tax fund, which is required under the Implementing Act, containing at least $100,000 that originally should be funded with Federal Settlement Act funds. And that fund is used to make payments in lieu of property taxes on the land. And then the third requirement is that if the land or natural resources are within a city, town, village, or plantation, that there needs to be local government approval. The bill would repeal those provisions, as amended by the proposed amendment by the tribal attorneys, you would just repeal that and start over with saying land or natural resources acquired by the Secretary for the benefit of the band using Land Claims Settlement Act funds. And there wouldn't be those three additional requirements that are in the empty bullet points, for lack of a better word, on that part of the chart. There also would be a new provision. And again, it's not the way the bill is drafted, it's not located within the definition of Holton Band trust land. It's just a new provision saying that nothing in the law prevents the secretary from acquiring in trust for benefit of the band land using the Federal Indian Reorganization Act. And I wrote what I'm going to check and make sure it's not an error. Yeah, this is an error, so I'll repost this without this. There's no counties listed above for the Holton Band Trust land. So it would just say that you don't need local government approval unless required by federal Indian law. So I'll fix. And again, the Holton Band Trust Land statute currently has provision about title being transferred to a non-member, then it's no longer part of the Holton Band Trust Land, and that would be repealed. So the tribal attorney's proposed amendment would amend the statute to allow the Passamaquoddy tribe and the Penobscot Nation to acquire natural resources in trust under the Indian Reorganization Act, not just lands themselves. So they could acquire natural resources. And then I put here a better summary of the I don't want to use dispute because it's not being treated as a dispute in the tribal attorney's amendment. It's just the question whether the 1981 law ever took effect. The Holton Band and Maliseet Indians proposed in the amendment to have a statement saying that if they agree to that, so if the legislature passes this law and the Holton Band and Maliseet Indians agrees, because their agreement is required under the Maine Implementing Act to any amendments to it, if they agree, then their agreement wouldn't be any kind of concession that the 1981 law took effect. And so you'd be restructuring all of these provisions to say that you're repealing the existing law so that you don't get into the question of whether it took effect and you're just enacting new law. So that's one part of the proposed amendment. It also would change the definition of Holton Band trust land to specifically refer to a separate federal law called the Holton Band and Maliseet Indian Supplementary Claims Act of 1986, which does talk about the land acquisition process for Holton Band trust land. And so you would just refer to that federal law, which nobody disputes is in effect, and use that to be the definition. It would also repeal the provision regarding the Holton Band tax fund. That actually, I'm just going to stop for a second because that may be an area where maybe the amendment had something highlighted in red. Yeah, that's already being repealed in the bill. So I may have just been confused when I was looking at the amendment. I did many late nights, so hopefully you will forgive me. Either way, that Holton Band tax fund will be repealed.
I'm sorry, Janet. I think
this is already being repealed by the bill, so it's not just being repealed in the amendment.
Okay, I understand.
I mentioned it because it was enacted in the 1981 law. So I was trying to list all the different provisions from the 1981 law, but you don't have to look to the tribal attorney's proposed amendment to repeal that provision. It's already in the bill.
Okay, thanks for that clarification. Should we just take a pause and see if there are any questions on the tribal land and acquisition? That was a really clear explanation, actually, Janet. Thank you so much, but people might have a couple of follow-up questions. So let's just see. Any follow-up questions, Senator Sanborn?
I don't know if I totally defer to the chair. I didn't know if it made sense to sort of take the tribal lands acquisition piece separately and talk about that, given the lengthy nature and many different topics in the work session before us, or if we wanted to have Janet lay out the whole bill analysis before we talked about any of the topics. And I totally defer to the chair on either way. I just wanted to ask the question.
Okay, thank you.
I can stop sharing if you want to see each other.
Sure. And then Senator Keim has a question. Let me think about the issue you raised, Senator Sanborn.
Well, my question is pretty short for you, Janet. Just, I think several times you mentioned that, and I just wanted to clarify that if the tribes were to get land and put it into trust and then change ownership of that land, that they could do that and it would still be trust land? Is that, can you just clarify that for me?
So there's a current provision of law that says if title is transferred to a non-member, then it would no longer be included within Indian Territory or Holton Band trust land. I don't know to what extent that ever happens with trust land. I don't know. I'm not an expert in that area. If whether the secretary ever sells that land then and takes it out of trust status and gives it to someone who's not a tribal member. I don't know if there's a process for that. I would say that at least as far as the reservations are concerned, the way that the current implementing act is written is the land is within the reservation if it's owned by or in trust for the tribe or the nation. So maybe it just applies to that land. I don't know. I'd ask the people who actually are members of the tribe and nation for clarification on that. So I honestly don't know, but the current main implementing act says if it's put in this status and then it's sold to someone who's not a tribal member, it's no longer going to have this status. And I just don't know if that ever happens or when it would happen or how it would happen.
And so, right, so this bill repeals that, meaning that it could change ownership, except I'm not sure how it would change ownership since the Secretary of the Interior actually is the owner.
Right, and I don't know if that ever happens. I have no experience in it.
And you don't know why then we would be repealing that part of the law. What the purpose behind that is.
I do not specifically know the purpose. I'm just letting you know that it's being repealed if you pass the bill.
Perfect. Thank you.
Senator Keim, before I move on to Representative Babbage's question, I just wanted to check in with you about Senator Sanborn's suggestion that we pause on the bill analysis and maybe do a deeper dive and perhaps bring on the attorneys who have prepared the legislation and the amendment to ask them these follow-up questions? Or do you think we should continue to go through the document as a whole? I could go either way.
I know that their responses tend to be very lengthy, so I guess if we do that, we probably will not get back to the bill. But I'm fine with whatever you choose.
Okay, I think, I sense that we are going to have committee members who have to sign off in a short time. And I think if we can continue to go through the bill analysis, people can catch up by watching the video. And so I think it makes more sense actually to continue to go through the analysis and then dive into the questions when we can all be back on screen. So let's proceed in that way. And so Representative Babbage, did you have a question for Janet?
Thank you, Madam Chair. Yes, I did. To be answered later if that facilitates things. But I wondered if the sale of trust land to third parties or whatever could apply in two ways. And I'm just going to mention those, and we can validate this later with somebody that would be in the know. About 15%, my observation has been from the statistics I've read that about 15% of residents on the reservations are not tribal members. And is that one category that could be applied here? And then secondly, trust land is by definition more immune from state regulation. and therefore could be more valuable to third parties that have nothing to do with the tribes. And so that might be a non-tribal purchaser as well. And I'd just like to know if those two categories might apply. Thank you.
Yeah, I've made a big star and recorded your question on my chart, Representative Babbage, and we could definitely follow up on that. Thanks.
I'm writing that down too. So the next topic, at least the way I approached the bill, was about takings. So the bill eliminates language in the Maine Implementing Act regarding the takings of tribal land for public use under state law. So under the Maine Implementing Act right now, it provides that prior to the taking of Passamaquoddy Indian Territory or Penobscot Indian Territory by a public entity or a public utility, there must be a finding that there's no reasonably feasible alternative to the proposed taking of tribal land in general, and there are a lot of details and I'm omitting them here. If any land is taken within either tribe's reservation, the public entity or utility must purchase land of equal value adjacent to the reservation as compensation. By contrast, if land is taken within either tribe's Indian territory, funds received as compensation for the taking to be used to purchase new Indian Territory land within 2 years. In either case, additional state consent is not required to include the replacement land within the reservation or Indian Territory. There's a different provision, so it's 6205A subsection 2 that applies to Holton Band Trust land. And that section provides that lands may be taken from Holton Band Trust land to the same extent as privately owned land, and that the United States would be a necessary party to any condemnation proceeding, and that proceeds from the taking would have to be placed in the land acquisition fund for the Holton Band and Maliseet Indians. So all those detailed requirements and authorities for takings would be eliminated in the bill. So the Attorney General's question was whether repealing those provisions would make it impossible to take tribal lands for public use in any circumstance. And I should be clear, we're talking about state takings. They're still federal government takings, which are a separate matter, not addressed here.
Madam Chair?
Yes.
Would it be possible, if we're not going to take questions right now, would it be possible for Janet to put it back up on the screen? As we look at different papers, it's great to know to go back to where Janet is when she's speaking, and it's just helpful to me if that's helpful to the committee at all.
Yeah, that's fine. And I just want to clarify, right now we're asking questions of Janet, but if there are questions that we need to pull other people onto the panel, we'll do that later. And so, please do, I'm encouraging everybody to ask questions of Janet. If you have questions for Janet, and there obviously are going to be some occasions where we'll have to pull others onto the panel, but we'll do that at a later time.
Okay, I will switch. Somehow I shrunk it before I closed it last time. Sorry about that. Okay, the next somewhat large topic is about fishing, hunting, trapping, and taking of wildlife. So the bill adopts federal Indian law regarding the exclusive jurisdiction of the affected Wabanaki nations to regulate fishing and hunting by both tribal members and non-members on their respective tribal lands, but it retains the authority of the Maine Indian Tribal State Commission to regulate fishing on waters at the boundary of tribal lands. The bill authorizes the state solely for conservation purposes to regulate such activities by tribal members off tribal lands to the extent permitted under general principles of federal Indian law and in a manner consistent with reserved tribal treaty rights. So that's sort of the overview. If you look at the provisions of the bill, because I know this committee is very detail oriented, which I love because I am detail oriented. Even if I make mistakes sometimes in the details, I will fix them. But under current law for the Passamaquoddy tribe and the Penobscot Nation, they have, sorry, something just popped up on my screen. I couldn't see it anymore. Sorry. Passamaquoddy tribe and the Penobscot Nation have exclusive authority to regulate hunting, trapping, and taking of wildlife in their Indian territory and to regulate fishing on any less than 10-acre pond, so not a great pond, wholly within their Indian territory. In addition, the tribes or nations hunting, trapping, taking of wildlife, and fishing ordinances may not discriminate between tribal members and non-members. On this particular topic, even though current law is limited to the Passamaquoddy tribe and the Penobscot Nation, the bill would repeal that provision and enact a new subsection right under it that would mirror current law, except it would also apply to the Holton Band and Maliseet Indians, allowing them to regulate hunting, trapping, and taking of wildlife and fishing on their trust land, or Holton Band trust land, which is that defined term we just talked about. And it would also not have any language prohibiting the affected Wabanaki nations from enacting ordinances that favor tribal members over non-members, or even, dare I say, the other way around. It just wouldn't have that language in it. So the next category of hunting and fishing provisions in current law. So we're in this second part of the chart here. Tribal members may take fish within their tribes or nations' respective reservations for individual sustenance, except as limited by the Commissioner of Inland Fisheries and Wildlife regulations, which there is a provision for that we're going to talk about in a minute, governing fishing or taking of wildlife on tribal lands. So again, this is only specific to the Passamaquoddy tribe and the Penobscot Nation in current law. So the bill would amend that provision and apply it to all of the affected Wabanaki nations and their Indian territory and trust land, rather than in current law, the sustenance right is limited to the reservations. In addition, the bill would include both fishing and taking of wildlife, so it wouldn't be just limited fishing. And it removes the language in that provision that talks about the takings being for individual sustenance. The Attorney General had a concern about this, about removing that individual sustenance and whether the extent of the effects that would have. And that's over here, but I'm going to focus more on the bill at the moment. So the next provision of current law, again, applied only to the Passamaquoddy tribe and the Penobscot Nation under current law. This bullet point here, just so you can follow, the tribe and the nation must maintain registration stations for wildlife that are killed in their territories. They must report registered wildlife to the Inland Fisheries and Wildlife Commissioner, and they must make their records open for inspection, and that provision would be repealed. The next part of current law states that the Maine Indian Tribal State Commission, or MITSIC, has exclusive authority to adopt rules regulating the use of motors on waters that are less than 200 acres within Indian territory. And Indian territory is right, that's not a mistake, because remember, these provisions are only in current law about the Passamaquoddy tribe and the Penobscot Nation. The bill would repeal that language, and then there's one provision of Title 12 in the bill at the very outset, and that's related to this. It repeals some language in Title 12 about these MITSIC rules for motors. So the last item on this page is under current law, MITSIC has exclusive authority to adopt fishing regulations for certain boundary waters and great ponds. So ponds of greater than 10 acres. Actually didn't know they were called that. My house does not touch, but looks at what is called great pond. And I thought that's what it meant. But apparently that's really a thing. If you staff IF&W, you would know that, but I don't. So right now, MITSIC has authority to adopt fishing regulations for boundary waters, and then also great ponds that are wholly within Indian territory, subject to a statutorily mandated balancing of specific factors in enacting those regulations. And the bill would amend that provision to allow MITSIC authority to regulate fishing in boundary waters for the Holton Band Trust Land. And it would also clarify that MITSIC's regulations, when adopted, may not limit sustenance fishing by tribal members within their respective Indian territory or trust land.
Janet, could I please ask you a question about the previous set of boxes?
Absolutely.
So when the notation that 1626 repeals the two sections that give MITSIC exclusive authority. So who would have authority to adopt rules and regulations regarding the use of motors? on Great Ponds.
So if I'm understanding correctly, if we think about the general principle of the bill, which is that if it's tribal land, the tribes have the jurisdiction over it. So my understanding would be, it would be the specific tribe whose land it is.
Thank you.
And again, when I say tribal land, I'm talking about trust lands and reservations. I'm not talking about any land held in fee. When we're talking about jurisdiction, we're talking about those defined terms we just went through that whole chart about.
Thanks, that's helpful.
So also under current law, the top of this next page, MITSIC must conduct studies and consult with the tribe, nation, landowners, and state officials in doing those studies, and then recommend to the Inland Fisheries and Wildlife Commissioner policies for non-tribal land. So about regulations of hunting and fishing, etc., on non-tribal land. And those policies and studies are all about the protection of fish and wildlife stock on lands or waters that are subject to the tribes, the nations, or MITSIC's regulations. So this isn't a requirement that the commissioner follow them, but this is information providing, an information provision to do these studies and provide some recommendations so that the policies on surrounding lands don't affect the stocks on the lands that are regulated by the tribes. The bill would amend that provision to include consultation with the Holton Band of Maliseet Indians. And it would also say that not just to consult with, but also to be concerned with the fish and wildlife stocks on Holton Band Trust land. So it's extending this, just like all the other provisions, to include the Holton Band of Maliseet Indians, because just a reminder, because the heading is way up on the other page, all of current law on this topic is really only talking about the Passamaquoddy tribe and the Penobscot Nation. The second row on this page says that lands and waters subject to the tribe, nation, or MITSIC's regulations must be posted conspicuously, and that is retained in the bill, but expanded also to include lands and waters subject to regulation by the Holton Band of Maliseet Indians. The next part is the authority under current law for the Commissioner of Inland Fisheries and Wildlife to conduct fish and wildlife surveys within Indian territories. And if the commissioner believes that the stock of any fish or wildlife outside of Indian territories is being adversely affected by tribal or MITSIC regulations or lack thereof over the fishing or taking of wildlife within Indian territories, then the commissioner can adopt remedial measures. This provision has a lot of language and a lot of specified processes, but I think for our purposes today, and feel free to correct me, the thing to understand is that the Commissioner of Inland Fisheries and Wildlife has authority if the commissioner believes that the activities occurring on tribal lands are negatively affecting fishing and hunting off of tribal lands to adopt remedial measures, which could include applying state regulations to tribal lands. The bill would repeal that and enact a new provision that would authorize the state to regulate fishing, hunting, trapping, and taking of wildlife by Indians off of Indian territory or trust land solely for conservation purposes and only to the extent authorized by federal Indian law and consistent with reserved tribal treaty rights. So probably these aren't really equivalent. It's just that they were next to each other in the statute. They're kind of slightly different topics. But as far as this, there were some attorney general concerns again about the reserved treaty rights and whether there are such reserved treaty rights or what kind of litigation that might lead to. And then just as a general statement, there are some specific laws in Maine law that are not affected or not directly affected. They're not amended in this bill that specifically apply to tribal members. So for example, there are tribal elder quotas in that specific statute. You can link to it here and read it. And the question was, how is that affected by this new provision of the bill, which says that the state has very limited authority to regulate the fishing, hunting, trapping, and taking of wildlife by tribal members outside of their Indian territory and trust land. So how would those be interacting is the question that was raised. There's also a provision of current law that says any fish or wildlife lawfully taken on Indian territory may be transported in the state. Remember, current law is really about the Passamaquoddy tribe and Penobscot Nation, thus the Indian territory phrase, which is not used for the Houlton Band and Maliseet Indians. So the bill would apply this to Houlton Band trust land as well. And just as I said, Houlton Band and Maliseet Indians isn't included in this provision about fishing and hunting of current law. So the band has no authority to regulate hunting, trapping, taking of wildlife, or fishing on Houlton Band trust land currently under the implementing act. And that provision, which has that effect, would be repealed by the bill. And that would comport with all the other requirements, the provisions of the bill that we talked about, which adds the Houlton Band and Maliseet Indians to all of these provisions about the authority to regulate fishing and hunting, and then to have MITSIC regulated on boundary waters and great ponds. So the tribal attorney's proposed amendment is only that issue about whether you repeal and replace or amend that provision of the statute. So the next topic in the bill is land use and natural resources. So the bill is designed to afford the affected Wabanaki Nations authority to regulate natural resources and land use within their tribal lands under federal Indian law. So as we've discussed before, state law applies under the Maine Implementing Act to all tribes, tribal members in their lands, unless it's specifically otherwise stated. And federal laws don't generally apply for the benefit of Indians if they conflict with or preempt the civil, criminal, or regulatory jurisdiction of the state, and that includes laws relating to land use or environmental matters. The bill would repeal that provision of the Implementing Act and enact a new section, which, as I stated above, provides that the affected Wabanaki Nations and the state agree under the Federal Settlement Act that the affected Wabanaki Nations have the authority to regulate natural resources and land use within the boundaries of their respective Indian territory or trust land to the extent provided by federal Indian law. And then again, if there is a federal law, in this case, I'm saying federal law as like a law passed by Congress relating to land use or environmental matters, that's for the benefit of Indians, Indian tribes, or tribal lands, it would be applicable in Maine under 6216, even though it might not have been, even though it might conflict otherwise with state law, because state law isn't going to apply to tribal territories and trust land under the bill. So this is not as detailed a provision. It doesn't get into all the nitty gritty of what applies where and when. It references federal Indian law for that. And I am not an expert on federal Indian law. So I did refer to you to some of the pages of the task force report that go through some of the general precepts of federal Indian law as far as land use and natural resources. And again, the Attorney General's concerns here, you've heard before, just wanted to repeat them because they're applicable here about the effectiveness of these provisions. The other thing that was raised by the Attorney General was that there are some federal laws, including that allow for treatment as a state status. You talked about the Safe Drinking Water Act this morning, and I'm sorry I couldn't be there. I had a family emergency, but there is treatment as a state status under other federal laws. For example, the Federal Clean Water Act. And in that context, although the provision of the bill that talks about land use and natural resources talks about the tribe's regulatory authority within the boundaries of tribal land, there are some laws like the Federal Clean Water Act that allow the tribal regulation to have effects outside of tribal land. For example, discharges upstream of tribal lands are sometimes required to comply with downstream tribal standards if the Federal Clean Water Act is applied. So that was the Attorney General's concern. Again, I am not an expert on that. I would defer the questions on the details of how this land use and natural resources provision works to others who are far more expert than me in this field.
Janet, before we do a brain shift into taxation. I just wanted to do two things. One is to ask committee members first if they had any questions about the trust lands and land use and natural resources sections. And then I feel like we've been meeting steadily since 12:30, and so we should probably take a little break for all of our benefits, and especially yours, Janet. So first of all, committee members, any questions through section 9 of this bill analysis? Representative Evangelos?
Thank you, Madam Chair. It's a simple question, Janet. Is there a process where people would go onto the nation's land and report to an office where they could buy a fishing or hunting license?
If the tribes made that process, they absolutely could. I think that would be up to the tribes.
I think they're already doing it now as municipalities, so it would be a logical extension of the nation's powers, but thank you for that.
Yeah, the bill wouldn't stop them. It would just defer to the tribes to have authority over their lands and set the rules that they choose to set.
The only reason I bring it up, Madam Chair, is it's very important for our sportsmen and women to know that their access to hunting and fishing will not be impeded, other than what they'll have to do, what the rest of us already have to do, is go to the office and buy a license. So thank you for that.
Any other questions, committee members? Okay, it's 4:17, and so I would like to give everybody at least a 5-minute break. Janet, how much of a break would be helpful to you?
5 minutes would take care of my personal needs at the moment.
Okay, so
read into that what you will.
So just to simplify it, let's return at 4:25. That's easier math. See everyone in a little bit. Hi, Janet. I think folks will be rejoining us momentarily.
Okay.
This has been really helpful, Janet, so thorough, and we really appreciate all the hard work that you put into the understanding the bill and creating the bill analysis.
It's really a remarkable job, and I think it's of great benefit of the committee members.
Thank you. I do want to say to anybody listening, there may be mistakes in it. It's a long bill and very detailed. And I do not mind people telling me what the mistakes are. Just send me an email, I'll fix it. If there's a mistake, it was not intentional.
Janet, I think there are enough of us back, and I know some committee members had other commitments that they had to head off to. So, but I know that they will be looking forward to watching the replay on YouTube. So whenever you would like to begin, I think we're good.
Sure, I know that everybody wants to hear about tax law all of the time. So I expect lots of likes on the video. As you can tell, when I'm nervous, I make bad jokes. So
I thought it was a good joke.
Thank you.
Having taken a tax class.
Understood. So the bill amends both the Maine Implementing Act and Title 36 of the Maine Revised Statute. So that is a difference between this section of the bill and other parts of the bill, which mostly are focused on the Maine Implementing Act, other than that one part about Title 12 I mentioned really briefly about motors. So this amends both, and it's to adopt certain principles of federal Indian law involving state and tribal authority to tax activities by Indian tribes, tribal members, and activities on tribal lands. So the general rule now is that state laws, including tax laws, apply to tribal lands, tribes, and tribal members within Maine, except as provided in the Maine Implementing Act. And that is based both on 6204, which we've referred to before, which is being repealed in the bill, and then 62083, which is a specific provision about taxes. The general rule is also, and I'm sorry, this breaks across the page, just the way the cookie crumbled. The Passamaquoddy tribe and Penobscot Nation, but not the Holton Band and Maliseet Indians, may impose taxes to the same extent as a municipality within their Indian territories. I confirmed this with the AG's office because I am not a tax lawyer, but currently municipalities may not impose income or sales taxes in Maine. So to the extent that the Passamaquoddy tribe and Penobscot Nation have the authority under current law to impose taxes like any municipality, they're not all kinds of taxes. There are only certain taxes that municipalities can impose. And those are the only ones that the tribe and the nation are authorized to impose currently. So the bill repeals those general rules provisions and enacts a new provision of 6208, which is again within the Maine Implementing Act, and it provides that the state and the affected Wabanaki nations agree, again to the Settlement Act, that the affected Wabanaki nations have exclusive jurisdiction to tax tribal members and tribal entities on their respective tribal lands. And then it has a phrase at the end that says, including entities owned by a tribe or a tribal member. This is the only chart because it really did make a lot more sense for people to follow. To that, where I put the tribal attorney's proposed amendments on the right. And again, whichever, whether I put the Attorney General's concerns or the tribal attorney's proposed amendments in the chart, it wasn't that they were more important. It was just that I thought it was harder to follow if you moved them to the bottom, whichever one I chose to go in the chart. It would be great if papers were really, really wide and able to be screen shared, and then I put everything in every chart, but I was sensitive to the fact that screen sharing is hard on a wider paper, then the type would be too small for you to see. So that was literally the only reason I don't have them in the chart all the time for both. So in the tribal attorney's proposed amendment, it would eliminate this italicized language. And that's probably because there is a definition of tribal entity below. So we're going to get to that, but you can definitely check with the attorneys to figure out why they eliminated that language. I know it made sense to me when I put the chart together, but I'm a little tired now, so I can't think about it at the moment. And then again, we have these provisions, 6206A being one, that the Houghton Band of Maliseet Indians doesn't agree took effect. So it's important to remember that, but it wouldn't prevent the bill from doing what it does, which is just to repeal that section. So the bill also newly defines tribal entity, and I put it up here in the general rules kind of provision because it applies throughout. So under the bill, a tribal entity is a business entity, and there's specific types listed like corporations and partnerships, for example, for which at least 50% of the ownership interests are held by any combination of one of the affected Wabanaki nations and its members. And for the purposes only of this definition, and that's important because some of the testimony asked about this part of the bill. So for the purposes only of defining a tribal entity, member includes a married couple if one spouse is an enrolled tribal member. Obviously, both spouses are, that's fine. So it probably should say if at least one spouse is an enrolled tribal member. But to the extent some of the testimony asked how this definition of member applied throughout all of the other language, as I read the bill, that definition is only applicable to deciding if something is a tribal entity. Otherwise, a tribal member would be a member as defined by the tribes themselves. They have, under current law, and the bill doesn't change it, they have sole authority to decide tribal membership.
Could I ask a quick question, Janet?
Yes.
Does the tribal entity concept apply also outside of the tax provisions of 1626?
If it's mentioned anywhere, I didn't see it mentioned other places. I could do a search of the bill again, the bill text, but it's a definition that applies to all of the main implementing act.
Okay. All right. Thank you.
Just saw its import, like it seemed important in the tax area. So that's why I mentioned it here.
Okay, great. Thanks.
The tribal attorney's proposed amendment. Remember, I told you there's specific types of business entities listed. It would add LLCs to that list. And so it changes slightly the wording of the part of the definition describing the at least 50% ownership requirement. I had a guess about why the wording was changed, but I would suggest you ask the tribal attorneys themselves. So my guess is in italics, but don't hold me to it. I would definitely trust the people who wrote it to understand what they meant to do by that change. But I did want to point out that that was a change. So the big first topic in tax is income tax. So if we just go through the provisions of current law and different types of people or entities or government be subject to tax. First, we look at settlement fund income. So we don't need to get into the weeds of this unless you really want to, but the Settlement Act has land acquisition funds, and then there's some other funds that can sometimes be paid to tribal members or different tribal interests, and any settlement fund income to the Passamaquoddy tribe, the Penobscot Nation, and tribal members is exempt from state income tax under the Maine Implementing Act, and that is not changed in the bill. So that exemption remains. As far as income tax, this is state income tax and tribal governments. Under current law, state income tax applies to the affected Wabanaki Nation. So all three, except that the Passamaquoddy tribe and the Penobscot Nation are exempt from state income tax when acting in a governmental and not a business capacity. The bill would repeal this provision in the Implementing Act and enact a new provision that would say that all three of the affected Wabanaki nations are exempt from state income tax for income earned on or from activities on or otherwise sourced to their respective tribal lands. There is another provision that's in the bill. It's 62086, and it has a general statement about income tax and the agreement of the state and the affected Wabanaki nations about how state income tax is going to be applicable only as allowed under federal Indian law. The way that provision is currently written, it does not look like it applies to the tribal governments themselves. It's clear it applies to tribal members and tribal entities. And so the proposed amendment by the tribal attorneys would clarify it also applies to the governments as well. So it is provided in this one provision of the bill. And if you adopt the bill and the tribal attorneys amendment, it would be also clear in this other provision. Then there's also outside the implementing act, but in the tax code, the bill would state that beginning January 1st, 2022, there's a subtraction from taxable state income for income of all the affected Wabanaki nations. These are nations as nations, so tribal governments sourced to Indian territory or trust land. You can see here that this part doesn't talk about beginning January 1st, 2022. This part in the tax code does. So this is the type of thing, I have a detailed list of questions at the end of the bill analysis. They're sort of in the upright page setting instead of the wide page setting. And some of them I'm asking not because I'm suggesting the bill is wrong or drafted wrong. Sometimes I'm really asking the question, and it wasn't clear to me how this January 1st, 2022 interacts with the broad statement in the main implementing act part of the bill that doesn't talk about a year when it begins. Obviously, January 1st, 2022 has already occurred. So there may need to be a change to that, or maybe there wouldn't be. I don't know. Retroactively, not everybody's filed all their income taxes for that yet. So that was tribal governments and their amenability to state income tax. Now we're going to turn to tribal members and tribal entities. So under current law, regardless of where the income is earned, state income tax applies to members of any Indian tribe in the state and to all business entities owned by members of any Indian tribe in the state. So the bill would repeal that provision of current law and enact a new provision, actually two new provisions within the main implementing act that provide that the state and the affected Wabanaki nations agree under the Federal Settlement Act that state income tax does not apply to members of the affected Wabanaki nations or to tribal entities who reside on their respective Indian territory or trust land, sorry, the word land is missing, if the income was earned on or sourced to their respective Indian territory or trust land. So that's a big mouthful, and I want to make sure you realize that's a two-part test, both of which have to be met. So you have to be exempt from state tax under the bill, which is following federal Indian law. You would have to be a tribal member or entity that is both residing on your respective tribes, trust lands, or reservation, and you have to be earning the income on there. If that two-part test isn't met, then you aren't exempt from state income tax under the bill, which, as I understand it, is how federal Indian law works as well. There are some minor technical changes in the tribal attorney's proposed amendment to this language, just to make the two provisions, you know how I said there's two provisions, there's this one here, 62086, 62089A. It makes those two match a little bit better. It doesn't change the substance of them. If you look as far as state income tax applicability to tribal members and tribal entities, there is also a provision that amends the Title 36, so the state's tax laws. Again, it's that same provision I talked about before, but it applies beyond tribes as governments. So it says that beginning January 1st, 2022, there's a subtraction from taxable state income for income of, and I think it's meant to include tribal members and tribal entities. That's not entirely clear the way the provision is written. And I believe that's the reason why the tribal attorneys proposed an amendment to that provision to make that a little bit clearer. So it would subtract from taxable state income the income of tribal members and tribal entities, again, If both parts of the test are met, the income would have to be sourced to Indian Territory or trust land, and the tribal member or tribal entity has to reside on Indian Territory or trust land. If you're reading really, really carefully, you may notice that I just said generally Indian Territory or trust land here. And above, I talked about the respective tribes, Indian Territory or trust land. So for example, a tribal member of the Passamaquoddy tribe would have to live on Passamaquoddy Indian Territory and earn their income on Passamaquoddy Indian Territory to be exempt from state income tax. That's how the provisions that are amending the Maine Implementing Act are written, and that's my understanding, as basic as it is, of federal Indian law regarding taxation. This provision in Title 36 is written a little more broadly, and I don't know if that's an error or not. So that's the type of thing, again, that's mentioned in the list on the bottom of the bill analysis of questions I have for people who know exactly what was intended. So what does that leave? So remember 6216 is, there's no reason why you should remember this, but it's the provision of the bill that talks about state laws don't apply generally to tribal members and tribal entities and tribes as tribes on tribal land unless provided for under federal Indian law or the Maine Implementing Act. So here is a place where federal Indian law does allow state law to apply to tribes or tribal members. And so if you look at federal Indian law, state income tax law would apply to a tribal member who does not reside on tribal land. So any income they earn would be subject to state tax. And state income tax also does apply to income of a tribal member that's earned or sourced to land off of their tribe's land. So if there is a member of the Passamaquoddy tribe who doesn't live on Passamaquoddy Indian Territory, state income tax applies to them. If there's a member of the Passamaquoddy tribe who does in fact reside on Passamaquoddy Indian Territory, but who works in the state house, for the legislature, then state income tax would apply to them because they're not working or earning or having their income sourced to their tribal land. So now if we look at state income tax and non-members, under the Maine Implementing Act, the state has exclusive authority to tax income earned by non-members on tribal lands. Remember, that's the general provision about state laws applying everywhere. So that provision is repealed. There's a new provision enacted that says the state and the affected Wabanaki nations agree under the Federal Settlement Act to concurrent jurisdiction, allowing the Wabanaki nations, the state and local governments to tax non-tribal citizens on tribal lands, except that the state and local governments may not impose taxes if their jurisdiction is preempted by federal Indian law. And there's case law on this with balancing tests and different tests about when the state or the local government's jurisdiction to also impose taxes is preempted. And I would refer you to the charts in the task force report, or more importantly, to the tribal attorneys in the AG's office who know this tax law really intimately, and they could answer if you have questions about this concurrent jurisdiction provision. And then as far as sourcing of income, there's nothing in current law about how you decide if income is sourced to tribal lands, because remember, that's really important to decide if income earned by the tribe as a government or by tribal members would be exempt from state income tax, or by tribal entities. There's no sourcing rule in current state law because that doesn't apply. State income taxes apply. But under the bill, because sourcing matters, there is a provision that's a general rulemaking provision allowing the Maine Revenue Service to adopt routine technical rules in consultation with the affected Wabanaki nations to implement the tax provisions of this legislation. This is just a guess on my part, but I would imagine some of those rules would have to be about how you do the sourcing. Does anybody want to talk about income tax? I know everybody loves to talk about income tax, especially as we approach April.
Yeah, I was going to say it's that time of year. Committee members, any questions about the income tax section that Janet has just explained to us? Representative Thorne, go ahead.
Thank you, Madam Chair. Janet is and I don't even know, pardon my ignorance, if like disability checks or social security checks, I don't believe those are taxed, are they?
I am not a tax attorney. I can write that down as a question, but I do not know the answer. Right.
I just curious if you're receiving a check either from the state or from the federal government, are those are they taxed now? Or the next question would be, if they are, would they continue to be, or would this exempt that?
I think that's a great question for the other attorneys.
Okay. Thank you. Thank you, Madam Chair.
Thanks for the question.
I'm just writing it down so I don't forget. So turning to sales tax, under current law, tribes, tribal members, and tribal entities, for them, state sales tax applies to the Passamaquoddy tribe and Penobscot Nation when acting in a business and not a governmental capacity. It also always applies to the Holton Band and Maliseet Indians and always applies to tribal members and businesses. Under the bill, the state and the affected Wabanaki nations would agree under the Federal Settlement Act that state sales taxes do not apply to all three of the affected Wabanaki nations, their tribal members, and tribal entities for purchases made on the tribes or the members or the entities' respective tribal lands. In addition, but if the property or service that's purchased is used primarily outside of the relevant tribal land, then state use taxes would apply instead to the original sales price. So if you look at this new provision in Title 36, it will talk to you about how you decide if something that was purchased and that originally looked like it would meet the exemption, so state sales tax didn't apply. It talks about the test for deciding whether it's primarily used outside of the relevant tribal land and deciding when use taxes apply. For non-members, state sales taxes under current law apply to purchases by non-tribal members on tribal lands. Under the bill, the state and the affected Wabanaki nations would agree under the Federal Settlement Act to concurrent jurisdiction, allowing the Wabanaki Nation, state, and local governments to tax non-tribal citizens on tribal lands, again, unless the authority of the state or local government would be preempted by federal Indian law as far as that sales tax jurisdiction. I am not an expert on this, but I will say I remember a lot of discussion during the task force about this idea of concurrent jurisdiction for imposing taxes on non-member purchases on tribal lands and how that could lead to double taxation. It's my understanding, if this is something you're curious about, you might want to ask the tribal attorneys or the AG's office or the chiefs about this, but it's my understanding that across the country, there are agreements entered into between the states and the tribes so that there isn't a double taxation going on. There is a provision in current law. We're going to transfer a sales tax revenue because remember, the left-hand side is current law. In the tax laws, so this is not in the implementing act itself, there's a provision that says that the amount of sales tax revenue collected by the state that's attributable to sales occurring on the Passamaquoddy reservations is returned to the Passamaquoddy tribe on a monthly basis. The bill would enact a new provision within the implementing act and also amend that provision of the tax laws to expand the sales tax revenue transfer provision to include the transfer of sales tax revenue to all three of the affected Wabanaki nations for sales occurring on their respective tribal lands. The proposed amendment from the tribal attorneys would clarify that the sales taxes we're talking about are taxes on sales to non-members. And maybe you all picked up on that immediately, but I remember reading this sales tax revenue transfer provision and thinking, why do you need to return sales taxes if sales taxes don't apply? And this is why, because it's the sales taxes imposed on the non-members by the state. In addition, there's another provision which says that the state in the bill itself that says that the state and the affected Wabanaki nations may enter into agreements to share revenue from sales taxes collected on the respective tribal lands. Again, that did strike me as a little odd given the other provisions of the bill, and the tribal attorney's proposed amendment clarify that the agreements for sharing revenue from sales taxes would apply to sales taxes collected on the Wabanaki nation's fee lands, not the tribal lands. So again, if you have questions about that, I would defer them to the tribal attorneys who would understand why they want to propose that change. We move from sales tax to property tax. Under the current implementing act, the affected Wabanaki nations must make payments in lieu of property taxes for real and personal property within tribal lands, but property of the Passamaquoddy tribe and the Penobscot Nation within their Indian territory that they use predominantly for government purposes is exempt from the requirement for these payments in lieu of property tax. I believe you talked a little bit about these earlier today, so hopefully this is a little familiar concept. The bill would repeal that provision and enact a new provision that would say that the state and the affected Wabanaki nations agree under the Federal Settlement Act that the affected Wabanaki nations tribal lands are not subject to state or local real property tax. It doesn't mention personal property tax like the payments in lieu of taxes provision does. The proposal from the tribal attorneys would amend this new provision in the bill to clarify that the real property tax exemption also applies to tribal members and tribal entities' property within their tribal lands. And then as far as the authority of the tribes, most of this chart is about the applicability of state tax laws. But I did want to point out that the affected Wabanaki nations don't have the authority to impose real property taxes on trust lands because they're owned by the federal government, and nothing in this bill changes that. Just for purposes of understanding what revenue sources are available to the tribes versus the state, I thought that might be important information to you. The Attorney General had some concerns as far as the sales tax provisions. The Attorney General wondered if the intent of those provisions of the bill was to apply beyond the sales and use taxes that are mentioned in the Title 36 provisions of the bill, or if they're also intended to apply to the service provider tax and the gasoline tax. There were some other examples, but those were some examples in the Attorney General's testimony. There was also a concern about the fact that a tribal entity can't reside somewhere. That's not a concept used for businesses. And there was a question whether it might make sense to reference a concept that would be used for entities, for example, where the entity is organized. So that's a principle used a lot in corporate law. Is it organized in Delaware versus Maine? You have a location. Would it be organized under tribal law, I think is the question, or state law? I don't know that that's the test you would want to apply, but that's a question. You could also look at the place where it operates. I'm not a tax lawyer, so I don't know how complicated these questions can become, but it was a question raised in the Attorney General's office. As far as the concurrent jurisdictions provisions we talked about for income and sales tax. So the states and local governments concurrent jurisdiction in the new provision from the bill to tax non-members for activities on tribal lands doesn't apply if the jurisdiction is preempted by federal Indian law. The Attorney General raised a concern that there's a fact-specific balancing test when any of these tax cases as litigated, and for that reason, it may be difficult to predict this concurrent jurisdiction and the contours of it precisely. There was a question raised by the Attorney General about non-members sometimes being subject to state and local taxes for activities on tribal lands, and the question whether tribal entities would be compelled to collect and remit those taxes. And that is a question. I would say that they're subject to those taxes now, so I don't know what happens now, but if you're interested in that question, that may be the follow-up question you want to ask. And then again, because these new provisions within 6208 of the implementing act are established as agreements between the state and each affected Wabanaki Nation, there's the question raised throughout the bill by the Attorney General about whether there is authority to amend the main implementing act in this way with regard to the Holton Band and Maliseet Indians, because the Federal Settlement Act has slightly different language about Congress's advance consent to changes to the structure of the tribal state relationship for that band. Switching to gaming. Oh, may I ask Representative Thorne's question?
Yes, please do.
Thank you, Janet. I didn't want to get too far away from what's swimming around in my head. If I get this correct, let's say I go into a shop on tribal land and I buy something, a t-shirt for $10, and I pay a dollar, just for round numbers, tax. I have to pay that. They pay that to the state, and then the state returns that dollar back to them.
So first of all, I would say the dollar you're paying in tax, there's concurrent jurisdiction under the bill. So it could be that some you're paying directly to the tribe and some you're paying to the state. I don't know exactly the contours. I don't think state jurisdiction to impose sales tax would be preempted in that fact scenario, but not being an expert, I'm not going to conclusively say either way, but it is concurrent jurisdiction. So you might be paying some directly to the tribe anyway. But then under the sales tax transfer provisions, yes, it would be returned back.
Well, possibly a state tax plus a tribal tax, for lack of a better word.
Possibly, although it's my understanding that across the country, there are efforts to avoid double taxing, so there are agreements entered. Whether that would happen here, I can't say, but that's my understanding of the way that those kinds of provisions work.
But if a tribal member, whatever they show for proof that they're a tribal member, they wouldn't pay that tax. They just pay the straight $10.
They could pay a tax if the tribe has a tax, but they wouldn't pay state sales tax if it's their territory they're purchasing it on.
Okay. And when that money goes back, does it go back to the specific tribe? In other words, is it a general Wabanaki fund that it would go back to, or would it go to a Passamaquoddy if it was purchased on Passamaquoddy tribe land, or Penobscot on Penobscot land? How would
it's specific to whose land it is. So whose Indian territory or Holton Band Trust land it is.
Okay. Thanks. Thank you, Madam Chair.
So as far as gaming, generally federal laws enacted after October 10th, 1980 for the benefit of Indians, Indian tribes, or tribal lands would apply in Maine under this new provision 6216, which has been referenced a couple times today in the bill. That section also specifically says, so this is in the bill, that the affected Wabanaki nations may not conduct gaming activities in the state under the Indian Gaming Regulatory Act and its implementing regulations. So the Attorney General expressed a concern here. It may be a little complicated to follow, but I will do my best. So it looks as though, to the Attorney General, this provision may be intended to prevent expanded tribal gaming in the state. But if so, the Attorney General is concerned whether that may be ineffective the way it's written. because the bill repeals the provision of the Maine Implementing Act that right now generally makes state law applicable to the affected Wabanaki nations. So that would be repealed. And under the new 6216 of the bill, state laws would not apply to the affected Wabanaki nations, their members, and tribal lands, except as otherwise provided in the Implementing Act or federal Indian law. And nothing in the Maine Implementing Act has a provision that says state gaming laws apply. So unless federal Indian law said that they do, it doesn't. In California versus Cabazon Band of Mission Indians in 1987, the US Supreme Court concluded that California could not enforce its anti-gaming regulatory laws against a tribe, due in part to the tribe's retained sovereign authority. That was a complicated case, but that was one part of the court's decision. Subsequently, Congress enacted IGRA to impose restrictions on tribal gaming and to give states some authority over tribal gaming. So IGRA is actually a law, unlike a lot of laws you think of for the benefit of Indians or Indian territories. IGRA is actually a law that applies specifically to Indians and Indian members and Indian territories, but it actually is a law that gives states authority that they otherwise didn't have to impose restrictions on gaming. So the Attorney General's concern is that if state laws don't apply, so all the laws about restricting gaming under state law and IGRA doesn't apply, the Attorney General is concerned whether that means that there isn't a regulatory scheme, in which case we would go back to the predating Settlement Act, predating IGRA, predating everything, where the tribes have authority to decide whether to conduct gaming. And I'm not saying that's bad. I'm just saying that's the question raised by the Attorney General, is what was the intent of the provision? And depending on your intent, does the way it's written achieve that intent? It may, absolutely. It's just the question that was raised. So the next topics are civil jurisdiction. So the first in the task force report was referred to as civil legislative jurisdiction. In the bill, it's referred to as civil regulatory jurisdiction generally. So the bill amends the Maine Implementing Act to restore to the affected Wabanaki nations the exclusive authority, to exercise civil regulatory jurisdiction over tribal members and non-members on tribal land. I'm sorry. So currently state law applies, remember, to all federally recognized Indian tribes, tribal members, and tribal lands and natural resources, including non-member activities on tribal lands, unless otherwise specified in the Implementing Act. In addition, under current law, remember that the Passamaquoddy tribe and the Penobscot Nation have the same authority as municipalities to adopt ordinances for their Indian territories, and the state lacks authority to regulate internal tribal matters for the Passamaquoddy tribe and the Penobscot Nation. In addition, the Implementing Act does not recognize similar authority for the Houlton Band and Maliseet Indians. So the extent of civil regulatory authority now is, if you read it's hard because I don't want to say that this is law or not. I don't want to weigh in on that, but there's nothing in the Implementing Act that says that the Houlton Band and Maliseet Indians has regulatory authority currently, and the Penobscot Nation and the Passamaquoddy tribe have municipal authority, except full authority over internal tribal matters. Under the bill, there's a new provision enacted in the Maine Implementing Act to say that the affected Wabanaki nations and the state agree under the Federal Settlement Act to adopt federal Indian law, except, of course, when it conflicts with the Maine Implementing Act directly, regarding the inapplicability of state law and the exclusive civil regulatory authority of the affected Wabanaki nations over the tribes, tribal members, and tribal entities on their respective tribal lands, and concurrent civil regulatory authority of the state and the affected Wabanaki nations over non-members on tribal lands. This is, I see your question. I'm about to ask you to say it. I'm not ignoring you purposefully. But I would say this is another area which has some, it doesn't have a lot of detail in the bill, but there is, of course, detail in federal Indian law. And so I referred you to the pages of the task force report that could give you some more information on that topic. And I would just point out the Attorney General wanted to remind you as you consider this provision that civil regulatory and jurisdiction has many different topics in it. And just he gave as examples any law governing the licensure and regulation of professionals, or laws about organizing and regulating corporations. And I do want to see your question, sir. Go
Am
ahead.
I-
Representative.
Okay,
Yep, go
thank you. Janet, I think you're doing an amazing job, and I thank you so much for this. This is incredible. But I actually have a question for Senator Carney, if that would be okay.
Go ahead.
Thank you very much. As you know, the day is going late, and in my head, I was thinking, I have a lot of questions about each and every one of these things that may or may not be directed to our analyst. And I'm guessing, based on the way we've done things before, that after this is tabled the next time around, we'll be going through it and asking varying questions of all of these things. Or should I have been asking all of my questions, whether they were for the analyst or not, right now? I don't know. I guess I'm getting confused as to, I've enjoyed listening to this and just sitting through and kind of going through it. But then all of a sudden I got so caught into it, I wasn't sure if what we were planning.
Thank you for the question. The plan is to continue to go through the analysis with Janet, and we're actually pretty close to being done. And I've been carefully noting people's questions, including Janet's suggestions for where we want to ask questions of others. For example, the attorneys for the tribes or the Attorney General's office. And I've been taking pretty good notes about those questions. And I'm thinking we can complete the bill analysis if everybody's good to keep going. And then when we take up the bill again at a second work session, that's when we would go through that process of kind of pulling in section by section, pulling in other people who we want to ask the questions of.
All right. Well, I really appreciate that. I kind of thought that was the way it was. And I just thought I would get some clarification. So very much thank you. I appreciate it a lot.
Okay, yeah. And I think we have some people who had to leave early today, and by finishing the bill or continuing to work on the bill analysis, as long as everybody's okay to keep doing that, then people can watch it on YouTube, and then we'll all be kind of back at the same level of preparation when we resume.
I think that's a great game plan. Thank you.
Thank you. Representative Thorne?
Thank you. Mine's a relatively easy one. I didn't know if Janet was able to make that a little bit bigger so that my face isn't planted right into the camera. If she is able to do that, that's fine. If not, I'll maintain. Thank you.
I think that's as big as I can go. Okay. On reflection, I don't know that this is regulatory jurisdiction or civil, but it was something I didn't want to forget to include. So there is a provision about tribal school communities. So under current law, the Passamaquoddy tribe and the Penobscot Nation have authority to create their own tribal school communities, which shall operate under the laws of the state applicable to school administrative units. The bill amends that provision to also authorize the Holton Band and Maliseet Indians to create its own tribal school communities. Nothing about operating under the laws applicable to state school, to school administrative units. That language is left in the bill. And I point that out because the Attorney General's office raised a concern about whether it was clear if this tribal school communities had to follow the state's education standards and rules under the bill. I don't know if that's what this language is intended to do. And if so, it's retained. So that would still apply, but that may be an area, again, if you're looking for some more clarity. That particular concern wasn't clear to me, but I don't staff the education committee, so that may be something to investigate. Next, we have civil jurisdiction of tribal courts. So the bill amends the Maine Implementing Act to provide that the tribal courts of the affected Wabanaki nations enjoy exclusive authority to exercise civil adjudicatory jurisdiction over Indians and non-Indians on tribal lands. To the extent that the tribe, nation, or band doesn't exercise or terminates its exercise of this authority, then the state would have that authority instead. So how does this work? Under current law, under the Implementing Act, the tribal courts of the affected Wabanaki nations may, if the relevant affected Wabanaki nation so elects, exercise exclusive jurisdiction over a couple of specific types of civil proceedings, including small claims between members of specific tribes arising on the tribal court's own reservation land, or for the band's tribal court on Holton Band jurisdiction land. So if you remember, we talked about a way earlier in the bill analysis, Holton Band trust land. And that's all of the land acquired by the Secretary using Settlement Act funds for the Holton Band and Maliseet Indians. There is a smaller subset under the law currently that's considered Holton Band jurisdiction land with respect to the tribal court's jurisdiction. I say that, but there isn't currently a tribal court for the Holton Band and Maliseet Indians, but if they choose to have one, their jurisdiction would be limited more than you would think of just Holton Band trust land. There's a smaller subset under current law. And then also important to see that for the Passamaquoddy tribe and the Penobscot Nation, these small claims have to arise on the reservation. It's weird that I said specific tribes, but that's because this is one area of current law where if you read the provisions for the Passamaquoddy tribe, the Penobscot Nation, and the Holton Band and Maliseet Indians, they don't match as far as which tribal members are involved. That's one of the things the bill does uniformly with the tribal court provisions, is make all the language match between the different statutes. So in addition to small claims, for civil court jurisdiction, there's jurisdiction over Indian child custody proceedings to the extent authorized by the Indian Child Welfare Act, and also jurisdiction over domestic relation matters, including marriage, divorce, and support between members of specific tribes residing on the tribal court's own reservation land, or for the band on the Holton Band jurisdiction land. So what the bill does is amends those to equalize the court authority. Like I just said, some of the language doesn't match up between the provisions. So that's the first thing it does. It also expands the jurisdiction of the band's tribal court to Holton Band trust land, not this subset called jurisdiction land. And it also amends the language to not just be reservation land for the Passamaquoddy tribe and the Penobscot Nation, but to be all of their, I think it does it for all the Indian territory. If it doesn't, then I asked that question in the questions at the bottom. Oh yeah, it doesn't. That's actually, that seemed odd to me that the bill expanded the court's jurisdiction from Holton Band jurisdiction land to Holton Band trust land. So all of the land, but it kept the reservation land language. And I didn't know if that was intentional or not, but I did ask that question at the bottom because I thought that was an odd difference. It also enacts new provisions of these laws that say the state and the affected Wabanaki nations agree under the Federal Settlement Act that except as otherwise provided in the Maine Implementing Act, the affected Wabanaki nations tribal courts have authority to exercise jurisdiction over civil actions arising on their respective tribal lands to the extent provided by federal Indian law. The Attorney General raised a concern that this provision down here may be ill-defined in an area of frequent litigation as far as the contours of federal Indian law in this area. I did note that looking at the task force report, generally tribal courts have civil jurisdiction over conduct by tribal members on tribal land, internal tribal matters, and then certain types of conduct by non-members. That's the area where there are some areas of litigation, and exactly defining those contours is a little difficult to summarize here. So I referred you to the task force report for more information. And then obviously, if you have questions, ask the other attorneys who will know that better. And then There is a provision in the Maine Implementing Act currently that says the Passamaquoddy tribe and the Penobscot Nation have exclusive authority to enforce violations of tribal ordinances by members of either tribe or nation. That's repealed under the bill, but I don't think it means that that authority is gone. It's just the language would no longer be necessary due to the other provisions of the bill. Criminal jurisdiction. This gets a little complicated, it seems like, but I just want to back up and say when you're looking at criminal jurisdiction, the way federal Indian law works is you look at the identity of the defendant as far as are they a tribal member or are they not, and you look at the identity of the victim, are they a tribal member or are they not, and that changes tribal court's authority. And just as a backup, I never even said this originally, probably because you all understood it, but generally speaking, across the country, Congress has plenary authority over Indian tribes and tribal relations. Maine is different under the Settlement Act. It's the state with that authority. But all of these criminal jurisdiction laws have evolved over time with different statutes as far as expanding or restricting throughout history the authority of tribal courts in this criminal jurisdiction area. And that's why it looks very complicated, but it's just a lot of federal statutes have added up together. And so hopefully this chart helps explain them a little better. So as far as general due process protections in tribal court, under the current Maine Implementing Act, there's a whole list of rights that must be afforded to defendants, no matter what type of defendant you are. And those are rights that are being explicitly adopted from federal statute. So there are search and seizure rights, double jeopardy protections, rights against self-incrimination, to a speedy and public trial, to be informed of the charges against one, to confront witnesses, and also to have the ability to compulsory process for favorable witnesses, the right to obtain one's counsel at own expense, the rights against excessive bail, excessive fines, or cruel and unusual punishments, prohibitions on ex post facto laws, a right to a jury of at least 6 members if a sentence of imprisonment may be imposed, and a right to habeas corpus. All of those rights already under the Implementing Act apply in tribal courts in criminal cases, and none of those are taken away or as far as this general provision, it's not changed. We are going to talk about a little bit later on in the chart some additional rights that do apply in certain cases. You may have noticed this reference to 6 members of a jury and you're thinking, but aren't there normally 12? We're going to talk about that. And then the Attorney General's concern with regard to this, although I would say it's a concern under existing law as well, is that although tribal defendants are entitled to specific due process protections, including language that's comparable to the 4th and 5th Amendment, you know, the search and seizure rights, the rights against self-incrimination. These aren't direct quotes, these are summaries because the bill analysis was long enough without direct quotes. But the tribes aren't, it's not clear whether they're required to apply US Supreme Court cases interpreting those rights. So for example, the Miranda rule about to implement the right against self-incrimination, that Miranda rule, you're not going to see the whole thing you hear on Law and Order. It's not written in the US Constitution, as somebody has to say that when they want to interrogate you in custody. That's a common law developed interpretation of how the right against self-incrimination works. And the Attorney General just raised the question whether that case law applies. Now we're going to turn to when would the tribal court have exclusive jurisdiction over a criminal case under current law versus under the bill. So under current law, remember I told you the identity vis-a-vis whether they're a tribal member or not of the victim and of the defendant are important. So tribal court exclusive criminal jurisdiction only applies to crimes committed by a tribal member against another tribal member or for which there's no victim. So it's the only time that the tribal courts have exclusive criminal jurisdiction. Currently, that jurisdiction is limited to crimes committed on the tribes, nations, or bands, reservation, or Holton Band jurisdiction land. Remember, these are subsets of all of their tribal lands currently. and only to crimes for which the maximum sentence is less than a year and the maximum fine is less than $5,000. And if you look at the provisions of Maine law, those are your Class D and E crimes. Under the bill, this exclusive criminal jurisdiction is expanded. Again, it's still only crimes by a tribal member against another tribal member, or crimes where there isn't a victim. And under the bill, the exclusive jurisdiction would include crimes committed on the tribe's Indian territory or Holton Band Trust land. So that's all of the lands we've been talking about. And it would include Class C crimes as well, not just Class D and E crimes. If you look at the bill summary, which is the language that's not in the chart quoted above, it says that the maximum penalties under federal law apply. I do have a question at the bottom of the bill analysis about whether that's exactly how the language is drafted, but that's a nitty-gritty thing. So you can decide whether you want that to apply, and we can just make sure the language says it. So for tribal members committing or being charged with crimes against another tribal member for which there's no victim, up to Class C crimes under the bill. But if you're defendant and you're charged with a Class C crime, you have to have additional due process rights. So everybody gets the rights listed above here. And of course, the tribal court can give you even more rights than that. These are just the minimums. But if you're charged with a Class C crime under the bill, you'd also be entitled to additional due process protections that come straight from federal law. So you'd be entitled to the effective assistance of counsel. If you're an indigent defendant, you'd be allowed to have an attorney at public expense, and it has to be an attorney licensed to practice law, where there are licensing standards that ensure competence and professional responsibility. The judge must be licensed to practice law and have sufficient legal training to preside over the criminal proceeding. And the tribe's criminal laws, rules of procedure, and evidence all have to be available publicly prior to you being charged. And the proceeding must be recorded, including by audio or video. And then before I get to the concerns, I would say also under current law, if you are a juvenile defendant, and again, we're talking exclusive jurisdiction, so we're only talking about tribal member defendants. If your conduct would fall within the exclusive jurisdiction of the tribal court, if you had been an adult, then you would still fall under the exclusive criminal jurisdiction of the tribal court, even though you are a juvenile, so charged with a juvenile offense. And then there are certain juvenile drug and liquor offenses that are in the Maine Juvenile Code that are also specifically included. The only change in the bill is that we're changing which adult offenses are within the tribal court's exclusive jurisdiction. So that's going to change which juvenile crimes are within the exclusive jurisdiction, because it just follows the adult crimes, if that makes sense. So the bill doesn't change the juvenile language, but by changing the adult jurisdiction, it's changing the juvenile jurisdiction.
And so one example, Janet, would that be the inclusion of the Class C crimes?
Correct. It's going to be a juvenile crime, so it's not going to be treated like the Class C crime, although there are all kinds of, crimes that could be committed. But it would be the juvenile crime equivalent.
Thanks. Representative Barnett?
Thank you. Question for Janet. Is there no guarantee, excuse me, of counsel for an indigent defendant for Class D and E crimes under the proposed?
So under current Maine Implementing Act, that's not a requirement. That does not mean there isn't a guarantee of it. It's just not imposed by virtue of state law, which incorporates federal law. The tribes absolutely may guarantee that themselves.
But when you were talking about federal law, you were talking about 1301 through 1303, and you did say right to obtain counsel at own expense. But then later on, you talked about 1302C.
Right.
And is that just for the Class C? Is that?
It's just for crimes with a more than a year or more of punishment. So like felonies.
Okay.
We don't usually use the term felony in Maine, but it's for felonies. These are felony rights that the federal government requires to be afforded defendants charged with felonies in tribal courts.
Is there anything in the bill that states that council must be required for indigent defendants for Ds and Es?
I didn't see it. I'm sure people will correct me if I'm wrong.
Okay.
But these are just the minimums. So obviously the tribal court may itself afford that.
Okay, thank you.
Thank you, Representative Harnett. Representative Thorne, go ahead with your question.
Thank you, Madam Chair. Hopefully this will continue in my short answer streak. Janet, is there anything that you've read that says any of this is reciprocal to other tribes that are visiting? In other words, if somebody from the Mohegan tribe came to Maine and bought the same T-shirt, would they be exempt, or would they have to pay the tax like non-local tribal members?
So the tax provisions, it depends on what tribe you belong to. The criminal jurisdiction provisions, I'm looking right now.
I just didn't know if it was reciprocal for other tribes across the country. Didn't know how that worked. That was just a curiosity question.
I believe, and I know people are listening who will correct the record if I'm wrong, the tax provisions are specific. So it's,
You have to be
if you're a member of the Penobscot Nation, you need to be on Penobscot Nation land to get those tax provisions to apply to you. But the criminal laws, I don't know federal Indian law, I'm forgetting. I used to know this stuff, but I don't remember. The Maine Implementing Act is slightly differently written for the different tribes, but at least it would be, if under the bill, if you're a member of one of these three affected Wabanaki nations, then you're considered a tribal member defendant.
Yeah.
And a tribal, it's all three. So criminal jurisdiction is slightly differently. It's being a tribal member as opposed to which tribe.
Oh, so the T-shirt analogy is, if somebody from Penobscot tribe was down on Passamaquoddy, that it wouldn't, they wouldn't apply as exempt. Is that right?
Right, for the tax, but if they stole the shirt, then the court would have jurisdiction over them.
All right, we won't get wrapped up. Thank you. I appreciate it.
So that's exclusive jurisdiction. That's when only the tribal court can prosecute that case. Then we're talking about concurrent jurisdiction. Concurrent with who? Concurrent with state courts. So if you remember, when we're talking exclusive jurisdiction, we were talking, you had to be a tribal defendant and the victim, either it had to be a victimless crime or there had to be a tribal victim. As far as concurrent jurisdiction, let's look first at the category. I probably should have put these categories in the other order, but I couldn't move the chart. It wouldn't let me because of the format. But the first category we're going to look at is a non-member of any tribe being the defendant against a tribal member being the victim. So here we have a victim who's a member of the tribe, but the defendant is not. Under current law, this was the VAWA stuff you've heard a lot about in this committee. There are certain Class D domestic violence offenses. There's a footnote there that lists all of them for you, for which the maximum sentence is less than a year, less than or equal to a year, or less than or equal to $2,000. If they're committed on the tribe's tribal lands, then the tribal court would have jurisdiction over that if it's alleged to have been committed by a non-member against a tribal member. In these situations, the tribal court is required by the Maine Implementing Act to provide the following additional due process rights. Now, these are in addition. I'm going to scroll, so hope it doesn't hurt your eyes. These are in addition to the general rights. Okay, so in addition to those general rights we talked about under the Maine Implementing Act, if you're a non-member of a tribe charged with a domestic violence offense that's in the list against a tribal member committed on tribal land, and you're Subject to concurrent jurisdiction by the tribal court, you're entitled to unanimous verdict of 12 jurors, an impartial jury that does not systematically exclude any distinctive group, including non-Indians. You're entitled to all of the rights under 1302C. So these are the ones listed above. And you're also entitled to all other rights necessary under the Constitution in order for the state to exercise its concurrent jurisdiction, which basically means, remember, this is concurrent. If you were charged with that same offense in state court, any right you would have under the Constitution, if the state court was trying you, well, they don't try. If they're adjudicating the case, then you're entitled to that same right in tribal court. And nothing about the bill changes that. That's just so you understand what the jurisdiction is, concurrent criminal jurisdiction, if it's a non-member defendant and a tribal member victim. There is a change, though, as far as concurrent jurisdiction, if a crime is committed by a tribal member against a non-member. So under current law, it's very similar to what I just talked about. If it's a crime committed or alleged to be committed by a tribal member against a non-member, then it's only certain Class D domestic violence offenses over which the tribal court has concurrent jurisdiction. Again, because they're Class D, it's less than a year imprisonment and less than $2,000 or up to $2,000 a fine. It would have to be a crime committed on the tribe's tribal lands for the court to have concurrent jurisdiction over it. And all of these same rights we just talked about would have to be applied. So under current law, if it's a tribal member defendant and a non-member victim, or vice the opposite, then it's these Class D domestic violence offenses with all of these rights, and that's the concurrent jurisdiction. What the bill does is it doesn't affect it if you're a defendant who's a non-member of a tribe. It doesn't affect the tribal court's jurisdiction over you. But if you are a tribal member defendant, it does affect the tribal court's concurrent jurisdiction over you to expand it to all Class C, D, and E crimes, not just domestic violence offenses. And they're crimes committed on the tribe's tribal lands, and the tribal court has to provide you all of these same due process rights. So nothing's changed here. The unanimous verdict, impartial jury, the rights that we talked about for Class C offenses above, and all other rights whose protection is necessary under the Constitution in order for the state to exercise its concurrent jurisdiction. So I did want to point out, because this tripped me up for a long time, making sure that I was accurate in this bill analysis. And again, if I'm not accurate, somebody please tell me and I'll fix it. But I did want to point out that this concurrent jurisdiction over a tribal member defendant is similar to the tribal court's expanded exclusive jurisdiction over tribal defendants in the bill. So we're going from D or lesser crimes, and now we're including Class C crimes. The difference is jurisdiction over that tribal defendant is exclusive to the tribal court if the victim is a tribal member or there isn't a victim. But jurisdiction is concurrent with the state court if the victim is not a member of any tribe. So that's the difference. But otherwise, the jurisdiction over tribal defendants would be the same. It'd be Class C, D, and E crimes with all of these rights applied, if that makes sense. Let's see. There were some concerns raised by the Attorney General throughout all of these, including to the extent there is concurrent jurisdiction over different offenses. There are some provisions about law enforcement we were going to get to, and the Attorney General was concerned whether there's authority to investigate these crimes on tribal lands, even though the state courts would have concurrent jurisdiction over them. There were also some questions about if it's concurrent jurisdiction, you could be, and the way that the main implementing act reads, which is not changed in the bill, which is why it's not in the chart, is that a conviction in tribal court or an acquittal in tribal court doesn't prevent a conviction or an acquittal in state court. So the Attorney General raised questions about some double jeopardy protections there, but that's not a change from current law. It's just that now we're including more classes of crimes. So that's worth noting. There was a concern raised by the Attorney General over crime a wish expressed by the Attorney General. A lot of times the Attorney General didn't say, I'm weighing in on the policy, just raised concerns, but here he kind of did say that he was worried about the state not retaining jurisdictions over crimes involving fraud, theft, or misconduct involving state funds, as well as crimes involving misconduct by state employees in their official capacities. You'll notice that doesn't make sense here because it's concurrent jurisdiction, but that sentence is up here too for exclusive jurisdiction. So that's really where that concern rises. And I just accidentally copied it into both provisions, but I didn't want to not tell you about it. And then again, the authority to investigate if you have concurrent jurisdiction, but you might not have law enforcement jurisdiction over tribal lands. And then the worry about double jeopardy. Give me 1 second before I talk about state court exclusive jurisdiction. I'm going to cross out that paragraph I need to cross out.
Okay, and then when you're ready, I think Representative Hagan has a question for you, but take your time.
Yep, go right ahead.
Okay, thank you. So when we're talking concurrent jurisdiction, are there any rules in play as to who gets what? Does the state or the tribal court, how do they figure out who gets it? The trial or what?
That is absolutely a question to talk to the chiefs and the other attorneys about. I will say from staffing the task force that it's my understanding that there are a lot of cooperative agreements usually across the country and coordination of prosecutors, tribal prosecutors and state prosecutors to figure that out. But that's definitely a detail I don't have personal experience knowing.
Okay. Can I have a couple of two follow-ups?
Go ahead.
Thank you. And then can you elaborate on the double jeopardy issue that the Attorney General has here on these things?
Yeah, I'm gonna pull out the bill because it's right in here. So this is current law. It's not changed by the bill. It's just that now we have more classes of crimes within the concurrent jurisdiction. If you're a tribal defendant and the victim is a non-tribal victim, it's now up to Class C, and it's not limited to domestic violence offenses. But for what the Maine Implementing Act says and what's not changed is that a prosecution for a crime or a juvenile crime over which a tribal court has exclusive jurisdiction doesn't bar a prosecution for a crime over which the state has exclusive jurisdiction. So that could be, I'm not a criminal attorney, but there might be some crimes that could count different ways. And then also a prosecution for a crime under which the tribe has concurrent jurisdiction with the state doesn't bar the state's subsequent prosecution for that crime. And then the flip side is true too. If the state has prosecuted and it has concurrent jurisdiction, it doesn't bar the tribe from exercising its jurisdiction. So it goes back and forth, has lots of details like that. So it's essentially saying the exercise of one sovereign of its jurisdiction doesn't impede the exercise of another sovereign of its jurisdiction.
Okay. And then my last one was, I seem to recall reading somewhere that under federal Indian law, 3 years was the maximum penalty that could be issued by a tribal court. And then I read that in this bill somewhere, I thought that, well, when you add a Class C felony, that can go for more than 3 years. And I believe I read up to 9. Did you see that anywhere in this
Let me
stuff?
go down. This was one of my questions.
Okay.
So I asked what was the intent for the maximum penalty that a tribal court can impose for a Class C crime committed by a tribal member defendant under the bill. And this may be very clear in the bill. It wasn't clear to me. So I'm just posing the question so that people who know can tell you all and we can make sure the language follows. But I was a little confused. So there are certain sections, and I've cited them here, that state that the definitions of crimes and juvenile crimes and the punishments applicable to these crimes are governed by the laws of the state. I'm really glad you asked this question. I want to pause and say, if you read the summary printed on the bill, it says that the state laws no longer govern the definitions of crimes in tribal court. That is an error. That was true of 2094. It is not true of this bill. So state laws would still govern. So I just want you, if you have the bill and you see that, cross it out, because that's not true. And I don't want you to be confused by that statement. But if the definitions and punishments applicable to these crimes are governed by the laws of the state, then the maximum sentence would be 5 years and a $5,000 fine, just like you said, Representative Hagan.
Yep.
But there's a different provision of the bill that says the procedures for the establishment and operation of tribal forums created to effectuate the purposes of this section. So this section would be the section for each of the separate tribal courts. Those procedures and operations are governed by federal statutes, including without limitation, these specific provisions of the United States Code. Included within those provisions is 1302 subsection 7, which does impose the following maximum sentences on tribal courts. For a single offense, a sentence of 1 year and a $5,000 fine, except that if the defendant has been previously convicted of a comparable offense or is being prosecuted for an offense that would be a felony under federal law, then the maximum penalty for that single offense would be 3 years and a $15,000 fine. In addition, under 1302(7), in a single criminal proceeding in tribal court, the total sentence cannot be more than 9 years in that single criminal proceeding. So I was not clear which one of these two provisions wins, and so which maximum penalties provide. The summary says, the summary of the bill says it's the latter, that it's the federal laws that govern. I just was confused because of this other language.
Right, me too. Thank you very much.
But the answer is you get to pick, and then we get to make the law say that. So, okay. So we talked about tribal exclusive jurisdiction over crimes, and we talked about concurrent jurisdiction over crimes, and that's concurrent with the state. And now we're talking about state court exclusive criminal jurisdiction. So under current law, all crimes and juvenile crimes for which the tribal courts do not have exclusive or concurrent jurisdiction are exclusive to the state. And that is the same. But if you look at the bill, you might be misled into thinking it's being changed because the language is being moved, but it is the same. Or I should say, I was misled because I saw it crossed out somewhere. So I checked. It's just being moved. So as far as law enforcement authority, under current law, the Passamaquoddy tribe and the Penobscot Nation, their tribal law enforcement have exclusive authority to enforce tribal ordinances within their respective Indian territories and to enforce the criminal, juvenile, civil, and domestic relations laws over which their courts have exclusive jurisdiction on their respective reservations. And that's not a mistake. Remember, we talked about that. That's the way the exclusive jurisdiction is written right now. It's about the reservations. And then under the bill, it amends that provision of the Maine Implementing Act to include the Holton Band and Maliseet Indians and to expand the exclusive tribal law enforcement authority to the criminal, juvenile, civil, and domestic relations laws for which the relevant tribal court has exclusive jurisdiction to the Indian Territory or trust land, which begs the question I raised earlier, why is that reservation not changed in some of those criminal provisions? I think it was meant to be changed to Indian Territory and it wasn't, but that's why I asked that question earlier on. And it's in the list of questions at the bottom, at least I hope it is, I'll double check, so that you can ask the what the intent was, or you can decide what you want the intent to be. Yes, sir.
Just another question that came to my head just a second ago with looking at concurrent jurisdictions with the courts and whatnot. Would the criteria for approving judges on Indian land switch to the way it is in where they have to go through our Senate, excuse me, the judiciary, then the Senate, or would it stay the same?
It would stay the same. I didn't see anything about changing the judge approval process.
Okay. Thanks.
And I did want to clarify this question about moving from reservation to Indian Territory is a question in the civil area, but we're talking about law enforcement authority over civil laws as well. Let's see. So the Attorney General raised the question about the fact that there's expanded geographic and exclusive authority of tribal enforcement from just reservations to all Indian Territory or trust land. And there were concerns raised about whether it would be difficult for the tribal law enforcement to go to maybe distant lands that are within the Indian Territory or Holton Band Trust land. And that the only way around that is to enter some cooperative agreements. So that was just a point he raised. Under current law, there's also a provision that says that tribal, state, and county law enforcements have concurrent authority to enforce MITSIC fishing ordinances and to enforce all other laws of the state. There's no changes because I already told you that it applies to the Holton Band and Maliseet Indians. Because right now, the Holton Band and Maliseet Indians has a different provision about tribal law enforcement, and it allows the band to appoint tribal law enforcement officers to enforce state law, and also allows all state, county, and local, and it specifies Holton law enforcement officers to enforce all state laws in Holton Band Trust land. And that would be repealed, and the Holton Band of Maliseet Indians law enforcement authority would be now equivalent to that of the Passamaquoddy tribe and the Penobscot Nation as defined in the bill. Wow, criminal jurisdiction is definitely very complicated like tax. So I'm very impressed with everybody for sitting through that. So the next piece, and we are really almost at the end now, not that they're less important, they're just farther on in the page numbers. The next pieces are about consultation, tribal state cooperative agreements, assemblies, and a bicentennial accord. So the bill establishes a tribal consultation process for state agencies. So as far as consultation, each state agency has to request a government-to-government consultation process beyond the ordinary public comment and public hearing process with each of the affected Wabanaki nations that may be affected by a proposed action. And proposed action is defined as proposed agency rules, legislation, or other policy statements or actions that may directly and substantially affect one or more of the tribes, including tribal land or natural resources rights. My eyes are going buggy, I can't follow it. And the relationship between the tribes and states and tribe and state jurisdiction. So if there's a proposed agency rule or legislation or policy statement that affects any one of those things, then it's a proposed action for which this consultation process is mandated. If the tribe elects to consult, so the state has to reach out and offer the consultation process, and the tribe gets to decide if it wants to elect that, to exercise that consultation process. If it does, then the agency and the tribe must determine a mechanism for consultation that provides for meaningful and timely discussion with agency decision makers, and it provides the tribe's ability to provide detailed feedback. The agency must carefully consider the tribe's input and notify the tribe in writing of its final decision and the rationale for its decision. There are a bit more details in the bill of how that works, but that's the general overview of the consultation process. That provision of the bill also requires by October 15th of last year. So if you want to enact the bill, you need to fix that date. Each state agency must, in consultation with the affected Wabanaki nations, develop and adopt policies to promote effective consultation, collaboration, and communication with the affected Wabanaki nations. The policies have to promote robust government-to-government, state and tribe relationships and culturally competent practices in the agency. In addition, under that policy provision, it requires that the policy be given to all agency employees. There's also a requirement under this part of the bill for each state agency to designate a tribal liaison who's responsible for coordinating the agency's consultation responsibilities. There's also a requirement that each agency ensure all employees responsible for tribal consultation, receive training on their responsibilities, training on effective communication and positive tribal state government-to-government relations, as well as trainings on cultural competency. In addition, the bill would require the governor's office and MITSIC to maintain contact information for the chief of each tribe or a designee of the chief and for each tribal liaison. And finally, under this part of the bill, each agency must annually report to the governor the chief of each tribe and MITSIC regarding its consultation duties. And again, all of those dates in this part would need to be adjusted if you wanted to move forward, because they were written in a way that would apply if this was enacted last year. Sorry, I just realized the typo, so I'm circling it. Okay. Then in section 6218 of the bill, it authorizes the state and its political subdivisions to enter into cooperative agreements with all federally recognized Indian tribes in the state. This is the one part of the bill that addresses the Mi'kmaq Nation, to facilitate the delivery of government services and to avoid disputes on issues of mutual interest. Section 6219 of the bill requires the governor to annually convene an assembly with the chiefs of the affected Wabanaki nations to discuss issues involving the tribal-state relationship. In addition, MITSIC would biannually organize a legislative assembly between the chiefs of the affected Wabanaki nations, legislators, and tribal council members from the tribal governments to discuss the relationship between the state and the tribes. So there would be a chief executive sort of assembly annually, and then biannually more of a legislative type of consultation between the governments. And then section 6220 would direct the governor to collaborate with the chiefs of the affected Wabanaki nations to develop an agreement known as the Bicentennial Accord to establish principles for tribal state relations. MITSIC would be directed to provide technical assistance and support in developing and implementing the accord, and provide technical assistance in updating the accord. And that would occur, like discussions about that would occur during the MITSIC organized biennial legislative assemblies under the bill. The tribal attorneys did propose an amendment to address the fact that the deadlines have passed or are shortly about to pass, and they would add a year to all of those deadlines. They also amended a provision in the consultation process about the number of days the Wabanaki nations have to respond to agency consultation requests. If you remember, I just said it really quickly, but the agency is required to reach out for consultation, but it's up to the tribe to elect to engage in that consultation, and the proposed amendment would change the number of days they have to make that election. So the last topic, it's slightly addressed in the bill, but it's more of a topic about the proposed amendment from the tribal attorneys. So under current law, the Passamaquoddy tribe and the Penobscot Nation and their officers and employees are immune from suit when the respective tribe or nation is acting in its governmental capacity to the same extent as any municipality and its officers and employees would be immune from suit. So the bill does significantly affect that by applying that provision also to the Holton Band of Maliseet Indians and eliminating the phrase when the respective tribe or nation is acting in its governmental capacity. So all of 3 of the affected Wabanaki nations would be immune from suit when when they're to the same extent as a municipality. I want to double check that before I mislead you, because I'm tired and I don't want to misspeak just because I'm tired. C2016. Yes, it's still under the bill to the same extent as a municipality. And the tribal attorney's proposed amendment wouldn't have this immunity turn on whether a municipality would be immune. So it doesn't tie the immunity of the 3 affected Wabanaki nations to municipal immunity. Instead, their proposed amendment would amend the head note to refer to sovereign immunity and instead afford the affected Wabanaki nations, their officers and employees, the same immunity from suit that other federally recognized Indian tribes, their officers and employees have under federal Indian law. So there's already a change in the bill, but this is a different change, a different rule would apply. And then because there are amendments to the main implementing act, the bill doesn't take effect unless the tribal governments of the affected Wabanaki nations certify their agreement within 90 days of the adjournment of the first special session. You can see there's another thing that would need to be fixed of the 130th legislature. And if you remember a long time ago when I started talking on and on and on about this bill. I told you there is this dispute about not so much dispute in the context of this bill, but this question about the effective of the 1981 law that was passed in Maine about the Holton Band of Maliseet Indians. And so Section 43 of the bill, which is this contingent effective date clause in the tribal attorney's proposed amendment, would explain that any agreement they have to this bill doesn't constitute an agreement about the validity of that act. And remember, the approach would be under that proposed amendment from the tribal attorneys that you would just repeal and replace those provisions with new sections so that there wouldn't be any question about whether the old section ever took effect. Because if you're amending it and it never took effect, that could become a quagmire. So it's just start afresh. And then also there's specific language stating that the bill would constitute a jurisdictional agreement between the state and the Holton Band of Maliseet Indians. And I don't want to speak for the attorney for the Holton Band. I did speak to him. It's my understanding, but he should clarify that for you directly, that this is designed to address the fact that the Federal Settlement Act has the different language about the consent of Congress to amendments to the jurisdictional relationship between each of those tribes and the state. And there's clear consent, explicit consent to amending the Maine Implementing Act for the Passamaquoddy tribe and the Penobscot Nation about different state versus tribal jurisdiction. And the language is that the state and the Holton Band of Maliseet Indians can enter jurisdictional agreements. And so this, a proposed amendment from the Holton Band would say, that's what this bill is a jurisdictional agreement. And the rest is just, you asked for some maps. There's links to different maps here. And then there's my whole long list of questions, which are really, I'm happy to go through them now, but I think they're more like detail things.
Janet, I feel like we should give you a standing ovation.
Seriously, that was amazing. Thank you so much.
Thank you very much, Janet. I did want to give committee members a chance to ask any follow-up questions they had or to express their appreciation of all your hard work. And then I think we will probably table 1626 and take it up in more of a discussion format as soon as we can reschedule our meeting. Would anybody wish to be recognized? Go ahead, Representative Harnett.
I just, I'm blown away by that presentation, Janet. That was over 3.5 hours, I think. And that was just remarkable. And I just want to thank you. And I can speak for myself and not other committee members, but I learned more today about this issue than I've learned in all the meetings I've been attending for the last couple of years. So thank you so much. It's just great.
Representative Hagan.
Thank you, Madam Chair. I'd like to jump on the bandwagon also. That was incredible. I thought I took good notes on these bills. I'm throwing my notes away. That's fabulous. Thank you so much.
Yes, great job, Janet. Thank you.
I do just want to say if there were errors, I am happy to be corrected because this is not my expertise. So I do hope you do ask those questions of the people who really know it.
RT, just wanted to say thank you to Janet. Excellent presentation. Thank you for your work in your presentation. I understand you are tired and I can appreciate that. So thank you so much.
All right, committee members, would anybody like to make a motion to table? Motion by Senator Keim. Is there a second? Seconded by Representative Harnett. And let's do our show of physical hands and see if we're all in agreement here. And we are indeed.
I have 8.
Thank you, Supi. And so 1626 is tabled until we can reschedule it. We'll reschedule the other bills that we were supposed to take up today as well. And once again, Janet, thank you so much. And is there a motion to adjourn by Senator Keim? Everybody else has seconded it. And all right, everybody. Oh, Soupy.
If I could, and I apologize, I may not, maybe I'm tired too, and I didn't hear. Did I hear a motion and a second on the tabling? Was it, I didn't get it. Could I just ask somebody to repeat who made
I
the
wrote
motion?
down Senator Keim and seconded by Representative Harnett.
Thank you.
Yeah.
I appreciate that.
Teamwork. And then Peggy, did you have anything for us before we adjourn?
Nope, budget tomorrow with appropriations. I don't know if you've received a link yet. Doesn't look like it, but well, it's not till 10, plenty of time.
All right, everyone. Thank you, Janet, and everyone for all your hard work today, and Peggy and Soupy to you as well. See you all tomorrow.
Thank you all. Have a good one.
Night.
Good night.
Okay. Peggy?